Crypto Winter: The Rise and Fall of Billion-Dollar Crypto Empires by Liam Murphy, Esquire. Chapter 1: Terraform Labs. Terra's Rise. In April 2018, Do Kwon and Daniel Shin launched Terraform Labs in South Korea. Do Kwon provided technical expertise in blockchain systems, while Daniel Shin leveraged his background in e-commerce to secure strategic partnerships and funding. The pair aimed to create a decentralized financial ecosystem anchored by an algorithmic stablecoin designed to hold its value through a novel mint and burn mechanism. An algorithmic stablecoin is a cryptocurrency that automatically adjusts its supply according to preset rules to maintain a stable price. Do Kwon and Daniel Shin believed that an algorithmic stablecoin, an asset pegged to a traditional currency or algorithm, would encourage the everyday use of cryptocurrencies. Unlike most cryptocurrencies, where the price is volatile and constantly moving up and down, stablecoins are pegged to a stable, pre-existing currency, like the $1. Do Kwon was born in South Korea, attended Stanford University, studied computer science, and worked at Microsoft. Before Terraform, Do Kwon, under the pseudonym Rick Sanchez, had experience working on the failed stablecoin project, Basis Cash, which also sought to maintain its value through an algorithmic mechanism. Daniel Shin, co-founder of Ticketmonster, brought e-commerce expertise and early on secured funding from Hashkey Capital and Galaxy Digital. Shin built partnerships with South Korean payment networks, and his knack for connecting with investors gave Terraform Labs credibility and cash early on. But over time, Shin stepped back, leaving Kwon to steer the company during its rise and fall. Terra. The Terra blockchain functioned as a public proof-of-stake network designed to support stablecoins pegged to fiat currencies. In a proof-of-stake system, validators secured the network by staking their tokens, which are used to validate transactions and create new blocks. This approach allowed token holders to participate in network governance. During the first 6 months of 2018, Terraform Labs dedicated its efforts to developing the Terra blockchain. Terra's initial white paper, published in March of 2018, introduced the Terra protocol and the Luna token, positioning Luna as a governance asset vital for regulating an algorithmic stablecoin eventually named UST. The company framed its public proof-of-stake blockchain as a vehicle for mainstream adoption, offering faster transactions and lower costs than legacy systems. As a governance token, Luna empowered holders to vote on proposed blockchain upgrades. During Terra's rise, the mint and burn model fueled the growth of UST and Luna, as traders arbitraged slight price deviations to maintain UST's peg to $1. Terraform's ecosystem relied on market participants arbitraging price differences between UST and Luna to maintain UST's $1 peg. If UST dropped below $1, users were incentivized to buy and exchange it for $1 worth of Luna, reducing UST supply and pushing its price back up. Terraform's fundraising efforts in 2018 and 2019 fueled rapid progress. From April through September 2018, the company sold nearly 200 million Luna tokens to institutional backers. These sales brought in the capital needed to refine the protocol's architecture and expand its reach. On October 11, 2018, Terraform Labs secured $32 million in seed funding from investment heavyweights such as Hashed, Kakao Ventures, and Sequoia Capital. After the turn of the year, the company conducted additional public sales of Luna, garnering both attention and smaller infusions of capital by retail investors, the Terra community members, and supporters. Terra's growing traction was reinforced by major exchange listings and a second white paper that broadened the project's scope. In January 2019, Luna's debut on OKEx boosted its trading volume and exposed the project to international audiences. By mid-year, Binance followed suit, substantially increasing Luna's liquidity and validating Terraform's presence in the crypto space. Terra's second white paper, Terra Money, Stability and Adoption, proposed a family of algorithmic stablecoins pegged to multiple fiat currencies, with UST remaining the flagship. This expanded vision catered to diverse regional markets by promising near-instant atomic swaps between Terra-based stablecoins. Protocols. In June 2020, Terraform Labs released the Anchor white paper, which described the Anchor protocol as a savings protocol that accepts Terra deposits, allows instant withdrawals, and pays depositors a low volatility interest rate. To generate yield, Anchor lends out deposits to borrowers who put down liquid staked proof-of-stake assets from major blockchains as collateral assets. Anchor stabilizes the deposit interest rate by passing on a variable fraction of the basset yield to the depositor. It guarantees the principal of depositors by liquidating borrowers' collateral via liquidation contracts and third-party arbitrageurs. In the Anchor white paper, Terraform Labs described the Anchor protocol as a principal-protected stablecoin savings product that pays depositors a stable interest rate. In exchange for depositing their UST coins with Terraform in the Anchor protocol, depositors were promised a steady and reliable 19.5% annualized return. In December 2020, Terraform Labs launched the Mirror protocol, which allowed users to create what Terraform called an MASSET, short for Mirror Asset, which was designed to track or mirror the price of equity securities or other types of securities, including U.S. equity securities. For example, MASSETs designed to mirror the stock of Apple were named MAAPL and were designed so that their value increased and decreased with the value of Apple stock. As Terraform explained on its website, MASSETs mimic the price behavior of real-world assets and give traders anywhere in the world open access to price exposure without the burdens of owning or transacting real assets. The Mirror protocol also enabled users to obtain Mirror token, the so-called governance token for the Mirror protocol. Mirror tokens received value based upon fees generated under the Mirror protocol. Terraform officially launched Anchor Protocol in March 2021, advertising returns of 19 to 20% on UST deposits, significantly increasing investor demand for UST. The total amount of UST first minted in June 2019 was slow to grow, with under 300 million UST circulating by early 2021. But in the 2 months following the launch of Anchor Protocol, the number of UST in circulation increased by close to 1 billion. By May 2022, there were approximately 19 billion UST, with 14 billion deposited in Anchor Protocol. The Anchor Protocol uses an algorithm to determine depositor and borrower interest rates for UST deposited on the protocol based on borrowing demand and supply. The primary driver in the algorithm is a pool utilization ratio, which is just borrowed deposits divided by total deposits. As this ratio decreases, borrowers pay less interest, and in turn, depositors receive less interest. The algorithm lowers borrower interest to encourage more borrowing, paying depositors a higher interest rate. As the utilization ratio rises, borrowers must pay more interest, discouraging borrowing. In addition to the rate determined by the Anchor Protocol algorithm, borrowers of UST on the Anchor platform also earned yield from interest paid by borrowers using collateral of bonded or staked crypto assets, called proof of stake, or POS assets, to collateralize their borrowings. The POS assets carry the letter B to signify they are the POS assets, not the underlying assets themselves. The POS assets have a right to earn a staking yield from the platform where the underlying assets are staked. The staking yield contributes to the rates paid to UST depositors. The POS assets paying yield into the Anchor protocol provide an additional yield over the algorithmically determined yield. The Anchor protocol generated depositors' returns by 1. Lending the deposited coins to borrowers who put up specialized bassets as collateral, and 2. Collecting interest on the borrower's loans. Those bassets are cryptocurrency derivatives which entitle the holder to returns, and the Anchor protocol passed those returns to depositors in the form of its 19.5% annual yield. More specifically, bassets are derivative coins representing underlying coins staked on their native blockchains. Staking is a process implemented by specific blockchains that allows holders to pledge coins toward the functioning and development of the blockchain for a period of time, and receive rewards in proportion to the number of coins pledged. For example, if 100 coins are staked for 1 year on a blockchain that offers 5% annualized returns, the holder will receive 5 new coins after 1 year. The Anchor protocol also used ANC coins as its governance token. As incentives, ANC coins were distributed to borrowers, and staking ANC could also be rewarded. At its height in early March 2022, the market capitalization value of ANC reached approximately $1.5 billion. Anchor's official launch in March 2021 sparked a dramatic rise in UST circulation, which soared from under 300 million to nearly 1 billion tokens in 2 months. Terraform Labs and its representatives promoted Anchor's offering as a gold standard of stablecoin savings, frequently citing the protocol's near 20% yield. On April 23, 2021, the Anchor Twitter account boasted that UST deposits increased when broader markets declined, presenting Anchor as a safe haven in volatile conditions. By May 2021, official tweets highlighted the newly released Anchor Earn SDK, aiming to integrate 20% yields into third-party platforms and applications. Anchor's marketing strategy emphasized consistent returns and user-friendly interfaces, downplaying concerns about algorithmic vulnerabilities. Community sentiment remained largely positive, as DeFi participants capitalized on lucrative yields without fully appreciating the protocol's reliance on consistent borrower demand. By the end of 2020, Terra's total value locked, or TVL, stood at roughly $42 million, reflecting modest but growing interest in Anchor and Mirror. Over the following year, the network's DeFi ecosystem expanded at a remarkable pace, driven by high yields on Anchor and the novel trading opportunities offered by Mirror. Industry data from DeFi Llama indicated that Terra's TVL reached $18.2 billion by late 2021, surpassing even Binance Smart Chain. This growth stemmed from retail investors seeking stable returns and institutional players drawn to Terraform's holistic approach to decentralized finance. At the same time, Daniel Shin's involvement waned, allowing Do Kwon to emerge as Terraform's primary spokesperson and figurehead. His frequent social media engagements and confident advocacy of Terra's mint and burn mechanism further propelled the network's reputation. Growth. Terraform Labs witnessed a meteoric surge in 2021, driven by the remarkable 25-fold price jump of its native Luna token. Analyst reports noted that Luna's market capitalization skyrocketed from $300 million to $6 billion in under 5 months. Observers attributed the excitement partly to 2 main protocols, Mirror and Anchor, which utilize Terra's stablecoins for synthetic asset creation and high-yield savings. Stablecoins are digital currencies pegged to national currencies like the US dollar. Luna reached fresh record highs at the end of 2021 after the much-anticipated Columbus 5 upgrade, which altered the tokenomics and increased deflationary pressure. Before the upgrade, users who minted UST above its $1 peg deposited an equivalent amount of Luna into a community pool. After Columbus -5, that newly minted UST led to the burning of Luna, removing tokens from circulation. Delphi Digital, a research firm, reported that over 23 million Luna, valued above $1 billion at the time, were burned immediately, driving the token's price upward. Incentive programs launched by various Terra-based decentralized finance DeFi platforms also contributed to the rising market value. Multi-chain lending projects like Abracadabra.money enabled people to deposit UST and earn yields, broadening Terra's reach within the DeFi ecosystem. By December 2021, Terra USD (UST) reached a market capitalization above $10 billion. DeFi users relied on UST for staking, liquidity management, and yield generation, fueling demand for Terra's stablecoins. Anchor played a prominent role in Terraform's ecosystem, allowing depositors to pool UST, lend it to borrowers, and collect interest. DeFi traders leveraged these high-yield opportunities to maximize returns, citing Anchor's 20% APY as a competitive alternative to traditional banks. Such growth in UST heightened Terra's profile, making its ecosystem a preferred destination for liquidity providers. The combination of Mirror's synthetic equities and Anchor's stable returns enabled Luna to climb further in price and perceived utility. In July 2021, Terraform Labs secured $150 million from investors Arrington XRP Capital, Pantera Capital, Galaxy Digital, and Block Tower Capital to expand its DeFi ecosystem. Terraform Labs channeled this capital into its ecosystem fund, which aims to sponsor projects on the Terra blockchain that enhance UST's visibility and usage. Pantera Capital and Coinbase Ventures had already contributed to a $25 million round. Terraform Labs framed this fundraising effort as critical to establishing Terra as a leading network for decentralized finance. By injecting resources into projects that leveraged UST, the company deepened liquidity across multiple DeFi protocols, which heightened investor interest. Platforms built on Terra's proof-of-stake architecture enjoyed lower transaction costs and near-instant settlement, making them attractive to developers seeking efficient blockchain solutions. UST's perceived stability, supported by Luna's mint and burn system, fueled confidence among venture capitalists eager to seize opportunities in the booming DeFi space. Terraform Labs encouraged the notion that mass adoption hinged on simple, accessible tools tied to UST, positioning itself as an innovator within the growing stablecoin sector. These coordinated investments provided a roadmap for broader global expansion, as Terraform positioned its blockchain infrastructure to compete directly with established networks. Do Kwon rose to prominence in 2021 as the face of Terra, drawing attention for his bold claims about algorithmic stablecoins and the future of digital finance. He often championed the success of Chai, a mobile payments application in South Korea that leveraged Terra's infrastructure to process millions of merchant transactions. Kwon's social media presence became emblematic of Terra's aggressive expansion strategy, reinforcing that Korea runs on Terra. Skeptics questioned whether mainstream adoption could anchor UST's peg, yet Terraform Labs pointed to growing partnerships with brands like Nike and Philip Morris. Venture investors seized upon Kwon's narrative, funneling capital into the ecosystem at a rapid pace. By year's end, Kwon was hailed as one of crypto's most influential figures, reflecting the sweeping impact of Terra's rise on the broader market. Terraform's momentum accelerated in late 2021 as the network burned over 23 million Luna tokens worth more than $1 billion following the Columbus 5 upgrade. Analysts from Delphi Digital describe this supply reduction as a critical driver of Luna's continued price rally, reinforcing the token's deflationary appeal. Wormhole integrations with Ethereum and Solana offered UST holders more avenues to deploy their stablecoins across varied DeFi platforms. Cross-chain functionality boosted Terra's reputation as a hub for interoperability, drawing liquidity from ecosystems seeking stable assets. DeFi traders capitalized on these developments by locking increasingly large sums in Terra's protocols, pushing UST's market capitalization past $10 billion by December 2021. LFG. Terraform Labs introduced the Luna Foundation Guard, LFG, in January 2022, presenting it as a dedicated reserve system designed to stabilize UST. Kwon described LFG as an independent nonprofit that would hold assets for algorithmic stablecoins, complementing Terra's existing mint and burn process. Terraform Labs contributed 50 million Luna to LFG. LFG's core mandate focused on reinforcing UST's peg and supporting the Terra ecosystem's builders, researchers, and community projects. The newly formed organization had no direct employees and was governed by a council that included Kwon, aligning with Terraform's pledge to embed safeguards beyond the protocol's original design. Terraform officials believed that maintaining off-chain reserves would address investor unease about the sustainability of an uncollateralized stablecoin. LFG featured high-profile members who added credibility to Terraform's new reserve strategy. Kwon served alongside Jump Crypto's president, Kanav Korea, known for backing UST since its inception. Delphi Ventures' Jose Maria Macedo, Real Vision's co-founder Teto, and Levana Protocol's Jonathan Caras also shaped LFG's operational plans. Terraform drew additional support from groups like Republic, GSR, and Tribe Capital, which purchased Luna tokens set to vest over several years. Observers questioned whether these contributions were partly symbolic, since Terraform allocated most of LFG's funding. Proponents argued that pooling resources from multiple industry players would instill more confidence in UST's peg during times of volatility. Shortly after LFG's formation, Terraform Labs announced a landmark $1 billion fundraising round to build a Bitcoin-denominated reserve for UST. Jump Crypto and Three Arrows Capital led the private token sale, alongside Defiance Capital, Republic Capital, GSR Ventures, and Tribe Capital. Terraform touted it as one of the largest raises in crypto history, underscoring a wave of enthusiasm for algorithmic stablecoins backed by outside reserves. Around this time, Luna's price spiked, with investors interpreting the new capital as a crucial step in safeguarding UST's $1 peg. Terraform executives compared the reserve to foreign currency holdings maintained by central banks, an added safety net if market-based arbitrage failed to keep UST priced correctly. Do Kwon and Kanav Korea took center stage to defend UST's peg, frequently appearing in public forums to explain the role of LFG's Bitcoin reserve. In late February 2022, Terraform staged a Twitter Spaces session that promoted UST's expansion across multiple networks through Wormhole. Korea framed the Bitcoin holdings as a mechanism to restore stability if UST slipped under $0.98, implying that traders could swap discounted tokens for Bitcoin. Kwon likened this to how conventional monetary authorities manage currency boards, relying on external assets during emergencies. Skeptics remained unconvinced that a non-collateralized stablecoin could merely survive a severe market dislocation by adding a Bitcoin cushion. Terraform proposed to extend UST into ecosystems like Solana, Avalanche, and Polygon. Between March and April 2022, LFG ramped up its Bitcoin purchases, progressively inching toward Do Kwon's $10 billion reserve vision. LFG announced that it had acquired 80,394 Bitcoin by April, an amount then valued around $3 billion. Terraform Labs supported this endeavor by transferring an additional 10 million Luna, worth $820 million, to the foundation. Kwon described the process as observing the Bitcoin standard, believing that tying UST's stability to a well-known digital asset would alleviate lingering trust issues. Outside observers worried that Bitcoin's volatility could exacerbate risks in a downturn. Terraform's leadership nonetheless pressed on, declaring that this was the most ambitious stablecoin reserve strategy yet undertaken in the crypto space. By May 2022, LFG had expanded its Bitcoin reserve to roughly $1.5 billion, hoping to prevent any sustained deviation from UST's $1 peg. Terraform stated that the reserve would only be activated if UST's price dipped below $0.98, aiming to halt a potential downward spiral. Investors like Jump Crypto and Delphi Ventures continued to bolster UST through large private token purchases, fueling perceptions of unwavering institutional backing. Jump endorsed Terraform's push for a Bitcoin reserve, publicly comparing LFG's approach to a central bank's currency holdings. Delphi emphasized that a robust insurance policy was essential to handle the inevitable extremes of crypto market cycles. Terraform Labs broadcast these endorsements to reassure smaller investors that high-profile industry participants believed in the project's fundamentals. Critics regarded the alliances as strategic, intended to bolster Terra's credibility among skeptics. The steady inflow of money helped LFG amass a considerable stockpile of assets, even as debates about algorithmic stability intensified. Public discussions about Anchor's yield rate sparked internal disagreements, illustrating the delicate balance between attracting deposits and sustaining reserves. On March 10, 2022, Polychain Capital and Arca proposed scaling back Anchor's 19.5% annual return, citing long-term sustainability issues. Members of LFG, including Korea and Macedo, opposed the proposal, maintaining that high yields were central to UST's growth. Anchor's official Twitter account also sided against lowering interest rates, highlighting Terraform's reluctance to diminish the protocol's main draw for depositors. The initiative ultimately failed. Do Kwon and Kanav Korea continued a coordinated public relations campaign to defend Terra's approach, detailing how LFG's reserves would intercede in a worst-case scenario. On March 1, 2022, they appeared on The Ship Show, a Twitter Spaces event hosted by Jump and Wormhole, to reinforce their long-running partnership. Korea called LFG's billion-dollar Bitcoin holdings a sizable treasury reserve meant to soothe markets if UST's peg came under threat. At the same time, Luna's price soared past $100, marking a remarkable climb from under $1 just a year earlier. By April 2022, its market capitalization topped $40 billion, placing it among crypto's top 10. Terra's fall. Terraform Labs faced a significant crisis in May 2022, when over $2 billion in UST was withdrawn from Anchor Protocol. On May 7, 2022, UST temporarily broke its dollar peg, dropping as low as $0.91. Arbitrageurs ran to redeem discounted UST for Luna at a notional $1 exchange rate. The influx of newly created Luna greatly exceeded demand, dragging its price downward in a swift spiral. By May 8, 2022, UST fell to $0.65, prompting LFG to deploy reserves. On May 9, 2022, LFG launched an emergency maneuver dubbed the Bitcoin Gambit, injecting $1.5 billion in Bitcoin and UST to defend the peg. The plan entailed lending half of that sum in Bitcoin to trading firms and using the other half to buy more Bitcoin, hoping to shore up sentiment and create buy pressure. On May 9, 2022, Binance suspended withdrawals of Luna and UST. Panicked discussions on social media accused Terraform Labs of losing command over its creation, as the suspension highlighted a loss of faith from one of the world's largest crypto platforms. News outlets pounced on the story, likening the halt to a temporary bank-run freeze that exacerbated investor anxiety. On May 10th, Binance resumed withdrawals for Luna and UST. UST's price momentarily rallied to around $0.9, and LFG rushed to line up over $1 billion in emergency funding, seeking to prop up the depegged stablecoin. By May 11th, UST fell to 35 cents, and Terra futures saw $106 million in liquidations. Community forums and social media channels rapidly filled with desperation, as some users reported catastrophic losses. Industry analysts cited the meltdown as a devastating case study on algorithmic stablecoins. Terraform Labs attempted last-minute interventions, but the stampede for the exits proved unstoppable. On May 13th, the Terra blockchain halted for 9 hours. Critics denounced the decision, labeling it a betrayal of decentralization's core principles. Many saw the event as a turning point in the narrative, revealing how decentralized systems can still rely on centralized interventions under catastrophic conditions. Amid mounting pressure, the LFG disclosed that it had drained its reserves from roughly 80,000 Bitcoin to a mere 313 by mid-May 2022. Elliptic analysts tracked large Bitcoin transfers from LFG addresses to major exchanges like Binance and Gemini, but the subsequent transactions remained opaque. Elliptic's research indicated that 22,189 Bitcoin were sent to a new address on May 9th, soon followed by an additional 30,000 Bitcoin. Within hours, the entire 52,189 Bitcoin ended up in a single Gemini account, highlighting the speed and scale of crisis management. Another 28,205 Bitcoin then moved to Binance in a single transaction, raising questions about whether those funds were sold or merely relocated. Terra's leadership acknowledged deploying significant Bitcoin holdings in a desperate bid to buoy UST's peg. DeFi applications built on Terra experienced a mass exodus of capital in the days following the collapse. Anchor, once the ecosystem's flagship yield platform, saw its locked value tumble from $17 billion to barely $100 million. Other projects, including Lido and Mars Protocol, suffered similar fates, prompting their developers to weigh migration strategies to new chains. Observers concluded that Terra's downfall might jeopardize trust in uncollateralized stablecoins, with $28 billion reportedly draining out of Terra-based protocols by May. The ripple effects reached every corner of the crypto industry, as participants questioned whether any unbacked stablecoin could withstand a full-scale confidence crash. From May 6th to mid-May, Anchor's total value locked plunged from $17 billion to a near-useless $106 million, reflecting a 99% collapse within days. Observers noted that Anchor's headline, 19% yield, had always drawn skepticism, with critics warning the high rate was unsustainable. Despite these warnings, billions of dollars had poured into Anchor since July 2021, lured by stable returns that evaporated when UST lost its peg. As trust in UST cratered, Anchor's viability came into question, leaving depositors without faith in the stablecoin that powered the platform. The broader Terra ecosystem suffered equally catastrophic outflows, with total DeFi value locked dropping from $29 billion to $155 million by May 20th. The chaos surrounding UST's collapse prompted calls for a revival plan from Do Kwon, who announced that Terra's stablecoin in its current form was irrecoverable. He proposed a new blockchain fork to preserve certain aspects of Terra's technology while discarding the worthless Luna tokens. Critics viewed this as an attempt to salvage brand reputation without addressing root causes, pointing to the fact that nearly all value had already disappeared. Preliminary votes on Terra's Agora form indicated overwhelming opposition to the fork, with over 90% of respondents signaling their displeasure. Several community members argued that no fork could repair the breach in confidence and that leadership missteps had tarnished Terra's image irreparably. After the meltdown, attention shifted to the massive losses incurred by leading venture firms that had backed Terraform Labs. South Korea's Hashed reportedly lost $3.5 billion, while Delphi Digital saw at least 13% of its assets under management vanish. Lido, Mars Protocol, and Astroport also hemorrhaged billions in total value locked, reflecting the systemic contagion within Terra's DeFi landscape. The abrupt downfall illustrated how fragile confidence could vanish when a stablecoin's peg slipped. Terra's collapse ignited discussions across the crypto space about risk management, proper disclosures, and the wisdom of relying on algorithmic mechanisms over fully collateralized models. Scrutiny grew more intense in November 2022, when a third-party audit revealed that LFG spent $2.8 billion in a failed effort to stabilize UST. Meanwhile, Terraform Labs burned through an additional $613 million, attempting to rescue the peg as it fell apart. The audit underscored the level of capital deployment over just a few days, while emphasizing that none of these interventions prevented UST from imploding. Market participants sought details on how LFG's Bitcoin reserves were deployed, suspecting that large blocks might have been sold off to defend UST during the crisis. Tom Robinson, co-founder of Elliptic, highlighted the importance of verifying whether the Bitcoin was merely relocated or liquidated in real time. Investors who suffered substantial losses demanded accountability, urging Terra's team to provide transaction-level data. By May 20th, 2022, the toll on Terra-based DeFi projects stood at more than $28 billion in lost value, dwarfing earlier crypto collapses. Anchor's downfall symbolized the perils of over-reliance on high-yield schemes, as its user base realized how swiftly a faulty peg could undermine any promised returns. Terra's defenders argued that harsh lessons would strengthen decentralized finance, pushing the space to adopt improved safety measures. Skeptics remained unconvinced, stating that no new measure could erase the unbridled optimism that fueled Terra's rise, or the mass devastation that accompanied its fall. The community braced for regulatory, financial, and reputational repercussions far beyond Terraform Labs alone. Prosecution. South Korean authorities moved decisively on May 23, 2022, in response to Terraform Labs' collapse and the billions lost in UST and Luna. They requested that major Korean exchanges freeze LFG's remaining assets to protect investors from further losses. Local media reported that the Seoul Metropolitan Police asked trading platforms to block withdrawals linked to LFG or Terraform affiliates. Investigators suggested that some of the Bitcoin reserves, initially intended to defend UST's peg, could have been redirected. Thousands of affected individuals tracked every development, hoping that any asset freeze might preserve something of their lost wealth. Police officials disclosed that a special financial crimes task force, nicknamed the Grim Reaper, led multiple investigations into Do Kwon and his colleagues. In September 2022, South Korean prosecutors issued Do Kwon and other senior Terraform executives arrest warrants. Officials claimed their failure to reveal key vulnerabilities in UST's design amounted to a breach of capital market statutes. Interpol supported the South Korean authorities by issuing a red notice, effectively designating Kwon as a fugitive. The government also revoked Kwon's passport, intensifying speculation over his whereabouts. Cryptocurrency observers describe this as one of the highest-profile crackdowns to date, reflecting heightened global attention on DeFi and stablecoin regulation. Amid the official warrants, rumors swirled that Kwon had fled Asia to avoid criminal prosecution, further complicating attempts to serve legal documents. Prosecutors indicated that Kwon's last known movements spanned multiple jurisdictions, making extradition a matter of diplomatic negotiation. Industry participants questioned how such international enforcement would shape future oversight for decentralized finance. Global press reports framed the hunt for Kwon as a symbol of the growing friction between regulators and crypto innovators. Legal experts cited this moment as a potential inflection point, predicting that governments would continue tightening rules around algorithmic stablecoins. But Do Kwon's saga reached a turning point in March 2023 when Montenegrin border officials arrested Kwon for attempting to board a flight using fraudulent documents. This confirmed suspicions that he had avoided surrender since the Terra collapse, leading observers to wonder about his motivations for traveling under false identities. Montenegrin authorities filed criminal charges for document forgery, holding him in detention while deciding how to respond to both South Korea and the United States extradition requests. Industry watchers remarked that the once celebrated tech entrepreneur had fallen dramatically from grace. News of the arrest circulated rapidly, stoking debates over personal responsibility versus systemic flaws in algorithmic stablecoin design. Indictment. Federal prosecutors in New York unveiled a sweeping indictment against Do Kwon on March 23, 2023. Marking the first major U.S. legal action against Terraform Labs. They charged him with securities fraud, wire fraud, conspiracy to manipulate markets, and violations of commodities regulations. Government officials alleged that Kwon knowingly misrepresented the stability of Terra's algorithmic stablecoin, UST, and conspired with unnamed entities to prop up its price. Hours before the announcement, Kwon had been apprehended in Montenegro on suspicion of passport forgery, adding an international dimension to the case. Observers noted that law enforcement agencies appeared to be collaborating across borders. Kwon's abrupt detention amplified ongoing concerns about accountability in the global cryptocurrency market. On the same day the indictment was unsealed, Montenegrin authorities confirmed that they had filed a formal proposal to charge Kwon and Terraform's chief financial officer, Han Chang-jun, for document forgery. This move underscored Montenegro's intent to pursue local criminal charges independently, even as the United States and South Korea submitted extradition requests. Legal experts pointed out that Montenegro lacked direct extradition treaties with either requesting nation, potentially complicating any transfer. The U.S. indictment alleged that Kwon had lied about UST's resilience, citing evidence of deliberate price manipulation. Federal prosecutors further claimed that Kwon employed external market-making firms to stabilize UST, echoing prior allegations made by the Securities and Exchange Commission. Investors worldwide watched the case urgently, mindful of the billions lost in Terra's collapse. While Kwon prepared to fight multiple cases, prosecutors in South Korea pressed forward with their own capital markets investigation. They alleged that Terraform Labs violated disclosure rules when promoting UST and asserted that Kwon failed to outline the algorithm's built-in risks. His passport had already been revoked, signaling the intensity of Seoul's pursuit. The issuance of an Interpol Red Notice reflected a rare level of global coordination, ensuring Kwon's potential arrest anywhere he traveled. As Kwon awaited trial, reports emerged that Montenegrin courts were deliberating whether to extradite him to the United States or South Korea. Lawyers argued that the lack of a straightforward extradition agreement with Montenegro would likely prolong proceedings. Meanwhile, the U.S. Department of Justice maintained that it would press for a direct transfer of custody, backed by the newly unsealed indictment. South Korean officials reiterated that their legal system had the most substantial jurisdictional claim, pointing to Terraform's incorporation and the nationalities of most investors. Montenegrin prosecutors remained focused on the separate passport forgery charges, leaving the question of when and where Kwon might face his most serious allegations. In the meantime, Terraform Labs distanced itself from its embattled founder, claiming that the organization's future no longer depended on Kwon's leadership. News of Kwon's indictment and arrest sent fresh shockwaves through cryptocurrency markets. Terra's Luna token, already battered after the ecosystem's 2022 crash, fell another 8% in response. Traders offloaded holdings amid speculation that additional regulatory clampdowns could further undermine the project's viability. Analysts drew parallels to previous high-profile arrests in crypto, suggesting that Kwon's detention might reinforce calls for tighter oversight of stablecoins. Terraform's operational teams attempted to reassure remaining users, emphasizing that day-to-day activities would continue despite the founder's legal troubles. Market sentiment stayed grim, given the scale of the alleged fraud and the billions in unrecovered losses. By June 2023, a Montenegrin court initially approved Kwon's extradition, only for appeals to stall the process. The defense team alleged that international conventions were not correctly observed, claiming Kwon's due process rights were at risk. Authorities in Montenegro countered that both the United States and South Korea had submitted valid requests, which needed careful review. Meanwhile, the U.S. Securities and Exchange Commission proceeded with its civil lawsuit against Terraform Labs, referencing the DOJ indictment to support allegations of market manipulation. Industry participants observed how Kwon's detention and possible extradition highlighted the shifting regulatory landscape for DeFi, algorithmic stablecoins, and cross-border enforcement. The Montenegrin court maintained that Kwon would remain behind bars until each step of the legal appeals had concluded. In September 2023, renewed hearings in Montenegro provided no immediate resolution, as both Seoul and Washington reiterated their requests for extradition. Debates surfaced over the complexities of overlapping claims, with some officials hinting at a diplomatic solution involving phased legal proceedings in multiple countries. Kwon's defense team continued to contest the forgery charges while also trying to mitigate potential punishment under U.S. or Korean law. The legal entanglements grew further when a Montenegrin judge acknowledged that Kwon's forced detention hampered the discovery process in concurrent American and Korean cases. Observers noted that these cross-continental proceedings highlighted the unprecedented nature of prosecuting a globally recognized crypto founder. Luna's market price remained depressed as each legal update underscored the unresolved fallout of Terra's collapse. In November 2023, the Montenegrin judiciary approved Kwon's extradition in principle, subject to final decisions from the justice minister once the defendant's 4-month prison term for passport forgery concluded. This short sentence was upheld by a higher court, which confiscated multiple passports that Kwon had carried. South Korea and the United States renewed their pleas to gain custody of him as soon as Montenegrin authorities deemed fit. Kwon pursued a fresh wave of appeals, using arguments that foreign political pressure undermined the fairness of local courts. Defense filings claimed Montenegrin judges were ill-equipped to parse the complexities of multiple overlapping cases involving securities law, financial fraud, and alleged money laundering. South Korean and U.S. officials dismissed those claims, contending that fundamental facts showed Kwon's direct involvement in misleading UST investors. At least one court briefly reaffirmed a prior order for extradition, only to have Montenegro's high court subsequently intervene again. These oscillations underscored how the political and legal dimensions of the case became deeply intertwined. Local news outlets chronicled the back and forth as emblematic of cross-border crypto controversies. On February 8, 2024, Kwon secured another reprieve when an appellate court granted him the opportunity to challenge prior extradition orders anew. His former chief financial officer was not as fortunate, returning to South Korea under a separate agreement. Defense attorneys indicated that this partial success suggested it could be months before Kwon's final disposition was determined. Prosecutors in the U.S. and Seoul publicly criticized the repeated delays, citing victims' rights and the vast sums involved in the Terra meltdown. The SEC pressed forward with its complaint, insisting on either deposing Kwon in Montenegro or barring him from submitting declarations in any motion practice. Court filings exposed the logistical hurdles of coordinating a civil case across multiple jurisdictions. By December 27, 2024, Montenegro's Ministry of Justice again announced plans to extradite Kwon to the United States after his prison term. Officials based their decision on the weight of American fraud and market manipulation allegations, insisting that the most significant portion of evidence rested in U.S. territory. Montenegrin authorities added that the nearly two-year saga of legal challenges had strained judicial resources. Kwon's defense team labeled the judgment hasty, vowing to file additional objections based on alleged procedural failings. Public records revealed that extradition was slated for early 2025, though prior court reversals left room for doubt. Prosecutors in both the U.S. and South Korea declared their readiness to pursue criminal trials once Kwon arrived in their custody. SEC. The U.S. Securities and Exchange Commission lodged a lawsuit on February 16, 2023, against Terraform Labs and its co-founder Do Kwon, alleging widespread misrepresentations about UST and the company's broader token offerings. Observers saw this move as a watershed in the federal government's attempts to regulate decentralized finance, noting that it challenged both stablecoin viability and the classification of ecosystem tokens like Luna, WLUNA, and MIR. The SEC's complaint described Terraform's products as crypto asset securities, accusing Kwon of fraud and unregistered sales. Terraform Labs publicly insisted it had not been contacted before the legal filing, questioning the SEC's motives and timing. Analysts pointed out that the case raised central questions about investor protections in volatile digital markets. Industry insiders braced for a battle that might permanently alter stablecoin oversight in the United States. The complaint outlined how Terraform allegedly concealed a private arrangement with a U.S. trading firm in May 2021 to restore UST's peg after it slipped nearly 10 cents below $1. Regulators stated that Terraform spun this intervention as proof of UST's self-healing algorithm, boosting public confidence in Terra's design. The filing highlighted that Terraform's marketing emphasized UST's resilience without disclosing the U.S. firm's large-scale token purchases. Investigators believe this omission misled potential buyers, obscuring external reliance for repegging. Terraform publicly denied wrongdoing, claiming that outside liquidity measures were standard practice and not indicative of system failure. Judge Jed Rakoff's partial summary judgment on December 28, 2023, endorsed the SEC's view that Terraform sold unregistered securities violating federal laws. The ruling specifically named Luna and Emir tokens as investment contracts, applying the Howey test to determine that purchasers expected profits based on the company's efforts. Terraform insisted that these tokens were essential utilities supporting the Terra ecosystem, not instruments for passive speculation. Internal documents reportedly quoted executives likening Luna ownership to holding equity, bolstering the court's conclusion that Terraform marketed it as a profit-bearing asset. Attorneys for Terraform claimed these statements were oversimplified illustrations rather than formal admissions that tokens qualified as securities. The SEC's complaint focused on how Terraform promoted Anchor Protocol, which offers 20% annual yields on UST deposits. Regulators argued that the stablecoin's peg, and by extension Anchor's impressive returns, hinged on continuous market confidence rather than a robust financial underpinning. Defense counsel countered that revenue came from legitimate staking fees, denying any scheme akin to a Ponzi. Prosecutors cited last year's spectacular UST collapse, which triggered widespread bankruptcies across the crypto sector, as strong evidence that Terra's stability claims were exaggerated. Participants who lost fortunes pressed for accountability, seeing the lawsuit as a long overdue reckoning. The court's reasoning around WLuna addressed Terraform's strategy of adapting tokens for compatibility with other blockchains. Judge Rakoff found that WLuna mirrored Luna's fundamental investment characteristics, subjecting it to the same registration rules. Defense lawyers insisted that wrapped tokens lacked direct avenues to yield, thus carrying fewer indicators of securities. The judge pointed to internal discussions describing WLuna as another means for investors to gain exposure to Terra's growth. The SEC interpreted these claims as further proof of Terraform's broader efforts to attract capital under the guise of decentralized token offerings. MIR, billed as a governance token for Terraform's synthetic mirror protocol, was also scrutinized. Prosecutors presented marketing materials depicting MIR as a revenue-sharing instrument, where protocol fees would accrue to token holders. Terraform argued that Mirror's decentralized nature meant profits flowed from open markets rather than a singular promoter. The judge nonetheless found that Terraform's statements trumpeted its behind-the-scenes efforts to expand Mirror, including software updates and financial incentives funded through token sales. Documents showed that the company's pitch centered on holders benefiting from Mirror's adoption, aligning with the Howey test's requirement of profit expectations from others' work. Terraform's attorneys attempted to claim private placement exemptions under Section 5 of the Securities Act, insisting that any token distribution was confined to sophisticated investors. The court pointed to Terraform's explicit push for public exchange listings, discount programs for secondary market sales, and statements affirming a strategic goal to boost liquidity. These factors suggested that Terraform fully intended a broad distribution, negating the notion of a narrowly targeted private sale. Legal observers noted that Terraform's large-scale token deals without registration left little room for a safe harbor defense once the court determined tokens were securities. Terraform had also argued that overseas transactions lay outside U.S. jurisdiction, a point the judge rejected based on the token's accessibility to American consumers. Evidence of a U.S. trading firm's role in stabilizing UST after its May 2021 DPEG became a focal point. The SEC claimed this arrangement was secretive enough to constitute market manipulation, whereas Terraform argued it was part of routine liquidity management. Investigators introduced whistleblower testimony indicating the deal involved discounted Luna tokens in exchange for purchasing vast amounts of UST. Terraform's statements at the time described the repegging as an automatic function of the algorithm, with no mention of external help. The court concluded that factual disputes over intent would require a trial to assess potential market manipulation or fraud. The partial summary judgment did not resolve all fraud allegations. The SEC had gathered statements from ex-employees and contract partners suggesting that Quan and other executives knew the anchor yields were unsustainable without continuous inflows. Terraform maintained that private messages were taken out of context, painting a distorted view of its approach. The judge indicated that credibility issues around these witnesses warranted a full trial to determine if executives actively deceived investors or overestimated the algorithm's resilience. Court documents showed the SEC expected to call additional experts to analyze Terra's on-chain activities. The SEC pointed to the complaint's thorough discussion of how these tokens fit the definition of securities, potentially creating a significant precedent. As litigation intensified, Terraform Labs also confronted broader fallout from Terra's collapse, which contributed to a wave of crypto bankruptcies and shook investor confidence. The meltdown erased tens of billions in market value and triggered separate class action suits. Critics identified the fiasco as a glaring example of insufficient transparency in DeFi, while others pinned blame on macroeconomic conditions that struck the entire crypto industry. Many participants indicated they monitored the Terra case to glean insights into how stablecoins might be structured. Judge Rakoff's holding that Luna, WLuna, UST, and MIR qualified as securities advanced the SEC's quest for an expanded regulatory footprint. Terraform Labs refused to concede, emphasizing that the rest of the fraud claims were set for a jury to decide. Observers noted that the case reflected a showdown between regulators seeking to rein in unapproved token issuances and entrepreneurs striving to keep blockchain networks open and permissionless. Terraform's attorneys contended that a thorough trial would reveal more complexity than the partial judgment suggested. Industry participants recognized that an ultimate verdict, especially one on appeal, could set the standard for how stablecoins and ancillary tokens must comply with securities rules. In March 2024, tension rose around the SEC's ongoing legal battle against Terraform Labs when Do Kwon requested a delay from his cell in Montenegro. Kwon's legal team cited the logistical barriers he faced in seeking permission to travel to the United States for an in-person defense. Lawyers representing Terraform Labs asked Judge Jed Rakoff to consider that forcing Kwon to participate remotely would be impractical. Opposing counsel maintained that any postponement would risk an indefinite stall of proceedings, given the uncertainties of extradition. Court records showed that if the judge denied the request, the trial would begin without Kwon's presence. Judge Rakoff allowed the SEC and Terraform Labs to weigh in on Kwon's postponement motion. The government argued that the public interest demanded a timely resolution, recalling the billions lost by unsuspecting investors. Defense attorneys challenged that Kwon's absence equaled an unfair advantage, citing that a remote trial could limit cross-examination and hamper his testimony. Observers remarked on the rarity of such a scenario, wherein a founder faced criminal detention abroad while battling civil fraud charges in a U.S. courtroom. Legal experts warned that any prolonged delay might complicate discovery, overshadowing key debates about the alleged misstatements concerning UST. On April 5, 2024, the jury officially deliberated on the civil fraud case against Terraform Labs and Do Kwon. The SEC contended that the defendants knowingly misled everyday investors about UST's stability, showcasing it as fully algorithmic despite behind-the-scenes trades orchestrated by major players such as Jump Trading. Internal messages and marketing materials illustrated that Terraform executives touted UST's self-correcting mechanism, yet privately relied on off-chain purchases to maintain the dollar peg. Defense lawyers argued that no one claimed the system was entirely hands-off, pointing to disclaimers about human market activity. Court observers noted that the evidence included tweets, official press releases, and private Slack communications, all dissected by the jury. Prosecutors alleged that Terraform's leadership withheld vital information, especially regarding a May 2021 intervention that saw millions of dollars in UST acquired by institutional traders. Jurors heard that Kwon and his associates subsequently broadcasted the repegging event as proof of the algorithm's strength, omitting mention of Jump Trading's assistance. An SEC attorney described this omission as part of a broader campaign to inflate trust in Terraform's products. The defense stood firm that third-party support for pegging was standard in many stablecoin ecosystems, with open knowledge that UST's mint and burn design required external liquidity. Legal analysts watching the trial reported on the complexity of bridging algorithmic claims with the realities of large-scale trades. Defense counsel underscored that the Terra blockchain allowed for market participation by any interested entity, not merely a secretive arrangement with one firm. They emphasized documents from Galaxy Digital that cited inherent risk factors, suggesting investors were aware of possible collapses. Courtroom tensions flared when the SEC countered that Terraform's public statements heavily downplayed reliance on external deals. Throughout the trial, Kwon remained absent and confined to Montenegro due to charges of falsifying travel documents. His lawyers referenced earlier rulings that granted partial appeals against extradition requests from both South Korea and the United States. Judge Rakoff expressed concern about how Kwon's confinement constrained defense strategy, yet declined to halt proceedings indefinitely. Media outlets followed each development, highlighting the unusual cross-border nature of the case. Terraform's interim leadership testified about the company's ongoing operations, revealing minimal remaining capital and a host of pending lawsuits. The jury deliberated for days, sifting through contradictory accounts of whether UST's stability hinged on clandestine trades or a transparent, if imperfect, algorithmic design. The SEC stated that the entire Terra ecosystem was propped up by illusions of automation, systematically concealing reliance on large off-chain transactions. Defense lawyers argued that Terra's alleged misrepresentations amounted to routine marketing oversights rather than deliberate deception. On April 23, 2024, the U.S. Securities and Exchange Commission shocked the crypto industry by requesting a massive $5.3 billion penalty against Terraform Labs and Do Kwon. The agency filed an extensive motion, alleging that Terraform and its founder had pocketed billions in illicit profits through sales of various tokens, including Luna and MIR. Regulators contended that the defendants continued to promote their ecosystem despite providing minimal disclosures about stability risks. Defense lawyers objected vehemently, calling the penalty unwarranted. Court filings noted that the company's assets barely approached $150 million, raising questions about how such a hefty fine would be enforced. The proposed $5.3 billion fine immediately became one of the SEC's most enormous fines ever sought. Government attorneys painted Terraform's operation as a sprawling fraud, claiming the company deceived everyday investors by touting an algorithmic stablecoin that could not maintain its peg without heavy market intervention. They underscored that previous jury findings supported their call for steep monetary sanctions. Terraform's legal team argued that the SEC's calculations failed to account for the meltdown's broader market context and for costs already borne by the firm. Judge Jed Rakoff set a timetable for arguments on whether the penalty was proportionate to the alleged misconduct. Regulators compiled data showing that Terraform allegedly raised over $4 billion through token offerings in just under a year. The SEC cited substantial Luna, MIR, and UST sales through private deals and general trading platforms, contending that this revenue amounted to ill-gotten gains. Enforcement officials insisted that the figure in their motion was a reasonable approximation, not an overreach. They highlighted internal records indicating that Terraform executives had boasted privately about the venture's revenue streams, even as UST's peg wavered. Defense counsel derided the estimate as speculative, claiming it exaggerated the proceeds. In their filing, the SEC also called for injunctions that would bar Terraform Labs and Do Kwon from offering or selling any crypto asset securities in the future. This proposal included a request to ban Kwon from serving as an officer or director of any public company, referencing the fraudulent nature of Terraform's business model. Agency lawyers portrayed Terraform's continuing token issuance as evidence of likely recidivism, pointing to the introduction of Luna 2.0 despite prior warnings. Terraform's counsel countered that the firm was only trying to salvage what remained of its ecosystem to compensate victims. Still, regulators insisted that the possibility of further misconduct could not be ignored. By mid-June 2024, the company reached a settlement with the SEC for $4.5 billion, slightly lower than the initially proposed penalty, but still a staggering sum. Judge Rakoff approved the agreement, recognizing that it included disgorgement and civil penalties and a stipulation to cease all token sales. The settlement terms required Terraform to wind down its existing operations and freeze any further development of its digital asset securities. Observers described the final arrangement as an unprecedented legal outcome, reflecting the escalating crackdown on DeFi platforms marketing unregistered financial products. Terraform publicly stated that the deal would at least offer clarity to creditors as it entered the bankruptcy's liquidation phase. Disputed liability concerning ill-gotten gains formed the heart of the SEC's case, with regulators insisting Terraform and Kwon had enriched themselves at the expense of deceived token purchasers. SEC documents showed that billions of UST were sold during periods of artificial price support, including transactions involving a trading entity known as Jump. Prosecutors claimed these arrangements allowed Terraform to maintain the illusion of a stable algorithmic asset, encouraging more buyers to trust the ecosystem. Kwon's lawyers attempted to show that real-time data on open markets indicated widespread knowledge of potential volatility. Court records suggested the jury had found that disclaimers were inadequate to dispel the notion that Terraform had misled novice investors. The final settlement obligated Kwon to pay around $200 million, dwarfing most prior personal penalties in crypto litigation. SEC Chair Gary Gensler and Enforcement Director Gerber S. Gruhl praised the resolution, claiming it validated their stance that such tokens counted as securities when promoted under a common enterprise with profit expectations. Defense counsel dismissed the statement as celebratory rhetoric, insisting that Terraform had never hidden the algorithmic complexities behind UST. Media outlets reported that Kwon's separate criminal charges in multiple jurisdictions and the civil settlement left him facing years of potential personal liability. Observers noted that the settlement effectively shut him out of the crypto sector, limiting any path to redemption in digital finance. Public reaction to the settlement was divided, with some describing the $4.5 billion penalty as a vital deterrent to future crypto fraud, while others called it an overreach that stifled innovation. Critics recalled that dozens of smaller projects had built upon Terra's infrastructure, some of which had no role in the alleged wrongdoing but were nonetheless affected by the meltdown. Policy experts commented that the deal might signal a more rigid federal posture on stablecoins, especially those relying on lightly tested algorithms. Businesses exploring decentralized finance weighed the settlement's implications for investor disclosures and registration requirements. A new sense of caution took hold, making it harder for similarly structured projects to gather venture funding. The SEC portrayed Terraform's marketing of algorithmic stability as a key element in the alleged deception, pointing to a trove of internal messages describing private liquidity deals. Kwon and his team had argued that every stablecoin requires a blend of algorithmic logic and active trading. Still, regulators insisted that Terra's leadership had overstated the code's ability to maintain a constant peg. The Anchor protocol's 20% yield was also singled out as attracting investors under pretenses. In depositions, Terraform executives contended that their disclaimers about potential risks were readily available. Still, the court ruled that these statements did not meet the stringent standards required of securities issuers. Observers suggested this outcome might trigger a wave of reclassifications among existing stablecoin providers. Throughout the trial, Terraform's attorneys highlighted that the company had entered Chapter 11 bankruptcy months earlier, intending to preserve any assets for victims. Given Terraform's meager holdings, they claimed the SEC's request for billions in penalties was largely symbolic. However, the settlement arrangement featured provisions that the SEC's claim would be subordinated until investor claims and creditor reimbursements were handled. Regulatory officials cited that subordination as proof the deal aimed to maximize victim recovery. While not all details of the liquidation were final, the settlement effectively spelled the end for Terraform's attempt to revive its brand or innovate on new stablecoin designs. The presiding judge's comments indicated that Terraform's conduct fell squarely under existing securities laws, reiterating that self-proclaimed decentralized networks still owed a duty of full disclosure. Court documents described how Terraform had continued marketing tokens even after acknowledging severe liquidity shortfalls, potentially enlarging the pool of harmed investors. The $4.5 billion figure remained one of the highest enforcement actions in crypto history, surpassing prior penalties for token sales. Both parties submitted final statements clarifying that the settlement was not an admission of guilt on every point, but rather a resolution to facilitate restitution and protect the public. Experts predicted that future enforcement cases would cite Terraform's saga as a prime example of how not to market an algorithmic stablecoin. The SEC's June 13th press release celebrated the case as a crucial victory for investor protection, framing Terraform's downfall as a lesson in accountability. Regulators hammered home that labeling a product as an algorithmic stablecoin, or decentralized finance, would not preclude it from being subject to securities law. Cryptocurrency advocates worried that Terraform's high-profile collapse and subsequent multi-billion-dollar settlement could spark a wave of restrictive regulations. Meanwhile, attorneys described the matter as a serious wake-up call for DeFi projects, pushing them to examine compliance strategies more thoroughly. Industry watchers remained focused on whether additional stablecoin issuers might face similar allegations in the months ahead. Extradition. After months of legal wrangling, Montenegro's highest court approved Do Kwon's extradition to the United States, concluding a protracted struggle over his fate. His lawyers had repeatedly challenged earlier decisions endorsing the request, arguing that local courts faced political pressure to expedite his handover. Judge after judge vacillated on whether Montenegro's limited extradition treaties permitted such a transfer. Counsel for Kwan insisted the process breached international conventions, especially given Kwan's pending appeals. Ultimately, the Justice Minister's final ruling allowed the U.S. request to prevail, citing that most legal criteria favored an American trial. Legal filings over the winter of 2024 recounted a remarkable back and forth in the Montenegrin court system. In November, the High Court unexpectedly granted Kwan's appeal, temporarily invalidating the initial extradition order. The same court reversed itself in late December, prompting Kwan's lawyers to lodge another objection. By February, Kwan had won a second appeal that halted immediate handover, a rare achievement that underscored his legal team's persistence and the political complexity surrounding his case. Observers describe the ordeal as a tug-of-war between Montenegrin institutions, with the Supreme Court stepping in to suspend each fresh lower court decision. Officials in both the U.S. and South Korea vied for Kwan's extradition. Throughout early 2024, media reports indicated that Montenegrin prosecutors and judges faced scrutiny over contradictory judgments. At one point, the Supreme Court questioned the High Court's authority, asserting that only the Justice Minister could finalize Kwan's transfer. This ongoing dispute postponed Kwan's departure for nearly a year, preventing him from mounting a physical defense in New York or returning to South Korea. Meanwhile, Terraform's co-founder and former CFO, Han Chang-jun, was sent back to South Korea under separate proceedings, leaving Kwan as the lone high-profile figure still detained in Montenegro. Kwan's American counsel argued that he should be permitted to travel to the U.S. to stand trial in person, citing the logistical difficulties of defending himself while behind bars in a Balkan nation. The Montenegrin appeals court twice signaled agreement with elements of Kwan's argument, but ultimately refrained from overturning all prior rulings. These partial victories kept him in legal limbo, detained and unable to relocate until the final decision took shape. On December 27, 2024, Montenegrin Justice Minister Bojan Božović ended the seesaw of decisions by approving the U.S. extradition request, concluding 18 months of intense legal drama. Government statements emphasize that most factors, such as the gravity of allegations and the wide-reaching implications, bolstered the American claim. The official decree specified that Kwan would face fraud charges related to the UST and Luna token collapse upon arrival in the United States. Montenegrin courts declared that the lengthy chapter of reversals and appeals had come to a close with this ministerial sign-off. As Kwan prepared for transfer to U.S. authorities, global investors, regulators, and crypto entrepreneurs braced for a high-stakes criminal trial likely to shape the industry's regulatory future. DOJ. After Montenegro approved Do Kwan's extradition to the United States in late 2024, federal prosecutors wasted no time. Attorneys representing Kwan had fought tooth and nail against each judicial decision in the Balkan country, filing appeals to delay or overturn the transfer order. But by January 2025, all procedural roadblocks had fallen. A grand jury indictment outlining multiple counts of wire fraud, securities fraud, and conspiracy was unsealed in the Southern District of New York, solidifying the government's position that Kwan was the linchpin in the $40 billion collapse of UST and Luna. Prosecutors arrived armed with evidence, internal Slack logs, marketing materials, and deals with major trading shops that they claimed propped up UST behind the scenes. Witness statements from former Terraform employees spoke to the intense internal pressure to promote the project's stability at all costs. The government insisted that these maneuvers were tantamount to a fraudulent scheme, painting Kwan's role as the public architect of an algorithmic stablecoin far more dependent on covert interventions than self-regulating code. Defense counsel, for their part, maintained that Terraform had always disclosed the risks in general terms, pointing out that sophisticated investors understood the inherent volatility of Luna and UST. Meanwhile, Terraform's corporate remnants grappled with an exhaustive bankruptcy wind-down. Court-appointed trustees confirmed that only a fraction of promised distributions to creditors would likely be met. Entities such as TQ Ventures and Standard Crypto, the high-profile unsecured creditors, had tempered their expectations, eyeing the chance that partial restitution might be forthcoming only if prosecutors seized hidden assets. The SEC's parallel enforcement efforts remained in play, but its record-breaking settlement overshadowed the smaller sums left for individual victims. Across the entire cryptocurrency sector, Terra's downfall and Quan's predicament fueled policymaking debates, with legislators rallying around stiffer stablecoin registration requirements and investor disclosures. In January 2025, Do Kwon faced his most consequential battle yet. From behind a defense table in a New York federal courtroom, he confronted federal charges that he misled investors and was responsible for triggering a trillion-dollar crypto collapse. Chapter 2. 3 Arrows. Capital 3AC. 3AC's rise. Ju and Davies met during high school. They both attended and graduated from Columbia University and then joined Credit Suisse in Hong Kong. In 2012, this homegrown team launched 3 Arrows Capital, 3AC, on a kitchen table in their flat, which a decade later would become the world's most significant crypto hedge fund. Ju and Davies concentrated on building a distinctive advantage through algorithmic trading, leveraging advanced technology to automate processes and maximize speed. 3AC pivoted from foreign exchange trading, which they had successfully dominated for years, to crypto, where they would make and lose billions. Leverage. 3 Arrows Capital took aggressive, highly leveraged positions in the market. By using borrowed capital, the firm could exponentially increase its profits. Ju Su's unwavering faith in Bitcoin fueled one of 3AC's most consequential trades, a massive bet on Grayscale Bitcoin Trust, GBTC. In early 2020, as Bitcoin's price began to rise, 3AC started accumulating GBTC shares, believing that institutional demand for Bitcoin would keep climbing. GBTC allowed investors to gain exposure to Bitcoin through traditional financial markets. By the second quarter of 2020, 3AC's heavy investment in GBTC became public knowledge, contributing to a surge in demand as other investors followed suit. By July, Grayscale's assets under management surpassed $5 billion. By December 2020, 3AC held nearly 39 million GBTC shares, worth $1.3 billion, making the firm one of the largest institutional holders of the trust. Meanwhile, Bitcoin's price had surged to new all-time highs. Ju coined the term supercycle to describe his belief that Bitcoin would enter an extended bull market without major corrections. By early 2021, 3AC had doubled down on GBTC, boosting its holdings to over $1.3 billion as Bitcoin's price soared past $40,000. Grayscale's total assets under management skyrocketed to over $20 billion. The firm's strategy of using GBTC as collateral to fund additional trades appeared to be paying off as Bitcoin continued its ascent. Genesis. 3AC built its empire on borrowed money. The firm borrowed billions from major lenders, including Genesis, Voyager Digital, and Blockchain.com. Genesis played a pivotal role in fueling 3AC's meteoric rise by extending massive credit lines to the hedge fund. In early 2020, 3AC began actively borrowing from Genesis. As the bull market surged through 2021, 3AC's reliance on Genesis escalated dramatically, with loan amounts climbing into the billions. The relationship between the two firms grew even closer when 3AC participated in a $150 million fundraising round for Genesis's parent company, Digital Currency Group. By September 2021, Genesis reportedly demanded additional collateral from 3AC. Despite these warning signs, 3AC continued negotiating loan extensions and revised repayment terms, leveraging its reputation as one of the most influential firms in the crypto space. Voyager. Voyager actively sought out 3AC in 2022. At the time, 3AC was one of the most respected firms in the crypto industry, and Voyager executives viewed it as a prestigious counterparty. In February 2022, Voyager began its diligence process, conducting an introductory call with 3AC representatives, where 3AC expressed interest in borrowing only on an uncollateralized basis, meaning it would not provide any assets as security for the loans. Despite this, Voyager proceeded with discussions, even as it required collateral from other borrowers, such as Alameda Research. A few days later, on February 11, 2022, 3AC and Voyager signed a mutual non-disclosure agreement, NDA, and 3AC immediately sought changes to the Master Loan Agreement, MLA, including removing requirements to provide audited financial statements and Voyager's consent rights over changes in 3AC's ownership structure. These requests, which would raise red flags for any lender under normal circumstances, were accommodated without significant pushback. The only formal diligence call between the two firms took place on February 28, 2022, lasting somewhere between 30 minutes to an hour. During this call, 3AC's Kyle Davies and Tim Lowe gave Voyager vague assurances about the firm's financial health. They claimed that 3AC only managed its founders' assets, engaged primarily in delta-neutral arbitrage trading, and limited its exposure to any single altcoin to 1 to 3% of its total circulation. Notably, 3AC refused to provide detailed financial statements, citing an earlier incident with BlockFi, in which a leaked balance sheet allegedly revealed 3AC's trading strategies. Despite these omissions, Voyager's due diligence team failed to request additional documentation. On March 1, 2022, Voyager's risk committee met to discuss 3AC's creditworthiness. Despite limited financial disclosures, committee members expressed confidence in extending large loans because Genesis Trading had already lent to 3AC and was presumed to have conducted thorough diligence. Voyager executives, including Stephen Ehrlich, dismissed concerns about 3AC's refusal to provide financials, arguing that such practices were not uncommon for hedge funds. The Risk Committee approved 3AC's onboarding. After this initial approval, it never revisited the risks associated with lending to the firm. On March 4, 2022, Voyager and 3AC executed the MLA, without requiring 3AC to submit standard financial statements like income reports, cash flow statements, or balance sheets. The only obligation imposed on 3AC was to provide a NAV statement upon Voyager's request, at a minimum of once per quarter. Just days later, Voyager issued its first two loans to 3AC, $100 million USDC at a 9% interest rate and 2,740 BTC at a 2% interest rate on March 8, 2022. A week later, on March 15th, Voyager extended another $100 million USDC loan under similar terms. None of these loans were collateralized nor subjected to further scrutiny by the Risk Committee. Internally, Voyager executives explicitly viewed these loans as a replacement for their exposure to Celsius, another crypto lending platform facing liquidity concerns. By the end of March, 3AC's leverage had grown dangerously high, with reports surfacing that the firm had taken on 10-figure loans from multiple lenders. However, when Voyager received an updated NAV statement from 3AC on March 30, 2022, showing that its NAV had dropped from $3.729 billion to $3.218 billion, no follow-up questions were asked. At the March 31st Risk Committee meeting, the drop in 3AC's net asset value was not even discussed, even though 3AC had previously claimed to maintain a hedged market position to avoid significant portfolio losses. As market conditions worsened, Voyager continued extending credit to 3AC, issuing an additional $150 million USDC and 10,000 BTC, worth approximately $460 million. On April 1, 2022, and another 2,500 Bitcoin on May 5, 2022. This final loan came just days before the UST collapse, a catastrophic event that would ultimately expose 3AC's risky $600 million bet on Luna and UST. 3. ACS fall. Unbeknownst to Voyager at the time, 3AC had invested heavily in the LFG. 3AC led a $1 billion investment round in LFG on February 22, 2022, tying itself directly to UST's fate. When LFG liquidated $2.8 billion in Bitcoin to rescue UST, it exacerbated the broader crypto market downturn. Voyager executives had access to public reports of 3AC's involvement in LFG, but failed to consider them in risk assessments. By May 23, 2022, 3AC reported another $600 million drop in its NAV, but the Voyager Risk Committee did not address the decline in any of its meetings. As the broader crypto market crumbled, Voyager made a last-ditch effort to assess its counterparties. On June 12, 2022, after Celsius froze withdrawals and signaled insolvency, Voyager reached out to all borrowers, including 3AC. On June 13, 2022, Tim Lowe assured Voyager executives in a Zoom call that 3AC had no exposure to Celsius. However, Lowe frantically contacted Voyager's leadership the following day, urging them to call him immediately. During the call, Lowe revealed that Kyle Davies and Suju were missing, and the situation was in bad shape. He advised Voyager to recall all loans immediately. On June 24, 2022, after receiving no repayment from 3AC, Voyager issued a formal notice of default and acceleration. 3 days later, on June 27, 2022, 3AC entered liquidation in the British Virgin Islands. Bankruptcy. On July 1, 2022, 3AC filed for Chapter 15 bankruptcy in the United States. Chapter 15. Bankruptcy allows foreign companies to safeguard their U.S. holdings while undergoing insolvency proceedings elsewhere. Still, in 3AC's case, it appeared to be a desperate attempt to shield any remaining funds from creditors. The law firm Latham & Watkins represented 3AC in court. Still, the firm's ability to protect its clients' assets depended on whether the founders, Suju and Kyle Davies, would cooperate with the liquidators. Almost immediately, the two co-founders vanished from public view. 3AC's lawyers, and the firm's founders, Ju and Davies, remained silent, keeping their audio and video off while their attorneys spoke on their behalf. The increasingly concerned liquidators suspected that the duo was liquidating remaining crypto holdings, selling off assets, including luxury properties, to move funds out of reach. While courts worked through the complex legal process of unwinding 3AC's financial mess, the firm's collapse had already sent shockwaves through the crypto industry. Lenders, counterparties, and investors scrambled to assess their exposure as a once-trusted institution vanished into the shadows. The hedge fund that had easily borrowed billions now had no public-facing executives, functioning offices, and no clear path to recovery. On July 12, 2022, the court granted Teneo the authority to seize and liquidate 3AC's remaining U.S.-based assets, expanding the legal fight over what remained of the firm's holdings. Teneo also received a subpoena to compel Ju and Davies to testify, along with the right to subpoena crypto exchanges, banks, and any financial institutions that had dealt with 3AC. That same day, Ju Su resurfaced on Twitter for the first time since June 15th, alleging that liquidators had baited him, tricking 3AC into discussing the sale of Starkware tokens, only to use that information in court. 3AC's liquidation was one of the most complex asset recovery efforts in crypto history, entangled in luxury yachts, missing founders, and an extensive network of digital holdings. Hundreds of non-fungible tokens, NFTs, were among the most closely watched assets. Crypto data firm Nansen estimated the collection's value at 625 Ether, approximately $842,000. The process of mapping 3AC's entire portfolio remained an arduous task. In June 2022, crypto commentator at Fatman estimated that 3AC's remaining assets, mainly illiquid equities and crypto tokens, were worth just $400 million compared to $2 billion in outstanding debts. However, court filings on July 9, 2022, revealed total liabilities exceeding $3.575 billion, illustrating the gap between what was immediately observable on the blockchain and the deeper financial records accessible through legal discovery. By July 2022, Bloomberg reported that liquidators had recovered only $40 million, underscoring the scale of the shortfall and the difficulty of asset recovery in a decentralized financial system. In the following months, liquidators sought to monetize 3AC's NFT collection, which had grown significantly in value. On September 26, 2022, they initiated the sale of select assets valued at $25 million. This process culminated in April 2023, when Sotheby's auctioned off high-profile NFTs, including CryptoPunks, marking one of the most publicized crypto asset sales in history. Despite these efforts, the liquidation of 3AC's sprawling web of holdings remained incomplete, with analysts and legal teams still tracking wallets and transactions in real time, a watershed moment in crypto forensic investigations. Meanwhile, crypto lenders from New York to Singapore reeled from the fallout, with Blockchain.com alone reporting a $270 million loss due to 3AC's default. The hedge fund's collapse triggered a broader market contagion, leading to Voyager Digital's bankruptcy filing on July 5th, citing over $650 million in unpaid loans from 3AC. For 5 weeks after the bankruptcy filing, Zhu and Davies remained in hiding, offering no public statements as liquidators scrambled to locate their assets. During this time, 3AC's creditors launched a legal offensive, seeking court approval to subpoena the founders. On August 2, 2022, a U.S. judge authorized a subpoena to be served to Davies via Twitter, a rare move reflecting the founders' refusal to engage in the legal process. Meanwhile, Zhu and Davies left behind an unfinished financial empire in Singapore, symbolized by their abandoned $50 million San Lorenzo superyacht, Much Wow, still docked in La Spezia, Italy. As rumors swirled about their whereabouts, liquidators became increasingly frustrated, suspecting that the founders were covertly selling off assets, including real estate and cryptocurrencies, to stay ahead of creditors. By December 3, 2022, liquidators formally accused Zhu and Davies of refusing to cooperate, alleging they were more interested in rebuilding their reputations than assisting with asset recovery. In bankruptcy court, attorney Adam Goldberg argued that the founders had obstructed efforts to return funds to creditors, prioritizing media interviews over legal compliance. This pattern of evasion continued into May 18, 2023, when liquidators filed a $1.3 billion lawsuit against Zhu and Davies in the British Virgin Islands, accusing them of fraudulent misrepresentation and financial mismanagement. By June 15, 2023, liquidators escalated the legal fight, filing a motion to hold Davies in contempt of court for failing to comply with bankruptcy proceedings. On August 13, 2024, 3AC's liquidators sued Terraform Labs for $1.3 billion, alleging that the firm manipulated the market for LUNA and UST, artificially inflating their prices before they collapsed. This lawsuit came after 3AC blamed Terraform for its downfall, claiming in court filings that Terra's implosion had inflicted irrecoverable losses on the hedge fund. Enforcement. On September 13, 2023, the Monetary Authority of Singapore, MAC, issued a 9-year prohibition order against Three Arrows Capital, 3AC, co-founders Su Zhu and Kyle Davies, barring them from engaging in any regulated financial activity in the country. The ban, a rare and severe measure, stemmed from multiple violations of Singapore's Securities and Futures Act, SFA, and its licensing regulations. MAS found that 3AC had failed to notify the regulator about the employment of a portfolio manager, Chung Jun Young Arthur, between August 2020 and September 2021, and later provided false information to cover up the violation. Additionally, the fund lacked a formal risk management framework, exposing investors to unchecked leverage and reckless trading. Despite the ban, Zhu and Davies continued to seek new ventures in the crypto space, most notably through OPNX, a bankruptcy claims exchange launched in 2023. The firm, designed to allow users to trade claims from failed crypto companies, including those impacted by 3AC's collapse, was quickly targeted by regulators. In August 2023, Dubai's Virtual Assets Regulatory Authority, VARA, fined OPNX nearly $2.8 million, a penalty that remains unpaid. Meanwhile, liquidators continued to pursue $1.3 billion in personal liability claims against Zhu and Davies, who had allegedly incurred the debts while 3AC was already insolvent. With creditors claiming $3.5 billion in unpaid obligations, the prohibition order was not just a regulatory punishment. It was a statement that one of crypto's most infamous hedge funds had been permanently blacklisted from the financial system it once dominated. Chapter 3. Voyager. Voyager's rise. In the early days of cryptocurrency, trading platforms were fragmented, opaque, and often complex for retail investors to navigate. Stephen Ehrlich, a former executive at E-Trade, recognized an opportunity to bring traditional brokerage principles to the digital asset space. In 2017, Ehrlich partnered with Philip McDonald to found Voyager Digital in Jersey City, New Jersey, to simplify cryptocurrency trading for mainstream investors. Unlike exchanges that operated in silos with varying price discrepancies, Voyager positioned itself as a brokerage, aggregating liquidity from multiple platforms to offer customers optimal execution prices. This model, reminiscent of traditional financial markets, aimed to eliminate inefficiencies that had long plagued the crypto ecosystem. By adopting a commission-free structure, Voyager sought to establish itself as the E-Trade of crypto. By January 2018, Voyager had formalized its corporate structure and relocated its headquarters to New York City. The company's vision extended beyond simple trading. It aimed to bridge the gap between traditional finance and the emerging digital asset economy. To achieve this, Voyager built a user-friendly platform providing seamless access to various cryptocurrencies. The startup's focus on accessibility and execution efficiency attracted early interest from investors eager to back a crypto-native brokerage solution. Securing capital was crucial to turning Voyager's vision into reality. In early 2018, the company closed a $5 million seed funding round, backed by prominent industry players such as Coinbase and Galaxy Digital. This initial investment enabled Voyager to accelerate product development and refine its trading infrastructure. At the time, crypto markets were experiencing an unprecedented boom, with Bitcoin surging to all-time highs. The influx of retail investors, many of whom were encountering crypto for the first time, underscored the demand for a more intuitive trading experience. With capital in hand, Voyager entered the crypto industry at a moment of heightened interest. By July 2018, Voyager launched its flagship brokerage platform, providing users access to popular cryptocurrencies such as Bitcoin and Ethereum. The company differentiated itself by offering commission-free trades, a feature that quickly resonated with cost-conscious investors. Instead of charging direct fees, Voyager operated as an agency broker, profiting from the spread between buy and sell prices. Voyager introduced interest-earning accounts to attract retail users, allowing customers to generate yield on their holdings. This move incentivized long-term adoption and positioned Voyager as a hybrid between a brokerage and a crypto bank. With a compelling value proposition, Voyager swiftly gained traction among retail investors looking for a streamlined, cost-effective way to engage with digital assets. Under the leadership of Stephen Ehrlich, Voyager expanded aggressively in the months following its launch, capturing a growing share of the crypto brokerage market. The company's strategic focus on technology and regulatory alignment distinguished it from competitors operating in the often unregulated crypto space. As the crypto industry matured, Voyager's rise seemed unstoppable, an ambitious company with a bold vision to revolutionize digital asset trading. However, the same market forces that fueled its rapid ascent would soon test the resilience of its business model. Brokerage. By early 2019, Voyager had begun expanding its offerings and securing strategic funding to fuel its growth. In January, a partnership with Prime Trust strengthened its regulatory and security framework, while a $12 million Series A funding round bolstered investor confidence. As Voyager scaled, it emphasized security, accessibility, and innovation, qualities Ehrlich frequently touted as central to its mission. One of Voyager's major selling points was its ability to offer users interest-bearing accounts, allowing customers to earn yield on their deposited crypto assets. This feature, introduced when traditional banking institutions offered near-zero interest rates, positioned Voyager as an attractive alternative for passive income seekers. In April 2019, the launch of the VGX token further deepened user engagement, providing rewards and incentives for trading and staking. The VGX ecosystem was designed to reward customer loyalty while adding an additional revenue stream to Voyager's business model. Throughout 2019, Voyager aggressively pursued strategic partnerships and acquisitions to solidify its market position. In July, it partnered with Circle, the issuer of the USDC stablecoin, to enhance transaction capabilities. That same month, Voyager acquired Ethos.io's assets, including Ethos founder Shingo Levine, who joined as Chief Innovation Officer. By the time the Ethos acquisition closed on October 1st, Voyager had laid a strong technological foundation to support its continued growth. In November 2019, Ehrlich co-authored a white paper emphasizing Voyager's commitment to security and ease of use, asserting that users' funds were always safe and available. That same month, the company launched a rewards program, promising additional benefits to users who held VGX and kept their assets on the platform. However, a December 18, 2019 blog post would later come under scrutiny. Voyager falsely stated that customer USD deposits were FDIC, insured up to $250,000 in the event of Voyager's failure. But in reality, FDIC coverage only applied to funds held at Voyager's banking partner, not Voyager itself. This misleading assurance gave customers a false sense of security, a claim regulators and legal experts would later challenge. As Voyager entered 2020, it continued expanding its product offerings, introducing interest-earning opportunities on stablecoins like USDT, USDC, and TUSD. This move attracted retail and institutional traders, offering a banking-like alternative in the rapidly evolving crypto industry. The brokerage firm also took the unusual step of going public through a reverse merger with a defunct mining exploration company, allowing it to be listed on the Toronto Stock Exchange. This listing required Voyager to disclose its financials regularly, a decision that Ehrlich argued would build trust with investors. It was a move that, in hindsight, exposed the company to greater scrutiny as it navigated the volatile crypto landscape. Combining a commission-free trading model, interest-bearing accounts, and aggressive marketing helped Voyager carve out a unique niche in the industry. However, as its user base grew, so did concerns about the sustainability of its business model. Voyager's reliance on interest payments and token incentives required continuous capital inflows, making it vulnerable to market downturns. Despite its rapid rise, cracks were beginning to form in the foundation of the company's operations. While Ehrlich maintained confidence in Voyager's ability to scale, the same innovative features that fueled its growth would later contribute to its dramatic downfall. Growth. By mid-2020, Voyager Digital was aggressively expanding its market presence, positioning itself as a trusted and lucrative platform for cryptocurrency investors. On May 6, 2020, the company issued a press release reaffirming the security of customer assets, emphasizing the reliability of its platform amid economic uncertainty. This announcement coincided with adding 5 new interest-bearing assets to the Voyager Rewards program, increasing the total number of holdings to 14. Voyager contrasted these offerings with the near-zero interest rates of traditional banks, promising returns as high as 6%. CEO Stephen Ehrlich positioned Voyager as a safe haven for investors looking to hedge against economic instability, reinforcing the narrative that Voyager was not just another crypto exchange, but a financial institution built for long-term wealth preservation. Voyager's rapid expansion was bolstered by strategic acquisitions, including its June 2020 purchase of Circle Invest. This acquisition allowed Voyager to absorb Circle Invest's user base, significantly increasing its customer count overnight. The deal also expanded Voyager's asset offerings, integrating a broader range of cryptocurrencies into its platform. Acquiring Circle Invest gave Voyager access to thousands of new retail traders and enhanced its legitimacy as a serious player in the cryptocurrency brokerage space. At a time when institutional adoption of crypto remained limited, Voyager's ability to rapidly grow through acquisitions signaled its ambition to become a dominant force in the market. In August 2020, Voyager introduced a loyalty program designed to increase user engagement by offering tiered benefits to customers holding VGX, the company's native token. The program provided fee discounts, cashback rewards, and priority access to new features, further incentivizing long-term investment on the platform. Around the same time, Voyager granted 1.75 million stock options to its executives and directors, exercisable at 90 cents Canadian per share. Voyager also settled outstanding debts with a related party by issuing over 35,000 common shares, further embedding its reliance on equity financing. While these moves fueled Voyager's short-term expansion, they also set the stage for its dependence on stock-based incentives, which would later be scrutinized. Meanwhile, Voyager's aggressive marketing and expansion strategies began yielding significant financial results. By September 2020, the company reported an 8-fold revenue increase, with Ehrlich announcing that Voyager was on track to generate $2 million in revenue for the fiscal quarter ending September 30th, 2020. This starkly contrasted the $1.1 million it had produced in the previous fiscal year. Shares of Voyager surged 250% year-to-date, outperforming even Bitcoin and Ethereum. Ehrlich positioned Voyager's stock as an attractive alternative for investors seeking exposure to crypto markets without directly holding volatile tokens. As Voyager's stock price continued its meteoric rise, the company remained focused on portraying itself as a stable, long-term financial partner for investors. On October 27, 2020, Voyager released a statement reiterating its rewards program as a haven for customers seeking stable returns during economic turbulence. Ehrlich emphasized that Voyager's platform provided security and high-yield opportunities, contrasting it with traditional banking institutions. The bullish momentum carried into 2021, with Voyager securing $200 million in Series C funding in January. Notable investors, including Alameda Research and Three Arrows Capital, contributed to the funding round, highlighting growing institutional interest in Voyager's business model. At the same time, the company enhanced the VGX token's utility by granting holders voting rights on platform decisions. By integrating community governance features, Voyager sought to solidify its relationship with its user base while reinforcing VGX's role within its expanding financial ecosystem. Voyager's explosive growth was reflected in its trading figures. Between January and March 2021, the company onboarded nearly 230,000 funded accounts, bringing total verified users to over 1 million. Net deposits soared from $170 million in January to $650 million by March, while assets under management, AUM, surpassed $2.4 billion. Meanwhile, the VGX token surged 3,267%, reaching an all-time high of $7.40 in June 2021. Voyager's ability to drive exponential user adoption and platform revenue growth underscored its rising influence in the digital asset space. Amid this expansion, Voyager introduced new product offerings, including an interest-earning platform and a debit card program. By March 2021, VGX had been integrated into Voyager's debit card, allowing users to earn cashback rewards in VGX for their transactions. Additionally, Voyager launched an interest-earning platform with high-yield annual percentage rates, APYs, on various cryptocurrencies. These innovations sought to embed VGX further within Voyager's ecosystem, ensuring that users had multiple incentives to hold and use the token. Despite these successes, questions about Voyager's financial practices began surfacing. On March 31, 2021, the company reported fee revenues of $53.7 million for the quarter, an enormous increase from previous periods. However, closer scrutiny revealed that Voyager's commission-free trading model was misleading. Instead of charging direct commissions, Voyager generated revenue by marking up asset prices through a hidden spread. This practice allowed Voyager to quietly take a percentage of every trade executed on its platform. This model became increasingly controversial as retail investors realized they were paying more than advertised. As Voyager's valuation soared, Ehrlich and other executives engaged in sizable stock sales. In response to growing concerns about insider trading, the company announced the adoption of Automatic Securities Disposition Plans, ADSPs, for Ehrlich and COO Gerard Hanchi on December 31, 2021. However, just weeks later, Ehrlich abruptly canceled his ADSP before any trades were executed under it. The timing raised further red flags, particularly as Voyager's stock was already in decline. Meanwhile, regulatory scrutiny intensified. By mid-2022, the Federal Deposit Insurance Corporation, FDIC, ordered Voyager to stop falsely advertising its products as FDIC-insured, calling the claims misleading. Voyager's collapse was not yet imminent, but the warning signs were undeniable. Its business model, built on the promise of security and stability, had begun to unravel as scrutiny increased. Investors who had once viewed Voyager as a rising star in the crypto brokerage space were now questioning whether its rapid expansion had been built on shaky foundations. The cracks in Voyager's empire were widening, and soon they would become impossible to ignore. Promotion. By mid-2021, Voyager Digital was aggressively embedding itself in mainstream culture. On June 17, 2021, the company announced a high-profile sponsorship deal with NASCAR driver Landon Cassill, who would become the first professional driver to be paid entirely in cryptocurrency. Cassill's sponsorship covered 19 races, with his earnings consisting of a portfolio led by Litecoin, LTC, and Voyager's own VGX token. The Voyager-branded car debuted at the Nashville Superspeedway, marking a new frontier for the crypto industry's foray into professional sports. This partnership symbolized Voyager's ambition to associate itself with high-performance, risk-taking athletes, an ethos that resonated with the speculative nature of crypto trading itself. Voyager's expansion into sports endorsements didn't stop with NASCAR. By September 8, 2021, the company had secured another central celebrity figure, NFL superstar Rob Gronkowski. Gronk, a four-time Super Bowl champion, became an official ambassador for Voyager, joining a wave of athletes and public figures embracing cryptocurrency sponsorships. His role was designed to appeal to the mainstream market, launching promotional campaigns that simplified crypto investing for the average consumer. His first campaign, titled New Best Friend, featured Gronk playing with a Shiba Inu puppy, a nod to the popular meme coins Dogecoin, Doge, and Shiba Inu, SHIB. Voyager structured the campaign as lighthearted and accessible, using Gronk's well-known comedic persona to make crypto investing seem fun and easy. The initiative also included NFT drops and livestream events, further solidifying Voyager's strategy of intertwining digital assets with celebrity culture. The push to attract retail investors continued with an even higher profile figure in the financial and sports world, billionaire Mark Cuban. On October 28, 2021, Voyager announced a 5-year exclusive integrated partnership with the Dallas Mavericks, Cuban's NBA team. At a press conference, Cuban extolled the virtues of Voyager as a simple, effective way for beginners to enter the cryptocurrency market. To entice new users, Voyager and the Mavericks launched a promotional giveaway. Anyone who downloaded the Voyager app, deposited $100, and made a trade within the promotional window would receive $100 in Bitcoin. The promotion framed Voyager as a risk-free entry point into digital assets, mainly targeting the Mavericks fan base. Cuban enthusiastically endorsed Voyager, going beyond a typical sponsorship agreement. He positioned himself as an educator, stating that Voyager would help bridge the gap between cryptocurrency's complex financial mechanisms and the average retail investor. This messaging helped Voyager cultivate trust, particularly among retail investors unfamiliar with the risks inherent in speculative assets. Steve Ehrlich, Voyager's CEO, reinforced Cuban's messaging, promising that users could open an account and start trading in 3 minutes or less. The combination of celebrity endorsements, sports sponsorships, and aggressive promotions suggested that Voyager was thriving. Its marketing machine portrayed it as an unstoppable force in the digital asset space, capable of onboarding millions of new users in record time. However, behind the polished endorsements and rapid growth, Voyager's business model remained highly dependent on customer deposits and token speculation. With each new account deposit, Voyager gained more liquidity to sustain its high-yield rewards program and token-based ecosystem. The reliance on aggressive growth and constant influx of new users was eerily similar to the unsustainable models in past financial bubbles. As Voyager's public visibility increased, so did regulatory scrutiny. Mark Cuban, once the company's most prominent advocate, later faced legal trouble over his role in promoting Voyager. Investors who suffered losses accused him of misleading endorsements, arguing that Voyager's business model was misrepresented as safer than it was. The celebrity-backed marketing campaigns, once a pillar of Voyager's credibility, became a point of contention in lawsuits alleging deceptive advertising. The same sports and entertainment figures who helped bring Voyager into the mainstream were now entangled in legal battles over the platform's ultimate collapse. Voyager's celebrity-driven era encapsulated the speculative frenzy of the broader crypto boom. By attaching itself to popular culture, Voyager successfully manufactured an image of legitimacy. Voyager's fall. Voyager Digital positioned itself as a safe and profitable platform for cryptocurrency investors, but at its core, it operated much like a bank, without the regulatory guardrails. Unlike traditional banks, which loaned deposits to creditworthy borrowers backed by collateral, Voyager funneled customer funds into high-risk loans to crypto hedge funds and institutional traders. Among its biggest borrowers was Three Arrows Capital 3AC, a hedge fund known for aggressive, leveraged bets on the crypto market. When asset prices rose, this strategy produced massive returns, fueling Voyager's growth. But when the market turned, the risk Voyager had absorbed became a liability of catastrophic proportions. By early 2022, the crypto market was showing signs of strain, with rising interest rates and macroeconomic instability causing volatility in digital asset prices. Despite these warning signs, Voyager deepened its financial relationship with 3AC. On February 11, 2022, Voyager formalized its relationship with 3AC by signing a non-disclosure agreement (NDA), which locked both parties into confidential negotiations. The NDA preceded the signing of a master loan agreement, ultimately granting 3AC access to massive amounts of Voyager's customer deposits. However, Voyager's lack of caution became apparent on February 16, 2022, when 3AC refused to provide audited financial statements. Instead of halting negotiations, Voyager accepted a one-sentence statement instead of proper financial disclosures. In any regulated financial institution, such a refusal would be a red flag, but Voyager's leadership either failed to recognize or willfully ignored the risks involved. Despite 3AC's unwillingness to provide essential transparency, Voyager continued forward. While some investors began retreating from risky digital assets, Voyager doubled down, formalizing its lending arrangement with 3AC. By March 1, 2022, Voyager's Loan Risk Committee, including CEO Stephen Ehrlich, had received an internal memo assessing 3AC as a low-risk borrower. This determination was based on little more than prior performance, ignoring the lack of financial disclosures and the broader market downturn. On March 4, 2022, Voyager finalized its master loan agreement with 3AC, cementing a relationship that would ultimately lead to its downfall. Voyager executives proceeded with the belief that 3AC had provided sufficient due diligence documentation, despite the absence of audited financial statements. Just days later, on March 7, Ehrlich approved transferring $100 million in Bitcoin and USDC stablecoins to 3AC. On March 8, Voyager approved additional term sheets for further loans, again without requiring any collateral. Unlike traditional financial institutions, which require borrowers to pledge assets as security, Voyager provided unsecured credit to a hedge fund engaging in increasingly volatile trades. The recklessness continued through March. On March 15, 2022, Voyager again lent another $100 million USDC to 3AC without requiring collateral. Internally, discussions began surfacing about 3AC's increasing borrowing from other lenders, raising concerns about its liquidity. Yet, rather than reassessing the risk, Voyager's leadership dismissed the concerns and moved forward. On April 1st, Voyager approved 2 more loans to 3AC, an additional 10,000 BTC and 150 million USDC, further entangling its fate with the hedge fund's success. At this point, more than half of Voyager's loan book was tied up in a single counterparty. In early May 2022, the crypto market experienced its most significant shock yet: the collapse of Terra's Luna ecosystem. Terra's algorithmic stablecoin, UST, lost its peg to the US dollar, setting off a chain reaction of liquidations across the industry. 3AC, heavily invested in LUNA and UST, saw its portfolio disintegrate overnight. Aware of 3AC's exposure, Voyager executives stared down an impending liquidity crisis. Despite this, Voyager continued to reassure customers that their assets were safe, even as internal discussions revealed deep concerns about 3AC's solvency. By June 2022, it became clear that 3AC could not repay its debts. On June 13th, Voyager publicly disclosed its $666 million loan to 3AC, representing the bulk of its loan portfolio. The following weeks saw a desperate scramble to recover funds. Voyager initially demanded partial repayment by June 24th and full repayment by June 27th, but 3AC failed to meet either deadline. As news of 3AC's impending default spread, Voyager's stock price plummeted more than 60%, triggering panic among customers and investors alike. On June 27, 2022, Voyager officially issued a notice of default to 3AC. With no means to recover its loans, Voyager attempted to secure emergency funding, drawing down $75 million from a $200 million credit line provided by Alameda Ventures. However, this credit line did not cover Voyager's mounting financial obligations. The collapse of 3AC set off a domino effect. With its primary borrower defaulting, Voyager was left with a gaping hole in its balance sheet. Now scrutinizing Voyager's operations, regulators began investigating whether the company had misled users about the safety of their funds. One particularly damning revelation emerged. Voyager had falsely advertised customer deposits as FDIC insured, despite not being a bank. On July 1, 2022, Voyager suspended all trading, deposits, and withdrawals, effectively locking customer funds on the platform. The move triggered outrage across the crypto community, with thousands of users unable to access their assets. The company's safety assurances had evaporated overnight, leaving investors scrambling for answers. On July 5th, Voyager filed for bankruptcy, becoming one of the first major casualties of the 2022 crypto collapse. Alameda. Voyager Digital's growing dependence on Sam Bankman-Fried's SBF Carr hedge fund, Alameda Research, marked a turning point in its financial trajectory. In October 2021, Alameda invested $75 million into Voyager, acquiring 7.7 million shares and a 4% ownership stake. At the time, the deal was framed as a strategic partnership, with both firms pledging to collaborate on non-fungible tokens, NFTs, crypto derivatives, and regulatory advocacy. The announcement sent Voyager's stock soaring 39% in Toronto, reinforcing market confidence. But beneath the surface, the investment signaled something deeper: Alameda's expanding influence over Voyager and its growing control over the fragile crypto lending ecosystem. As market conditions worsened in early 2022, Voyager's reliance on Alameda intensified. In May, Voyager raised $60 million through a private placement offering, once again led by Alameda. Other institutional players, including Galaxy Digital and Digital Currency Group, also participated, but Alameda remained Voyager's most influential backer. The investment provided short-term liquidity but failed to address Voyager's mounting structural weaknesses. Behind the scenes, the company struggled to sustain its high-yield payout model, which depended on constant capital inflows. Without fresh funding, Voyager's ability to meet customer withdrawal requests and maintain operations was in jeopardy. The growing interdependence between Alameda and Voyager created an illusion of stability, masking the underlying financial fragility. By June 2022, Voyager's situation had become dire, following the collapse of Three Arrows Capital, which defaulted on its $670 million loan. With a massive hole in its balance sheet, Voyager returned to Alameda, securing a $200 million credit facility consisting of cash, USDC, and Bitcoin. The company presented the loan as a safeguard for customer assets, reassuring investors that Voyager remained solvent. The loan was a last-ditch effort to buy time. Alameda, already Voyager's most significant external creditor, was now acting as its lender of last resort. This deepened Voyager's dependence on SBF's empire, raising concerns about the firm's autonomy and financial viability. On June 28, 2022, Voyager confirmed that it had fully exercised Alameda's $500 million loan facility. The move sparked immediate controversy, with analysts debating whether Alameda was propping up Voyager or positioning itself for a takeover. Some speculated that Alameda, having already acquired a substantial equity stake, was maneuvering to absorb Voyager's assets. Others saw the credit line as a desperate attempt to delay an inevitable bankruptcy. The loan came with a 15% annual interest rate, adding further pressure to Voyager's deteriorating balance sheet. The growing financial entanglement between Alameda and Voyager ultimately failed to prevent disaster. Within days of drawing the entire loan amount, Voyager suspended trading, deposits, and withdrawals, effectively trapping customer funds. The company filed for bankruptcy on July 5, 2022, marking one of the most dramatic collapses of the crypto crash. Once perceived as Voyager's savior, Alameda quickly distanced itself from the fallout, facing its own financial unraveling just months later. What had begun as a strategic partnership ended in mutual destruction, with both firms caught in the same web of reckless lending, opaque financial dealings, and misplaced market optimism. Bankruptcy. On July 1, 2022, Voyager Digital abruptly halted all withdrawals, deposits, and trading activity, sending shockwaves through the cryptocurrency industry. The company had assured customers that their assets were safe just weeks earlier. Now, more than $1 billion worth of cryptocurrency and cash deposits were trapped on the platform, leaving millions of users in financial limbo. Even Voyager-issued debit cards were rendered useless, cutting off access to funds many customers relied on. The news triggered an immediate market reaction, with Voyager's stock plummeting over 26% in U.S. trading to just 33 cents per share. In Canada, where Voyager's stock was listed on the Toronto Stock Exchange, TSX, trading had already been halted due to the Canada Day holiday. While Voyager scrambled to recover funds through legal action against Three Arrows Capital 3AC, the damage had already been done. The decision to suspend customer withdrawals was the first step in Voyager's rapid descent into bankruptcy. On July 5th, the company formally declared Chapter 11 bankruptcy in the U.S. Southern District Court of New York, revealing that it had more than 100,000 creditors and liabilities ranging between $1 billion and $10 billion. As the fallout from Voyager's bankruptcy deepened, regulatory scrutiny intensified. On July 7, 2022, the Federal Deposit Insurance Corporation, FDIC, launched an investigation into Voyager's misleading claims about deposit insurance. For months, Voyager had promoted itself as a safe platform, repeatedly stating that customer deposits were protected by FDIC insurance. However, only the funds held at Metropolitan Commercial Bank, MCB, Voyager's banking partner, were insured, meaning customers were protected in the event of MCB's failure, not Voyager's. MCB publicly refuted Voyager's claims, making it clear that FDIC insurance did not cover Voyager's bankruptcy, withdrawal suspensions, or asset losses. The revelation sparked outrage among users who had been led to believe their funds were secure, further damaging Voyager's credibility. Voyager's bankruptcy proceedings triggered a wave of legal and financial repercussions. The Toronto Stock Exchange swiftly moved to delist the company, halting trading as of 8 a.m. ET on July 7th and initiating an expedited review process. In the U.S., shares of Voyager, which had been trading over the counter under the ticker symbol VYGVF, were also suspended. As the legal battle intensified, the U.S. bankruptcy court froze Voyager's remaining assets, preventing further transactions on the platform. This action led to a surge in legal complaints, including class action lawsuits accusing Voyager of mismanagement and deceptive advertising. Simultaneously, the company issued clawback letters to some customers, attempting to recover funds from users who had recently withdrawn assets before the freeze, further inflaming tensions. Auction. As Voyager Digital entered bankruptcy proceedings in mid-2022, a fierce bidding war erupted over its assets. Both Binance and FTX sought to acquire Voyager's holdings, with bids due by September 6, 2022, and an auction scheduled for September 29 if necessary. The competition to purchase Voyager's assets reflected the broader industry's hunger for expansion, even amid worsening market conditions. Voyager's native token, VGX, surged over 40% following reports of the pending auction, signaling investor optimism. However, behind the scenes, major firms like Coinbase had already scrutinized Voyager's financials and backed out, concluding that the company's balance sheet was beyond repair. On August 4, 2022, the U.S. Bankruptcy Court for the Southern District of New York ruled that cash held in for benefit of FBO accounts at Metropolitan Commercial Bank belonged to Voyager's customers and was not part of the bankruptcy estate. However, the court declined to rule on whether cryptocurrency held by Voyager was customer property or part of the bankruptcy estate. The ruling underscored a key legal ambiguity in crypto bankruptcies. Traditional banking protections did not apply to digital assets. While Voyager's customers could access their cash deposits, their crypto holdings remained trapped, subject to the court's determination of whether they legally belonged to Voyager or its users. By September, FTX appeared to be the frontrunner in the bidding war, initially offering $50 million for Voyager's assets. However, Binance also made a competitive bid, increasing the stakes. The auction process unfolded in secrecy, with bidders vying to control Voyager's loan book, exchange infrastructure, and customer base. On September 29, 2022, FTX officially won the bid, agreeing to acquire Voyager's assets for approximately $1.4 billion. The deal, if completed, would allow Voyager customers to recover up to 72% of their locked funds. Court filings showed that the sale still required final approval, with Judge Michael Wiles overseeing the process. In the meantime, Voyager secured a $270 million debtor-in-possession financing agreement with FTX US, giving the firm temporary access to capital for its legal and operational expenses. The acquisition deal quickly encountered roadblocks. The Department of Justice, DOJ, and the Securities and Exchange Commission, SEC, raised concerns about regulatory compliance, with the SEC questioning whether FTX's proposed plan to return customer funds violated securities laws. Despite these concerns, Judge Wiles allowed the sale to proceed, rejecting the idea of an indefinite delay in the bankruptcy process. However, as legal challenges mounted, another crisis was brewing at FTX. By November 2022, reports surfaced that FTX and its trading firm, Alameda Research, face severe liquidity issues. SBF, once hailed as a crypto savior, was now scrutinized for potential fraud and mismanagement. On November 11, 2022, FTX filed for bankruptcy, immediately voiding its agreement with Voyager. The collapse of FTX upended the Voyager acquisition deal, leaving the bankrupt crypto lender in an even more precarious situation. With FTX out of the picture, Binance US reemerged as a leading bidder. In December 2022, Binance US submitted a revised bid to acquire Voyager's assets for over $1 billion. The deal was framed as a better alternative for creditors, offering an estimated 73% recovery of customer funds. However, regulatory scrutiny intensified. In January 2023, the SEC formally objected to the sale, citing concerns over Binance US's ability to secure customer assets and questioning whether the company had the financial capability to close a deal of this magnitude. The Texas State Securities Board and the Texas Department of Banking also objected, arguing that Binance and Voyager did not comply with state regulations. The legal battle escalated, forcing Voyager's creditors and customers into prolonged uncertainty. The legal struggles came to a head in early March 2023, when the DOJ's U.S. Trustee's Office appealed the approval of Binance US's acquisition. Regulators argued that the deal would shield Voyager executives from legal liability while failing to address core concerns about Binance's regulatory status in the U.S. Despite these objections, Judge Wiles overruled calls to pause the acquisition, emphasizing that delays would only harm Voyager's creditors. The Voyager token, VGX, briefly surged following the ruling, but confidence in the deal remained fragile. In a dramatic turn, Binance US abruptly canceled its acquisition of Voyager on April 26, 2023, citing the hostile and uncertain regulatory climate in the United States. The sudden reversal left Voyager with no buyer, forcing the company to pivot towards self-liquidation. Instead of a structured sale, Voyager announced it would return remaining assets directly to customers through a toggle option on its platform. Under the Binance deal, customers had expected to recover up to 73% of their funds. Still, following the cancellation, that figure was projected to drop to as low as 48% if claims from FTX and Alameda Research were upheld. Binance US's withdrawal ended the sale process and intensified legal disputes between Voyager and its former bidders. What began as a high-stakes bidding war between FTX and Binance had devolved into a legal quagmire, leaving Voyager's customers in limbo. The instability of its potential buyers shattered the company's initial promises of recovery, reinforcing the fragile nature of centralized crypto platforms. For Voyager, the road to resolution was far from over. For its creditors, the hope of regaining their lost assets now depended on the slow and uncertain liquidation process, litigation. By early 2023, as Voyager Digital and FTX navigated their respective bankruptcies, a new legal battle emerged over $446 million that Alameda Research had repaid to Voyager before its collapse. Alameda, the trading firm closely tied to FTX, sought to recover these funds, arguing that Voyager had received them after filing for bankruptcy in July 2022. However, Voyager's creditors pushed back, claiming that Alameda's actions had inflicted between $114 million and $122 million in damages on the now-defunct brokerage. This dispute underscored the tangled financial relationships that had fueled the crypto boom, and the legal complexity of unwinding them in the aftermath of multiple industry collapses. Voyager's creditors subpoenaed key executives from FTX and Alameda, including SBF and former Alameda co-CEO Samuel Trabucco, to bolster their case. The subpoenas sought to uncover details about FTX's attempt to acquire Voyager during its initial bankruptcy proceedings, which creditors alleged was designed more for publicity than for genuine financial recovery. Lawyers for Voyager's creditors argued that FTX had positioned itself as a white knight, promising to rescue Voyager's customers while simultaneously engaging in opaque financial maneuvers that ultimately contributed to the brokerage's downfall. The depositions, scheduled for February 23, 2023, marked a pivotal moment in the case, as lawyers aimed to expose the full extent of FTX and Alameda's involvement in Voyager's financial troubles. Adding to the intrigue, a Voyager subpoena intended for SBF was instead delivered to his mother, Barbara Freed, prompting his legal team to challenge its validity. As Voyager's legal battles dragged on, the company's bankruptcy trust successfully retained Alameda's capital contribution, preventing the funds from being clawed back. This ruling was a critical victory for Voyager's creditors. The case revealed how interconnected the failures of Voyager and FTX had been, with each firm's downfall accelerating the other's collapse. While Alameda had once been one of Voyager's largest borrowers, it was now attempting to reclaim assets that creditors argued should be used to compensate customers. A resolution to the dispute finally came in April 2024, when a Delaware bankruptcy judge approved a $450 million settlement between Voyager and the now-defunct FTX. Judge John Dorsey's ruling on April 29 effectively ended the long-running legal battle over Alameda's loan repayments. Under the settlement terms, Voyager was granted access to $4.5 million from an escrow fund, while the remaining $445 million would come from the lawsuit against Alameda. The ruling also terminated FTX's rights to the funds, preventing further legal claims from interfering with Voyager's recovery efforts. This marked a crucial step toward financial restitution for Voyager's creditors, although many had already suffered irreparable losses in the prolonged legal process. Despite the settlement, Voyager's legal challenges were far from over. The company continued to pursue claims against other entities, including the failed hedge fund Three Arrows Capital, which had played a central role in its downfall. At the same time, Voyager proposed a new repayment plan, aiming to reimburse customers for 100% of their assets, minus the amount still owed to the firm. While this plan offered some hope to creditors, it remained uncertain how much they would ultimately recover, given the complexities of ongoing litigation. The case served as a stark reminder of the fragility of the crypto lending industry and the legal turmoil that followed its unraveling. For many former Voyager customers, the settlement was too little, too late. Another chapter in a saga of financial devastation that had shattered trust in the once booming world of digital assets, FTX. Voyager Digital marketed itself as a safe and secure platform throughout its meteoric rise, reassuring customers that their funds were protected under federal insurance. In reality, these claims were misleading. Voyager falsely advertised that customer deposits were FDIC insured up to $250,000, a promise prominently displayed on its website, app, and in promotional emails. Many users, seeking an alternative to traditional banks, were drawn in by this assurance, believing their assets had the same level of protection as funds held in federally regulated institutions. However, Voyager was not an FDIC-insured entity, and its customers were left exposed to catastrophic losses when the company collapsed. The Federal Deposit Insurance Corporation, FDIC, only covers cash deposits in case of a bank failure, not the failure of a crypto brokerage. While Voyager did store customer cash at Metropolitan Commercial Bank, MCB, this insurance only applied to the bank itself, not Voyager. If MCB collapsed, customers could claim up to $250,000 in protection, but there was no safety net if Voyager failed. Yet Voyager's marketing materials did not make this distinction clear. Instead, customers were led to believe their fiat and crypto holdings were insured, reinforcing a false sense of security that ultimately exacerbated the impact of Voyager's downfall. When Voyager froze withdrawals in June 2022, customers were blindsided. Over $1 billion in funds were locked on the platform, with no immediate recourse for users who had believed their money was protected. Many had placed their life savings, home sale proceeds, and college funds into Voyager accounts under the impression that they were FDIC-backed. The fallout was devastating. By the time Voyager filed for bankruptcy in July 2022, it was clear that customers had been grossly misled. The FDIC intervened by issuing a cease and desist letter to Voyager, which finally removed the misleading claims from its marketing materials, far too late for those who had already suffered financial ruin. Evidence suggests that Voyager executives, including CEO Stephen Ehrlich, were fully aware of the deception. In 2021, Metropolitan Commercial Bank warned Voyager to clarify its statements to prevent consumers from mistakenly believing that cryptocurrency holdings were FDIC-insured. Voyager made minor revisions to its terms, but continued to promote misleading claims in its public communications. As late as June 2022, just weeks before Voyager halted withdrawals, Ehrlich reassured customers in a letter that their funds were protected by FDIC insurance. His words carried weight, convincing users to keep their money on the platform despite growing concerns about Voyager's liquidity. Regulators took swift action against Voyager and Ehrlich for their deceptive practices. On October 12, 2023, the Federal Trade Commission, FTC, and the Commodity Futures Trading Commission, CFTC, filed formal complaints charging Ehrlich with fraud and violations of financial regulations. The FTC alleged that Voyager and Ehrlich had violated Section 5A of the FTC Act, which prohibits deceptive business practices, as well as the Gramm-Leach-Bliley Act, which restricts the use of fraudulent statements to obtain consumer financial information. The FTC reached a settlement with Voyager that permanently banned the company from handling customer assets and imposed a $1.65 billion judgment. However, the penalty was suspended to allow for continued liquidation efforts. The legal repercussions extended beyond the company itself. The FTC complaint also alleged that Ehrlich had transferred millions of dollars to his wife, Francine Ehrlich, to shield assets from legal claims. The commission included Francine as a relief defendant, arguing that she had received funds derived from Voyager's deceptive practices without providing services in return. The case underscored the broader consequences of misleading financial advertising in the crypto sector, as regulators sought to hold individual executives accountable for their actions rather than allowing them to hide behind corporate bankruptcy protections. The origins of Voyager's FDIC deception stretched back years. In late 2019, Ehrlich co-authored a white paper outlining Voyager as a user-friendly gateway to digital asset trading, emphasizing its safety and liquidity. On December 18, 2019, Voyager published a blog post explicitly claiming that the FDIC insured customer deposits. The statement went largely unchallenged at the time, allowing Voyager to build a public image of reliability. As crypto markets boomed in 2020, this messaging became a crucial selling point, drawing in retail investors who were eager for high yields but wanted the reassurance of regulatory protection. Voyager doubled down on this narrative in subsequent years. On May 6, 2020, the company issued a press release touting new interest-bearing assets as safe havens during volatile economic conditions. Ehrlich framed Voyager as a financial institution committed to protecting user assets, further reinforcing the misconception that Voyager operated under similar regulatory safeguards as traditional banks. In October 2020, the company repeated these claims, branding the Voyager Rewards program as a secure alternative to traditional savings accounts. While customers were promised high returns, Voyager failed to disclose the fundamental risks of unsecured crypto lending and rehypothecation. The deception persisted even as Voyager's executives personally benefited from the company's soaring valuation. Between February and March 2021, Ehrlich and his Delaware LLCs sold nearly 1.9 million shares of Voyager stock, netting over $31 million. His largest transactions, totaling $19 million, coincided with a $50 million secondary stock offering. Just 1 week after Ehrlich's final sale, Voyager's stock peaked at $29.86 before plummeting 41% over the next 3 weeks. By November 2021, Voyager shares had lost 69% of their value, even as broader crypto markets remained near their highs. The timing of Ehrlich's sales raised serious concerns about potential insider trading. Voyager's unraveling revealed the dangers of regulatory arbitrage in the crypto industry. By operating as a broker rather than a lender, Voyager had avoided many of the traditional oversight mechanisms applied to financial institutions. However, its marketing claims had blurred the distinction, creating a false sense of security among customers. The collapse of the platform, coupled with the exposure of its FDIC misrepresentation, served as a wake-up call for regulators. It underscored the urgent need for clearer consumer protections in digital asset markets and stricter enforcement against misleading financial claims. In the end, Voyager's downfall was not just a story of financial mismanagement, but one of deception at the highest levels. Ehrlich and his company had knowingly misled customers, falsely assuring them that their funds were protected. When the truth came to light, it was too late. Billions of dollars had vanished, and countless retail investors were left with nothing. The legal actions against Voyager, the FTC settlement, and the criminal charges against Ehrlich marked a rare instance of accountability in an industry rife with fraud. Yet, for those who lost their savings, no regulatory fine or executive lawsuit could undo the damage caused by Voyager's lies. CFTC. A key component of Voyager's appeal was its rewards program, which advertised returns as high as 12% on customer deposits. Investors were led to believe that these high-yield returns were comparable to interest earned in a traditional bank or brokerage account, offering a straightforward and secure way to grow their assets. In reality, these returns were entirely dependent on Voyager's abilities to generate profits from lending out customer assets to highly leveraged third parties, including the now infamous hedge fund Three Arrows Capital, 3AC. The risk of default was never adequately disclosed, and the customers remained unaware that their funds were tied to volatile and unstable counterparties. As long as the crypto bull market persisted, Voyager's model appeared viable, but the moment the market turned, the platform unraveled. Voyager's lending practices were riddled with failures in due diligence, particularly in its dealings with 3AC, which received over $650 million in loans from the platform. Despite 3AC's history of aggressive, high-risk trading, Voyager's Loan Risk Committee, led by Ehrlich, approved massive unsecured loans with little more than a one-sentence letter, asserting 3AC's net asset value. No independent audits, financial stress tests, or collateral requirements were put in place to protect customer funds. Even as concerns about 3AC's exposure to the Terra Luna ecosystem collapse mounted, Voyager continued extending credit. The absence of proper financial scrutiny meant that when 3AC defaulted in June 2022, Voyager was left with an unfillable hole in its balance sheet, one that would directly contribute to its bankruptcy. Even as Voyager's financial position deteriorated, Ehrlich and the company actively concealed the extent of the crisis from customers and investors. On June 12, 2022, just days before Voyager would halt withdrawals, the company's official Twitter account falsely assured users that all products and services were fully operational and unaffected by market conditions. Ehrlich personally amplified this deception, retweeting the statement and reinforcing the narrative that Voyager remained financially stable. Internally, however, executives described the company as hanging by a thread. The delay in disclosing Voyager's exposure to 3AC, which was not admitted until June 22, 2022, allowed Voyager to collect more deposits even as it had teetered on the brink of insolvency. The regulatory fallout from Voyager's collapse was swift. On October 12, 2023, the Commodity Futures Trading Commission, CFTC, formally charged Voyager and Ehrlich with fraud, citing their failure to disclose the company's true financial risks. The complaint detailed how Voyager had operated as an unregistered commodity pool operator, CPO, by pooling customer assets for lending and trading without proper regulatory approval. Additionally, Voyager had buried critical risk disclosures in lengthy legal agreements while making misleading public statements about its stability. Regulators also scrutinized Ehrlich's personal actions, including his failure to register as an associated person, AP, despite engaging in activities that required such registration. Perhaps most damning, investigators uncovered evidence that Ehrlich had transferred millions of dollars to his wife's trust just as Voyager's financial condition worsened. These actions painted a picture of a CEO who, rather than protecting his customers, prioritized concealing Voyager's precarious financial position and securing his own wealth. Liquidation. By May 2023, Voyager Digital's unraveling reached its final stage as the company began liquidating its remaining assets. Customers who had been locked out of their accounts for nearly a year received devastating news. Their initial recovery would be just 36% of their crypto holdings, a fraction of the 72 to 73% they had expected if either of the failed acquisition deals with FTX US or Binance US had gone through. By comparison, creditors of other collapsed crypto firms, such as Celsius, were expected to recover around 70% of their claims. The difference underscored just how deeply Voyager's reckless lending practices and mismanagement had eroded customer assets. The situation remained fluid, however, as creditors hoped that ongoing litigation, particularly Alameda Research's lawsuit attempting to claw back $446 million from Voyager, would be resolved in their favor, allowing for additional distributions in the future. Voyager's bankruptcy process was riddled with complications, delays, and costly legal battles, which further reduced the amount available to creditors. In addition to the $446 million reserve for the Alameda lawsuit, Voyager's legal team set aside another $259.6 million to cover litigation costs, administrative claims, and other bankruptcy-related expenses. These holdbacks effectively siphoned away funds that otherwise could have gone to customers. The company also made a controversial decision regarding unsupported tokens. While users holding any of the 67 supported cryptocurrencies, such as Bitcoin, BTC, and Ethereum, ETH, could withdraw their funds, those holding any of 38 unsupported tokens, including Solana, SOL, and Algorand, ALGO, would have their assets forcibly liquidated and returned in USDCOIN, USDCOIN. For many investors, this meant realizing losses in a down market, an outcome far from the promises Voyager had once made about digital asset security. By April 2024, Voyager had secured a total of $484.35 million in settlements with FTX, Three Arrows Capital, 3AC, and Directors and Officers, D&O, insurance claims, marking one of the largest financial recoveries in the case. The funds accounted for approximately 25% of Voyager creditors' claims, offering some hope of additional distributions. The 3AC litigation, which had been ongoing since the hedge fund's collapse in 2022, produced a $675 million claim in Voyager's favor, though only $20.43 million had been received in an initial distribution. Additional payments were expected over time, depending on the liquidation of 3AC's remaining assets. The settlement with D&O Insurance, which covered Voyager's former executives, added another $14.35 million to the creditor pool. However, while these settlements represented progress, they also exposed the immense damage inflicted by Voyager's reckless financial strategy. Investors were still left far short of full recovery. Chapter 4. Genesis. Genesis's rise. Genesis Trading emerged in 2013, introducing the first over-the-counter OTC Bitcoin trading desk at a time when digital assets remained on the fringes of mainstream markets. The firm provided a structured and regulated service tailored to institutional investors, offering deep liquidity and personalized trade execution for hedge funds, family offices, and high-net-worth individuals seeking exposure to Bitcoin. Genesis was also an early mover in crypto lending, pioneering Bitcoin-denominated loans in 2013. This service allowed market participants to borrow Bitcoin against collateral, a revolutionary concept introducing liquidity solutions for a volatile and often illiquid asset class. The introduction of crypto lending expanded Genesis's business model and set the stage for the broader institutional acceptance of digital assets as viable financial instruments. As demand surged, Genesis's lending operations grew parallel with its trading desk, enabling the firm to cultivate a reputation as a full-service financial institution within the crypto economy. Its early willingness to experiment with novel financial products differentiated it from competitors and solidified its position as a market leader. By 2014, Genesis expanded its offerings to include Ethereum, reflecting its commitment to a multi-asset trading strategy. At a time when Bitcoin remained the dominant cryptocurrency, Genesis recognized the potential of Ethereum's innovative contract capabilities and moved swiftly to integrate it into its trading and lending services. This decision underscored the firm's forward-thinking approach, allowing institutional clients to diversify their exposure beyond Bitcoin. The expansion into Ethereum also set a precedent for Genesis's broader mission, serving as a gateway for institutional investors to access emerging digital assets while maintaining a high standard of professionalism and security. With Ethereum's rise, Genesis became a key facilitator of institutional participation in the crypto economy. The firm's growth trajectory accelerated with its first capital raise in October 2016, when it secured $12 million in Series A funding led by Ribbit Capital. This investment validated Genesis's business model at a time when institutional crypto adoption was still in its infancy. The capital infusion enabled Genesis to refine its trading infrastructure, expand liquidity reserves, and enhance its risk management framework, critical components for sustaining growth in a volatile market. By this point, Genesis had already processed billions in OTC Bitcoin trades. The funding also signaled a shift in market sentiment, as established investors began recognizing cryptocurrency's long-term potential. 2 years later, in October 2018, Genesis raised an additional $85 million in Series B funding, further cementing its role as a dominant force in institutional crypto trading. With this fresh capital, the firm scaled its trading desk operations, invested in cutting-edge technology, and expanded its lending division, responding to the growing demand for structured crypto financial products. Once skeptical of digital assets, institutional investors now viewed Genesis as a gateway to the crypto economy. By the close of 2018, Genesis stood as a symbol of institutional crypto adoption, an entity that had not only survived but thrived in an industry defined by volatility and disruption. EARN. In early 2021, Genesis Capital expanded its influence in the crypto lending market through a partnership with Gemini, the exchange founded by Cameron and Tyler Winklevoss. The collaboration gave birth to Gemini EARN, a high-yield investment product offering retail investors up to 7.4% annual percentage yield, APY. Unlike decentralized finance, DeFi platforms, Genesis operated as a regulated centralized lender, promising a more stable and secure alternative. The initiative marked a strategic pivot for Genesis, which had primarily focused on institutional lending, but now found itself at the forefront of retail-facing crypto investment products. The launch of Gemini EARN was accompanied by a coordinated media push, bolstered by digital currency groups, DCG, ownership of the crypto news outlet CoinDesk. On February 2, 2021, CoinDesk published a story highlighting the partnership, giving it an air of credibility among retail investors and reinforcing Genesis's status as a dominant force in crypto lending. The marketing effort paid off. Billions of dollars poured into EARN within months as investors sought passive income in a market characterized by speculative excess and rapidly rising digital asset prices. For investors, Gemini EARN appeared to be a safe and lucrative option. Gemini's website assured users that they could withdraw their funds at any time with no penalties, making the program feel as accessible as a traditional savings account but with far superior returns. Behind the scenes, however, Genesis was actively pooling these assets and lending them to institutional borrowers, hedge funds, and market makers. These loans were structured with collateralization requirements presumed to minimize risk, but the underlying exposures were not always transparent to EARN participants. Genesis's rapid growth in this period mirrored a broader shift in the crypto industry. By mid-2021, its total loan originations had surpassed $60 billion, a staggering increase from the $5 billion recorded just a year prior. The firm's lending business thrived as institutions sought leverage to maximize gains on Bitcoin, Ethereum, and other assets. At the same time, stablecoin adoption surged, with total market capitalization soaring from $10 billion to $150 billion, offering institutions a lower volatility alternative for crypto-based transactions. Genesis played a pivotal role in facilitating these shifts, extending loans that fueled speculative bets across the industry. At the core of the Gemini EARN arrangement was a Master Digital Asset Loan Agreement, which formalized the transfer of user funds to Genesis. Investors were required to sign this agreement before depositing their assets, effectively turning over their crypto to Genesis in exchange for promised yields. These digital assets were commingled with Genesis's broader lending reserves, a practice that would later be scrutinized as market conditions deteriorated. While Gemini acted as an intermediary, collecting fees to facilitate the program, it had little control over how Genesis deployed the funds. Genesis's lending model appeared fundamentally different from the risky yield farming strategies prevalent in the DeFi sector. Unlike decentralized protocols, where users directly interacted with smart contracts, Genesis operated within a framework of institutional trust, relying on its relationships and due diligence processes to manage risk. However, this centralized approach carried its own vulnerabilities. The company's lending decisions were concentrated among a handful of large counterparties, including hedge funds and proprietary trading firms, making it highly susceptible to cascading failures if key borrowers defaulted. The seamless integration of Gemini EARN within the Gemini platform further fueled its adoption. Gemini aggressively promoted the program through marketing emails and an easy-to-use one-click feature that allowed users to transfer assets directly into Earn. The exchange curated a list of eligible cryptocurrencies, like Bitcoin and Ethereum. By mid-2021, Gemini Earn had grown into one of the most popular retail crypto lending products, serving as a key revenue driver for both Genesis and Gemini. Investors flocked to Earn partly due to its stable rates, which contrasted with the highly volatile returns offered by DeFi platforms. Genesis determined yield rates monthly, adjusting them based on market demand and internal risk assessments. While the program initially advertised a 7.4% APY, rates varied depending on the asset and Genesis's ability to generate interest from borrowers. Despite the fluctuations, Earn investors were reassured by the perception that Genesis was a well-capitalized, institutionally backed entity operating under the oversight of a reputable firm like Gemini. Genesis's rise also reflected a broader trend in crypto markets, where centralized lenders played an increasingly dominant role in liquidity provisioning. Unlike retail investors, who lacked direct access to high-yield lending opportunities, Genesis was able to negotiate more favorable loan terms with institutional borrowers. This dynamic allowed Genesis to capture significant spreads between the interest it earned from counterparties and the yields it paid to Earn participants, making the business highly profitable, at least in the short term. The explosive growth of Genesis's lending operations coincided with an influx of hedge funds into crypto markets. Genesis CEO Michael Morrow noted an avalanche of hedge funds seeking exposure to digital assets, driving record demand for leverage. Many of these funds borrowed against their Bitcoin holdings to amplify bets on market movements, further entrenching Genesis as a central player in institutional lending. However, the firm's aggressive expansion also meant it was becoming increasingly entangled in the complex, interdependent web of crypto finance, setting the stage for future vulnerabilities. As the bull market raged on, Genesis and Gemini basked in the success of Earn, promoting it as a new standard for secure, yield-generating crypto investments. The program's popularity underscored the growing appetite for passive income products in the digital asset space, reinforcing the illusion that crypto lending could provide consistent, risk-adjusted returns. Yet, behind the scenes, the risks inherent in Genesis's business model were quietly accumulating, unnoticed by the retail investors who had entrusted billions of dollars to the program. The cracks would only become visible when market conditions turned, revealing the fragile foundation upon which Genesis's meteoric rise had been built. Genesis and Gemini's Earn program was marketed as a lucrative yet stable investment opportunity, but interest rates fluctuated dramatically behind the scenes. Investors who placed their assets in Earn saw their returns diminish over time. 3.05% APY in February 2021 dropped to 2.05% by May, then further declined to 1.65% in August, 1.49% in September, and finally 1.49% in October, 1.01% by February 2022. Despite these reductions, Gemini's marketing continued to claim that Earn's interest rates were more than 100x the average national interest rate, among the highest rates on the market. Investors were assured that rates could increase or decrease, though few expected the following sharp downward trajectory. By mid-2021, Genesis's lending business had evolved beyond Bitcoin, with Ethereum and DeFi tokens taking center stage. As demand for decentralized finance surged, hedge funds increasingly turned to Genesis to borrow ETH, using it to participate in DeFi protocols. Genesis reported that Bitcoin's dominance in its loan book had fallen from 70% at the start of 2021 to just 42% by the second quarter, a reflection of broader market shifts. During this period, Genesis saw record-breaking loan originations, totaling $25 billion in a single quarter, an eightfold increase year over year. With cumulative loan originations exceeding $66 billion since its inception, Genesis had become a linchpin of institutional crypto lending. Between February 2021 and November 2022, Gemini Earn investors funneled billions of dollars into Genesis, generating over $22 million in fees for Gemini and an additional $10 million in commissions from the cryptocurrency purchases. Gemini framed EARN as a low-risk and highly liquid investment, promising that funds could be withdrawn anytime. To reassure investors, Gemini publicly emphasized that it rigorously vetted Genesis through its risk management framework, reviewing financial statements and assessing collateralization practices. Internally, however, Gemini's risk analyses painted a different picture. By early 2022, Gemini downgraded Genesis's internal credit rating from BBB, investment grade, to CCC, junk grade, signaling increasing concerns about the firm's stability. In September 2022, Gemini decided to terminate EARN, formally notifying Genesis on October 13, 2022, and demanding the return of investor assets. Yet, even after making this decision, Gemini continued to accept tens of millions of dollars in new deposits from investors, funneling them into Genesis without disclosing EARN's imminent termination. At the same time, high-level Gemini employees, including one company officer, quietly exited their positions in EARN. Meanwhile, Genesis's financial health was unraveling. The firm's largest borrower, Three Arrows Capital, defaulted on billions of dollars in loans in June 2022, creating what Genesis internally referred to as a structural hole in its balance sheet. To conceal the crisis, Genesis Digital Currency Group, DCG, and its executives engaged in a coordinated misinformation campaign and in public statements and tweets. Genesis CEO Michael Morrow and DCG founder Barry Silbert assured investors that Genesis remained financially sound. On June 30, 2022, DCG executed a promissory note pledging $1.1 billion to Genesis over 10 years at a mere 1% interest rate, an illiquid and insufficient measure to cover the firm's shortfalls. Yet, Genesis listed the note as an asset on its balance sheet, misleading counterparties about its financial condition. Even as liquidity evaporated, Genesis continued to accept EARN deposits under false pretenses, misrepresenting its solvency and withholding crucial financial disclosures from Gemini and investors alike. Institutions. With the growing demand for yield-generating crypto products, Genesis expanded aggressively into institutional lending, positioning itself as the premier bridge between digital assets and traditional finance. Unlike Gemini EARN, which catered to retail investors, Genesis's lending services targeted hedge funds, market makers, and proprietary trading firms. These clients sought structured, centralized lending alternatives to the often opaque and risky decentralized finance DeFi markets. Genesis's reputation for providing liquidity and risk management expertise made it a trusted partner in the burgeoning crypto credit ecosystem. As institutional demand surged, Genesis rapidly scaled its loan book, solidifying its dominance in the space. The firm's lending ambitions extended beyond its direct client base. In a strategic move, Genesis partnered with BlockFi, another leading crypto lender, to create an expansive institutional borrowing network. The collaboration allowed BlockFi's retail borrowers to access Genesis's liquidity while expanding Genesis's footprint in the broader lending market. By 2021, Genesis was managing billions in active loans, benefiting from the symbiotic relationship with BlockFi. Yet this partnership also entangled Genesis with the broader vulnerabilities of crypto lending, as risk exposure mounted in an increasingly leveraged market. By mid-2021, Genesis's loan book was shifting dramatically as Ethereum and DeFi-related assets eclipsed Bitcoin in borrowing demand. Hedge funds aggressively borrowed ETH for DeFi trading strategies, significantly changing Genesis's loan composition. Bitcoin's dominance in Genesis's outstanding loans fell from 70% to under 45%, marking a fundamental realignment of the company's lending focus. This transformation aligned Genesis with the broader institutional trend favoring DeFi yield opportunities over traditional crypto holdings. Within a year, Genesis's loan originations surged eightfold, surpassing $66 billion, marking its ascent as the preeminent institutional lender in crypto. Institutional lending was only one pillar of Genesis's expansion. The firm capitalized on the explosive demand for crypto derivatives, particularly among hedge funds seeking leveraged exposure to Bitcoin and Ethereum. Genesis's derivatives desk facilitated complex trading strategies, including arbitrage, structured products, and options trading. With $35.7 billion in active loans and record-breaking demand for its trading services, Genesis evolved beyond a lender into a full-fledged prime brokerage. Its ability to offer integrated lending and trading services reinforced its role as a critical infrastructure provider in institutional crypto finance. As DeFi continued to capture market attention, Genesis's executives identified another emerging trend: the rise of non-fungible tokens, NFTs, and the metaverse. In response, Genesis launched a new lending division focused on financing digital asset investments. Traders and institutional investors could now collateralize their NFT holdings for liquidity, allowing them to extract value without selling assets outright. While this move positioned Genesis at the forefront of NFT finance, it also introduced new risks. Unlike Bitcoin or Ethereum, NFTs lacked a simple process to access liquidity, adding another layer of exposure to Genesis's expanding risk profile. During the same period, Genesis was key in facilitating Gemini Earn, a yield-bearing product that promised high returns to retail investors. Between February 2021 and November 2022, Gemini Earn users entrusted billions of dollars to Genesis, while Gemini collected over $32 million in fees. The product's marketing emphasized security and liquidity, reassuring investors that Genesis's lending model was thoroughly vetted. However, few questioned whether Genesis's short-term redemption promises aligned with the actual duration of its loans. The firm's rapid scale-up masked growing structural vulnerabilities in its balance sheet. Genesis's success hinged on the perception of financial stability, a narrative Gemini's marketing campaigns reinforced. Gemini's slogan, "Make your crypto work for you," suggested low-risk, high-reward investment opportunities. Earn participants were promised yields as high as 8.05%, with the added benefit of anytime withdrawals. Internally, Genesis dictated interest rates, adjusting them monthly based on market conditions. Genesis reached a new milestone, surpassing $150 billion in cumulative loan originations, a testament to the unprecedented growth of institutional crypto lending. By now, institutional borrowers relied on Genesis for deep liquidity in Bitcoin, Ethereum, and stablecoins. The firm's ability to facilitate large trades, provide lending at competitive rates, and support complex financial strategies made it an indispensable player in crypto finance. Yet, market signals pointed to rising stress. Volatility was increasing, and several major funds were experiencing liquidity pressures. Despite these warning signs, Genesis remained bullish on its lending model, confident in its ability to navigate the turbulent market. Beneath the surface, however, Genesis was deeply exposed to risky borrowers, including Three Arrows Capital, 3AC, whose leverage-fueled strategies depended on sustained market growth. When crypto prices began to decline in mid-2022, these leveraged bets unraveled, putting immense strain on lenders like Genesis. 3AC. Genesis's decision to extend hundreds of millions of dollars in loans to 3AC was based on a fundamental miscalculation: the belief that 3AC was financially stable. At the time, 3AC had built its reputation as a sophisticated trading firm with access to substantial liquidity. But when Terra's algorithmic stablecoin, UST, collapsed in May 2022, it wiped out billions in market value overnight, setting off a chain reaction across the crypto industry. By June 2022, the extent of the damage was undeniable. 3AC defaulted on its debts, leaving a $2.3 billion hole in Genesis's balance sheet. The impact was immediate and severe. Withdrawals from Genesis surged as institutional clients rushed to secure their funds, fearing a broader liquidity crisis. Meanwhile, parent company Digital Currency Group, DCG, led by Barry Silbert, sought to control the damage. DCG orchestrated a $1.1 billion promissory note to reassure investors, a financial maneuver meant to create the illusion of stability. The note, however, was not an infusion of capital. It was a 10-year debt instrument with a nominal 1% interest rate, offering no immediate relief to Genesis's growing liquidity crisis. Despite the glaring shortfall, Genesis publicly maintained that its financial health remained intact. Executives insisted the firm was well capitalized and had successfully managed its exposure to 3AC. Behind closed doors, the reality was starkly different. Internal communications revealed deep concerns about the firm's ability to meet obligations, particularly under its EARN program, which allowed retail investors to deposit funds through partnerships with companies like Gemini. Genesis's balance sheets classified the illiquid promissory note as a cash-ready asset, masking the true extent of the firm's financial distress. The firm's CFO avoided disclosing complete quarterly reports to Gemini and other key partners, knowing that transparency would expose the precarious nature of the firm's finances. The house of cards Genesis had built was teetering. Sales teams were given scripted responses to client inquiries, carefully avoiding the uncomfortable truth that the firm was insolvent. Meanwhile, the broader crypto market was still reeling from the Terra collapse. While DCG's involvement initially calmed fears, industry insiders recognized the promissory note for what it was: a desperate attempt to buy time. Investors began questioning whether DCG had the ability or intent to fully backstop Genesis's mounting losses. As pressure mounted, Genesis took legal action against 3AC. On July 18, 2022, the firm filed a $1.2 billion claim in bankruptcy proceedings, revealing that its total exposure to 3AC was far greater than previously disclosed: $2.36 billion. The revelation shocked the industry, confirming that Genesis had extended loans on far riskier terms than it had let on. However, any hopes of recouping funds were short-lived. DCG swiftly assumed the entire $1.2 billion claim, effectively transferring the debt onto its own balance sheet. This maneuver insulated Genesis from immediate collapse, but merely displaced the financial burden, sowing the seeds for DCG's own crisis. As regulators and creditors scrutinized the firm's dealings, inconsistencies in public statements and internal records became increasingly difficult to ignore. The crypto industry, still grappling with the fallout from Terra, had little patience for obfuscation. By late 2022, Genesis faced mounting legal and regulatory pressure to disclose the true state of its finances. The firm's attempt to reassure investors had bought time but had done little to fix the structural damage. By the time Genesis acknowledged the full extent of its financial peril, it was too late. The firm had not only miscalculated its risk exposure, but had actively engaged in financial sleight of hand to obscure its troubles. The $2.3 billion shortfall caused by 3AC's collapse was not just a singular misstep. It was emblematic of the broader recklessness that had defined the crypto lending boom. Like many of its peers, Genesis had operated under the assumption that the market would always recover. When that assumption failed, so too did the foundations of its business. In hindsight, Genesis's fate was sealed the moment it decided to keep lending to 3AC despite clear warning signs. Many in the crypto space shared the decision to prioritize growth over risk management, but Genesis's scale made its missteps particularly devastating. While the firm scrambled to contain the damage, the broader implications were unavoidable. Crypto's unregulated lending ecosystem had created a fragile financial web, and Genesis was one of the first, but certainly not the last, to collapse under its weight. Genesis's fall. Genesis had deep financial ties to SBF's empire. So, when FTX filed for bankruptcy on November 11th, a liquidity crisis swept through the industry, and Genesis was trapped in the contagion. Like a row of dominoes falling in sequence, Genesis's troubles accelerated in the following days and weeks. On November 16, 2022, Genesis froze customer withdrawals. The firm cited unprecedented market conditions and liquidity issues, effectively locking up billions of dollars in client funds. At the time, Genesis Global Capital, the company's lending division, had $2.8 billion in active loans. The decision to halt withdrawals sent shockwaves through the market, particularly for Gemini EARN users who had entrusted Genesis with their deposits. Genesis revealed that its derivatives unit had $175 million locked in its FTX trading account days before the withdrawal freeze. To stabilize the situation, its parent company, Digital Currency Group, DCG, injected $140 million into Genesis, aiming to restore confidence. However, this capital infusion did little to address the growing insolvency concerns. Gemini, which had partnered with Genesis to offer yield-bearing accounts through its Earn program, expressed frustration over Genesis's inability to meet obligations. Despite reassurances that DCG and Genesis were working toward a resolution, customers remained locked out of their funds, and confidence in the firm continued to erode. As fears mounted, the market reacted swiftly. On November 21, 2022, reports emerged that Genesis was considering bankruptcy. The mere mention of insolvency sent Bitcoin's price to a two-year low of $15,480. The news reinforced concerns that the crypto industry was entering a prolonged winter. Genesis's attempts to raise emergency funding yielded little success. With many firms still reeling from the FTX collapse, investors were unwilling to step in and rescue a lender that had lost its footing. On November 29, 2022, the company's creditors hired restructuring lawyers to explore legal options, including a potential bankruptcy filing. At the same time, Genesis's leadership faced mounting pressure. The firm had already cut 30% of its workforce to reduce costs, and key executives, including CEO Michael Morrow, departed amid the crisis. December 2022 brought even graver revelations. Reports indicated that Genesis creditors were owed over $1.8 billion. One of the largest creditor groups consisted of Gemini Earn users, collectively owed $900 million. In a letter to clients, Genesis's interim CEO, Darer Islam, admitted there was no immediate solution to the withdrawal freeze, stating that any resolution would take weeks rather than days. The situation grew increasingly dire for many of Genesis's customers, particularly those in the Earn program. Unlike retail investors who could cut their losses and move on, many institutional clients and crypto firms had vast sums of money trapped in Genesis. Gemini, which had assured users that their funds were safe, now faced legal and reputational risks as it struggled to recover deposits from Genesis. Cameron and Tyler Winklevoss, the billionaire founders of Gemini, engaged in a public dispute with Barry Silbert's DCG, accusing Genesis and DCG of misleading customers about the financial health of the lending unit. By early 2023, legal battles intensified. The involvement of multiple creditor groups, including major law firms like Latham and Watkins and Kirkland and Ellis, signaled that the bankruptcy process would not be resolved quickly. Meanwhile, FTX negotiated a settlement to recover some of its lost funds. In a controversial move, Genesis and FTX agreed to a $175 million settlement, far lower than the $3.8 billion FTX had initially claimed. Bankruptcy. By January 19, 2023, Genesis had no choice but to formally file for Chapter 11 bankruptcy protection in the Southern District of New York. The filing exposed the extent of the damage. The company owed over $5.1 billion to creditors, making it one of the largest collapses in crypto history. The bankruptcy proceedings revealed that Genesis had been insolvent for months, even as it reassured customers that it remained financially sound. Genesis's debt was far greater than anyone had initially anticipated. First-day bankruptcy filings showed that the firm owed over $3.5 billion to its top 50 creditors, many of whom had assumed they were dealing with a solvent institution. Some creditors, whose names were redacted from public filings, were individually owed as much as $462 million. The scale of the insolvency shocked industry insiders, reinforcing the reality that Genesis had been concealing its financial distress long before the FTX crisis. Despite repeated assurances from DCG and Genesis executives, the firm had been unable to meet its obligations for months. The bankruptcy filing also ignited a very public feud between Gemini and DCG. Cameron Winklevoss, co-founder of Gemini, accused Barry Silbert of fraud and called for his resignation. In an open letter, Winklevoss alleged that DCG had misled Gemini earned customers by downplaying Genesis's financial troubles. He argued that Silbert had knowingly engaged in deceptive practices, allowing Genesis to continue accepting deposits while fully aware that it was insolvent. Silbert denied the allegations, but the dispute escalated, drawing regulatory scrutiny from state and federal authorities. After the bankruptcy filing, Genesis and DCG attempted to craft a restructuring plan, allowing creditors to recover some of their lost funds. The proposed plan included selling Genesis's trading unit and repaying creditors over time through a mix of cash and newly issued convertible stock. However, the plan faced immediate resistance. Gemini and other major creditors opposed the terms, arguing that it undervalued their claims and failed to provide full restitution. This disagreement prolonged the bankruptcy proceedings, as competing creditor factions fought over how the remaining assets should be distributed. By February 2023, total creditor claims against Genesis had surpassed $4 billion. Many of these claims came from large crypto platforms that had used Genesis as their lending partner, including Gemini, which had shouldered a significant portion of the financial burden. As bankruptcy proceedings moved forward, Genesis's role as one of FTX's largest unsecured creditors came into focus. Court documents revealed that Genesis had been owed $226 million by FTX and its affiliated companies, making it the single largest unsecured creditor of Sam Bankman-Fried's defunct empire. This revelation highlighted just how deeply interconnected the crypto industry had become. Genesis was not only a lender to high-profile clients, but also exposed to many of the same financial risks that ultimately brought down FTX. Throughout January and February 2023, Barry Silbert continued to issue statements attempting to distance DCG from Genesis's troubles. In a letter to shareholders, he emphasized that DCG had borrowed money from Genesis, but insisted that these loans had been structured at arm's length and priced at market rates. However, the disclosure that DCG owed Genesis $447.5 million and an additional 4,550 Bitcoin further eroded trust. To many creditors, it appeared that DCG had used Genesis as a personal credit line, further deepening its financial entanglements. The battle over Genesis's remaining assets continued throughout the year. By August 2024, after months of negotiations, Genesis completed its restructuring and began distributing approximately $4 billion in digital assets and US dollars to creditors. Recovery rates varied based on asset type, but the process was far from smooth. Many creditors remained dissatisfied, arguing that DCG and Genesis executives had prolonged the bankruptcy process to protect their own interests rather than prioritizing customers. DCG. By early 2023, Genesis's bankruptcy filings revealed a tangled web of financial obligations, with its parent company, Digital Currency Group, DCG, owing over $1.65 billion to its subsidiaries. The debt comprised a $575 million loan due in May 2023 and a $1.1 billion promissory note due in 2032, an instrument initially intended to absorb losses from 3AC's collapse. As Genesis sought bankruptcy protection, court-appointed committees scrutinized DCG's transactions, including $850 million in unsecured loans and a $52.5 million set-off maneuver in November 2022. The complexity of these financial arrangements led to mounting accusations that DCG had improperly siphoned funds from its failing subsidiary to delay the inevitable. Amid intensifying scrutiny, Genesis and DCG reached an initial agreement with creditors on February 6, 2023, attempting to map out a restructuring plan. The deal included liquidating Genesis's trading division and refinancing DCG's outstanding debts. Additionally, DCG agreed to sell holdings in Grayscale's investment trusts, a move aimed at unlocking liquidity. The restructuring agreement proposed replacing the $1.1 billion promissory note with a new class of convertible preferred stock, a financial instrument that creditors regarded with deep skepticism. Cameron Winklevoss, co-founder of Gemini, announced that his company would contribute $100 million to help Gemini earn customers recover funds. Yet, many creditors saw the plan as an exercise in damage control rather than a path to full restitution. Despite these efforts, DCG's financial struggles worsened. In May 2023, DCG missed a $630 million payment to Genesis, reigniting tensions with creditors. Gemini, already embroiled in a legal and financial battle over earned user deposits, threatened to sue DCG CEO Barry Silbert over unpaid obligations, and the SEC had also taken action against both Genesis and Gemini, accusing them of selling unregistered securities through their yield-bearing earn program. The missed payment and ongoing regulatory and legal battles made it increasingly clear that Genesis's bankruptcy process would be long and contentious. One of the most significant developments came in August 2023, when Genesis and FTX reached a $175 million settlement. Originally, FTX had sought $3.88 billion from Genesis, arguing that the lender had withdrawn substantial assets from FTX before its collapse. The dramatically reduced settlement raised concerns among other Genesis creditors, who accused the firm of striking a backroom deal that prioritized FTX over other legitimate claims. Gemini and a coalition of creditors, calling themselves the Fair Deal Group, objected, calling the settlement a sweetheart pre-planned deal designed to manipulate bankruptcy voting. The controversy underscored the growing divisions among Genesis's creditors. Throughout August and September 2023, DCG and Genesis negotiated a broader restructuring deal with creditors. The tentative agreement projected recovery rates of 70 to 90% for unsecured creditors and 65 to 90% for those holding claims in cryptocurrency assets. However, these numbers were contingent on market conditions and prolonged repayment schedules, fueling concerns among creditors that they would be left holding devalued assets rather than actual cash. DCG also agreed to pay $275 million over 4 installments as part of the restructuring, but many viewed this as an insufficient gesture compared to the billions still owed. The restructuring plan included a controversial proposal that Gemini earned customers might recover up to 110% of their claims, a claim met with widespread skepticism. Gemini's lawyers called the figures a total mirage, arguing that the repayment scheme relied on IOUs rather than tangible assets. Many creditors feared they would receive only a fraction of their owed funds, stretched over an uncertain timeline, while DCG continued operating largely unscathed. Cameron Winklevoss publicly denounced DCG's attempts to use convertible notes and interest payments over 7 years as a substitute for full restitution, calling it a deceptive ploy. The ongoing legal battles escalated in October 2023, when New York Attorney General Letitia James filed a lawsuit against Genesis, Gemini, and DCG, alleging massive fraud affecting 230,000 investors, including 29,000 in New York. The lawsuit accused the companies of concealing billions in losses, particularly from retail investors using the Gemini Earn program. Internal documents showed that Genesis had internally classified its lending business as junk grade, while externally marketing it as a low-risk opportunity. The lawsuit also targeted DCG's use of the $1.1 billion promissory note as an accounting maneuver designed to disguise insolvency. The legal filings detailed how Genesis executives, including CEO Soichiro Moro, had reassured earn users of their funds' safety while privately acknowledging dire liquidity shortfalls. The lawsuit cited heartbreaking stories of retail investors, including a 73-year-old grandmother who lost her $199,000 savings, believing that the Earn program was a safe investment. Regulators sought a complete ban on DCG and Genesis operating in the financial sector and called for full restitution for defrauded investors. The lawsuit marked one of the most aggressive regulatory actions against a crypto firm in the United States. By May 2024, Genesis neared the final stages of its bankruptcy resolution. The proposed settlement, shaped by months of legal battles, aimed to distribute up to $2 billion to affected investors. The settlement included a plan to liquidate Genesis's remaining assets while maximizing distributions to creditors. The New York Attorney General's office hailed it as a victory for defrauded investors, though critics pointed out that actual payouts remained uncertain. Genesis framed the settlement as a necessary step toward closure, though its reputation as a leading crypto lender was irreparably damaged. The unraveling of Genesis underscored the systemic risks within crypto lending. The firm had once prided itself on serving institutional clients with sophisticated risk management, but its collapse revealed a reliance on interconnected borrowing, opaque financial arrangements, and questionable accounting practices. Genesis's ties to FTX, Three Arrows Capital, and DCG made it one of the most deeply embedded lenders in the crypto ecosystem, ensuring its downfall would send ripples throughout the industry. The SEC's role in the saga also highlighted the regulatory gap that had allowed crypto lending platforms to operate with minimal oversight. The agency's lawsuit against Gemini and Genesis, alongside state-level actions like those from New York, set a precedent that yield-bearing crypto products could be classified as securities. This ruling put pressure on other platforms to either register with regulators or shut down similar lending programs. Genesis's settlement with the SEC in March 2024, which included a $21 million penalty, reinforced the agency's commitment to enforcing securities laws in crypto. The broader implications of Genesis's collapse extended beyond bankruptcy courts and regulatory fines. The case exposed the fragile nature of crypto conglomerates like DCG, which operated as sprawling networks of interrelated businesses rather than independent entities. DCG's struggle to manage Genesis's downfall without dragging down its other holdings, including Grayscale and CoinDesk, reflected the delicate balance that major crypto firms had to maintain. The crisis forced Grayscale to sell off assets at a steep discount, further straining DCG's financial position. Genesis's bankruptcy also cast doubt on the viability of institutional crypto lending as a sustainable business model. Firms like BlockFi, Celsius, and Voyager had already collapsed under similar circumstances, and Genesis's downfall cemented the end of the high-yield lending era. The industry was concerned about whether such lending practices could ever function without robust regulatory oversight or were inherently too risky to sustain long-term. As Genesis's bankruptcy case concluded, creditors remained divided over whether the final settlements were fair. Some accepted partial payouts over time, while others continued to push for liquidating remaining DCG assets. Observers noted that while Genesis's legal battles were ending, the broader struggle over crypto's future regulatory landscape was just beginning. Section In January 2023, the U.S. Securities and Exchange Commission, SEC, filed a landmark lawsuit against Genesis Global Capital and Gemini Trust Company, accusing both firms of selling unregistered securities through their Gemini Earn program. The complaint alleged that Genesis and Gemini had offered a yield-bearing crypto lending product to hundreds of thousands of U.S. investors without proper regulatory disclosures. The SEC argued that these companies circumvented securities laws, depriving investors of crucial financial information needed to assess the risks associated with the program. The lawsuit came at a time of heightened legal scrutiny in the crypto industry, following the collapse of major players such as FTX and Three Arrows Capital, 3AC. The Winklevoss twins, co-founders of Gemini, were already embroiled in a bitter feud with Barry Silbert, the CEO of Genesis's parent company, Digital Currency Group, DCG. The SEC's intervention escalated the legal and financial turmoil surrounding Genesis, marking yet another regulatory crackdown on the crypto lending sector. The Gemini Earn program, launched in February 2021, allowed customers to deposit crypto assets with Gemini, which then loaned the assets to Genesis. In turn, Genesis relent those funds to generate interest payments for Earn participants. According to SEC filings, Genesis exercised sole discretion over how to use the loaned crypto, making investment decisions without direct oversight from Gemini or the depositors. The SEC alleged that this setup functioned as an unregistered securities offering, requiring compliance with the Securities Act of 1933. The regulatory agency contended that by failing to register the program, Genesis and Gemini denied investors critical protections, including transparency about how funds were deployed, what risks were involved, and whether Genesis had the liquidity to cover customer withdrawals. The complaint also revealed that in November 2022, Genesis halted withdrawals for 340,000 Gemini Earn users, freezing $900 million in investor assets. Shortly after, Gemini announced the termination of the Earn program, but by then, customers' funds were locked, triggering widespread outrage. As Genesis's bankruptcy proceedings unfolded, May 29, 2023, brought another legal twist. Genesis and Gemini jointly filed a motion to dismiss the SEC's lawsuit. In their filing, the companies pushed back against the SEC's claims, arguing that the Master Digital Asset Loan Agreement, MDALA, that governed Gemini Earn was not a security under federal law. Gemini's attorneys contended that the SEC had no legal basis for labeling the loan agreements as securities, asserting that no actual sale or offer of securities had occurred. The firms further criticized the SEC's enforcement approach, claiming the regulator had failed to establish how the Gemini Earn agreements constituted a securities transaction under existing case law. The move to dismiss signaled a more significant industry battle over how crypto lending and staking programs should be classified under U.S. financial regulations. By March 19, 2024, Genesis settled with the SEC, agreeing to pay a $21 million penalty while simultaneously resolving its bankruptcy case. The settlement included a permanent injunction against Genesis, barring it from engaging in future unregistered securities offerings. However, in a key concession, the SEC agreed it would not collect the penalty until Genesis completed all other creditor repayments, including returning funds to retail investors impacted by Gemini Earn. SEC Chair Gary Gensler framed the settlement as part of the agency's broader strategy to enforce securities laws in crypto lending markets, emphasizing that compliance was not optional, it's the law. The agreement reinforced the SEC's growing crackdown on lending programs that promised high-yield returns without the regulatory safeguards required for traditional investment products. The SEC's lawsuit and subsequent settlement with Genesis marked a turning point in regulatory oversight of crypto lending. The case highlighted how firms like Genesis and Gemini had operated without clear legal frameworks, exposing investors to substantial financial risks. It also underscored the limitations of the current regulatory system, where legal uncertainty allowed companies to grow unchecked before enforcement actions arrived only after financial collapses occurred. The regulatory battle over Gemini Earn became a case study in crypto's legal gray areas, shaping how future lending and staking products would be structured. As Genesis wound down its operations, its legal entanglements with the SEC, Gemini, and DCG left a lasting imprint on the industry, reinforcing the need for greater transparency, regulatory clarity, and investor protections in the evolving world of digital finance. NYAG. On October 19, 2023, New York Attorney General Letitia James filed a sweeping lawsuit against Genesis Global Capital, its parent company, Digital Currency Group, DCG, and Gemini Trust Company. The complaint accused the firms of defrauding more than 230,000 investors, including 29,000 in New York, by concealing massive financial losses and misrepresenting the risks of the Gemini Earn program. The investigation found that Genesis, under former CEO Soichiro Moro, and DCG, led by CEO Barry Silbert, schemed to hide more than $1.1 billion in losses after major borrowers defaulted, including Three Arrows Capital, 3AC, and Babel Finance. Gemini, meanwhile, falsely marketed Genesis as a trusted, low-risk partner, despite internal warnings labeling the firm's financial condition as precarious. By 2022, Genesis had been internally downgraded to junk grade, but Gemini never informed investors. The lawsuit detailed heartbreaking stories of financial devastation. One 73-year-old grandmother from New York invested $199,000 of her family's savings in Gemini Earn, trusting Gemini's safety assurances. She had hoped to use the money for her grandchild's education but lost it all when Genesis froze withdrawals in November 2022. Another New Yorker, a 56-year-old man, lost $20,500, virtually all of his savings, after being convinced that Gemini Earn was safer than other crypto investments. The Office of the Attorney General, OAG, found that Gemini executives were fully aware of the risks, even discussing internally whether to terminate the EARN program due to Genesys's worsening condition. By July 2022, Gemini's board compared Genesys to Lehman Brothers before its collapse, and Gemini risk personnel quietly withdrew their investments from EARN. Despite these internal warnings, Gemini continued promoting EARN as a low-risk product. The lawsuit also exposed a series of false and misleading statements from Genesys and DCG executives aimed at hiding the firm's financial collapse. After 3AC defaulted on billions in loans in June 2022, Genesys suffered catastrophic losses, compounded by another $100 million loss from Babel Finance. DCG issued a $1.1 billion promissory note to Genesys to mask these losses, payable over 10 years at just 1% interest. According to the OAG, this note was part of a scheme to portray Genesys as solvent and capable of meeting obligations falsely. Genesys misclassified the promissory note as a current asset on its balance sheet, despite its 10-year maturity, misleading investors and counterparties. Internal chats revealed that Genesys's CFO directed staff to withhold critical footnotes explaining the note's impact, admitting privately that full disclosure would highlight what happened. Publicly, however, Genesys and DCG maintained that Genesys was financially stable. 2 days after 3AC's default, the companies tweeted, "Despite continued heightened market volatility, the Genesys balance sheet is strong and our business is operating normally." Throughout 2022, Genesys provided misleading reports to Gemini, falsely inflating the value of its current assets. These reports allowed Gemini to continue accepting new investments into the EARN program, even as Genesys teetered on the edge of collapse. The OAG's investigation found that Genesys had not received audited financial statements from 3AC for more than 2 years, contrary to its claims of rigorous borrower due diligence. By November 2022, Genesys halted all EARN withdrawals, freezing $900 million in assets from 340,000 investors. The lawsuit charged that this outcome was not the result of unforeseen market volatility, as the companies claimed, but deliberate deception and reckless financial mismanagement. The Attorney General sought to ban Genesys, Gemini, and DCG from operating in New York's financial markets and demanded restitution for defrauded investors. The legal and financial fallout culminated in May 2024, when the U.S. Bankruptcy Court approved Genesys's amended plan of reorganization and a settlement worth up to $2 billion secured by the New York Attorney General. The settlement aimed to recover funds for defrauded investors, though actual distributions remained uncertain due to Genesys's complex bankruptcy proceedings. Genesys agreed to cease all business related to securities and commodities in New York. Observers described the settlement as a rare victory for retail investors, but tensions between creditors, DCG, and regulatory agencies continued. DCG's missed $630 million loan payment to Genesys in May 2023 had raised further concerns about its financial stability, delaying the bankruptcy's resolution. Chapter 5: Celsius. Celsius's rise. In 2018, Alex Mashinsky founded Celsius with an ambitious vision to disrupt traditional finance by offering an alternative where crypto investors could achieve financial freedom and economic opportunity. Branding itself as a mission-driven company, Celsius sought to appeal to retail investors disillusioned with conventional banking systems. The company's marketing was infused with grandiose promises, portraying itself as a force for economic equality. In a blog post, Celsius proclaimed, "Can we really bring unprecedented financial freedom, economic opportunity, and income equality to everyone in the world? We are Celsius. We dream big." The rhetoric was compelling, and for a time, the numbers suggested that the dream was becoming a reality. Celsius's early success was driven by strategic investments from influential figures in the crypto industry. In October 2017, Arrington XRP Capital led a $5 million pre-seed funding round, enabling Celsius to begin developing its lending platform. This initial investment gave the company the resources to build its infrastructure and refine its business model. In January 2018, billionaire crypto investor Mike Novogratz's firm spearheaded a $20 million Series A funding round, which helped Celsius launch its high-yield earned interest program. The company positioned itself as a bank-like entity for digital assets, promising depositors high returns while offering borrowers low-interest crypto-backed loans. These funds laid the foundation for Celsius's rapid expansion and the eventual rise of its CEL token ecosystem. Mashinsky was more than just the company's founder. He was its face and chief promoter. He took to social media, live television, and podcasts to pitch Celsius as a game-changing alternative to banks, regularly engaging with retail investors and reinforcing the narrative that Celsius was a safer, more rewarding place for their crypto assets. Internally, he maintained a tight grip on decision-making, participating in nearly every business committee, including the Risk Committee, Investment Committee, and Deployment Committee. His influence extended to strategic and operational matters, ensuring his vision dictated the company's trajectory. For investors and depositors, this direct engagement by Celsius's CEO projected confidence and control, qualities that would come under scrutiny when the company's risk management practices were questioned. The company's growth in its first few years was nothing short of meteoric. From its modest beginnings in 2018, Celsius expanded its workforce from a handful of employees to roughly 900 by 2022. Its assets under management ballooned from $49.8 million in 2018 to a staggering amount, $28.6 billion by November 2021, marking one of the most aggressive ascents in the crypto lending space. By March 2022, Celsius boasted approximately 285,000 active users who entrusted their digital assets to the platform. The company had also expanded geographically, initially incorporating in London before relocating its headquarters to Hoboken, New Jersey, as part of its broader push into U.S. markets. This move reflected Celsius's growing ambitions and the need to navigate the evolving regulatory landscape in the United States. By May 2022, Celsius had facilitated $8 billion in loans and managed nearly $12 billion in customer assets, making it one of the most prominent players in the crypto lending market. The company's business model appeared robust. Depositors earned interest by staking their cryptocurrencies, while borrowers could access low-interest loans using their crypto holdings as collateral. Celsius generated revenue from lending, discretionary trading, and even Bitcoin mining while claiming to return up to 80% of its earnings to its community. It did not charge fees, reinforcing the idea that it was fundamentally different from traditional banks. But behind the scenes, the sustainability of its high-yield model was already under pressure, and the cracks in its foundation would soon begin to show. From its inception, Celsius relied on its proprietary CEL token as a key financial instrument, intertwining its business model with the token's performance. In March 2018, Celsius conducted an initial coin offering, selling CEL at $0.3 per token with a fundraising cap of $50 million. The ICO was marketed as an opportunity for early investors to benefit from Celsius's projected growth, with founder Alex Mashinsky describing CEL as the backbone of the Celsius network. The token's value, he explained, would rise in tandem with Celsius's success, incentivizing both retail and institutional investors to buy in early. This strategy mirrored the speculative frenzy that had defined the ICO boom of the late 2000s and 10s, where companies sought to bypass traditional fundraising routes in favor of blockchain-based capital raises. Unlike conventional securities, CEL tokens were fungible, meaning that investors were not allocated individually managed accounts but held identical assets whose price fluctuated collectively. Celsius promised significant utility for CEL holders, offering reduced loan interest rates for borrowers who used CEL as repayment and higher interest earnings for depositors who accepted CEL as their yield. The token was initially sold through Celsius's over-the-counter OTC desk for accredited U.S. investors, with trading later expanding to secondary crypto exchanges. Celsius's internal policies acknowledged CEL's status as a security, requiring that U.S. purchases via OTC remain locked for a year post-settlement. This acknowledgement, however, did not translate into regulatory compliance. Celsius never registered its ICO or the Earn Interest program with the SEC, a decision that would later become a significant legal liability. Mashinsky actively promoted CEL as a measure of Celsius's financial health, a claim that aligned the token's performance with investor sentiment about the company itself. The token price goes up. Our entire compensation is the token, he explained in a March 2018 livestream event. So our job is to do everything we can to increase the price of the token as long as it's in the best interest of the community. By explicitly tying Celsius's fate to CEL's value, Mashinsky fueled investor expectations that holding CEL was equivalent to holding a stake in the company's future success. Celsius's leadership, including Mashinsky himself, received substantial allocations of CEL as part of their compensation, with over 100 million CEL distributed among company founders and executives. At its peak in June 2021, CEL reached a high of $8.02 per token, an astronomical increase from its all-time low of 3 cents in January 2019. Celsius executives capitalized on this surge, frequently publicizing CEL's price gains as evidence of the platform's growing dominance. On Twitter, Mashinsky celebrated percentage increases, linked to performance charts, and emphasized Celsius's role in creating a profitable asset. In one tweet from June 2020, he boasted that CEL had surged by 364% over 3 months, while in December 2021, he highlighted a 15% rally following an industry award for Celsius. The message was clear: CEL was an asset worth holding, and those who stuck with it would be rewarded. Celsius's Earn Interest program operated alongside the CEL token, reinforcing the platform's appeal to retail investors. Celsius offered interest rates as high as 17% for depositors who lent their crypto assets to the company, claiming that up to 80% of its profits were returned to users. Unlike traditional savings accounts, these interest payments were issued in cryptocurrency, including CEL, further embedding the token within Celsius's financial ecosystem. Investors were encouraged to HODL their CEL, a term borrowed from early Bitcoin culture meaning hold on for dear life. At the same time, Celsius suggested that the token's value would continue to appreciate. Promotional language frequently invoked the phrase "to the moon," referencing astronomical price gains that mirrored speculative crypto optimism. Internally, Celsius retained substantial control over CEL's market supply and distribution. The company held over half the total CEL supply within its corporate treasury, making it the largest single holder of the token. Mashinsky personally owned the second-largest share, ensuring that both Celsius and its CEO had vested interests in maintaining the token's price stability. The company pooled proceeds from CEL sales, using the funds for infrastructure development, operational costs, and other internal expenses. This self-reinforcing cycle, where Celsius's financial health depended on CEL and CEL's value depended on Celsius, created an inherently fragile structure. If CEL's price faltered, so too would Celsius's ability to maintain its promises of high yields and token appreciation. Celsius's aggressive promotion of CEL as a profitable investment placed it in murky regulatory waters. While traditional securities offerings require registration with financial regulators, Celsius never filed a registration statement for CEL sales or the Earn Interest program. The company also did not qualify for an exemption under U.S. securities laws, raising concerns that it had been selling unregistered securities to retail investors. Mashinsky and Celsius executives, however, downplayed these risks, focusing instead on driving CEL adoption and expanding the platform's user base. As long as new investors continued to buy in, the cycle remained intact. But any disruption to confidence in Celsius or the broader crypto market could trigger a collapse. Earn. From its launch in June 2018, Celsius promoted its Earn Interest program as a groundbreaking way for retail investors to earn passive income on their cryptocurrency holdings. The program operated like a high-yield savings account, offering interest payments as high as 17% annually on deposited assets such as Bitcoin, Ethereum, and stablecoins. Unlike traditional banking products, Celsius marketed its service as frictionless and decentralized, free from the constraints of legacy financial institutions. Alex Mashinsky, Celsius's charismatic founder, personally championed the platform, describing it as a way to unbank yourself and earn superior returns. "You don't have to do anything," he reassured investors. "You put the assets in, and every Monday you get yield in your account." Celsius's appeal lay in its simplicity and accessibility. The company's mobile app, launched alongside the Earn Interest program, allowed users to deposit their crypto assets with just a few clicks. Once transferred, these assets were pooled together and managed at Celsius's discretion. According to its terms of use, customer deposits became the property of Celsius, which could lend, invest, or trade them as it saw fit. This structure allowed Celsius to generate revenue while ensuring a steady flow of funds to sustain interest payments. Celsius claimed it returned up to 80% of its lending revenue to depositors, reinforcing the image of a user-first financial ecosystem. In 2019, Celsius introduced an additional incentive to deepen user engagement. It allowed depositors to receive their interest payments in CEL, the company's native token. Those who opted into this system earned higher yields, increasing CEL's adoption. The move tied Celsius's financial health to the success of its token, which saw significant price appreciation as more users embraced the platform. Celsius actively bought CEL on the open market to sustain these payouts, creating a feedback loop where its buying activity helped drive demand. This strategy boosted investor confidence, as CEL's rising price reinforced the perception of Celsius as a thriving, profitable enterprise. Investor enthusiasm propelled Celsius to new heights, attracting institutional and retail funding. In 2020, the company completed a $24 million Project $1 million equity round, valuing itself at $140 million. Investors saw Celsius as a high-growth startup poised to reshape the financial landscape, and its ability to onboard hundreds of thousands of users added to its credibility. At the same time, Celsius's user base expanded rapidly, drawn by its marketing message of financial empowerment and community-driven success. By early 2021, the platform boasted over 1 million registered users, managing billions of dollars in assets. Celsius's expansion strategy emphasized accessibility and mass adoption. The company aggressively marketed itself through online advertising, email campaigns, and social media engagement. It targeted retail investors frustrated with traditional finance, presenting itself as a superior alternative to banks. Promotional materials framed Celsius as a way to pour yourself a cup of profits and put profits in your pocket, reinforcing its appeal as a passive income generator. Combining high-yield promises, a seamless user experience, and strong community engagement helped Celsius differentiate itself. To further solidify its image as a user-centric platform, Celsius turned to equity crowdfunding. In 2021, the company raised $20 million from retail investors, allowing everyday users to buy shares in the business. This move reinforced the idea that Celsius was built for and by its community, enhancing its grassroots appeal. The campaign attracted thousands of new investors who saw Celsius not just as a service provider but as a movement they could be part of. This sense of ownership deepened customer loyalty and encouraged users to keep their funds on the platform, strengthening Celsius's financial position. Meanwhile, Mashinsky's influence continued to grow. He became one of the most visible figures in the crypto industry, frequently making media appearances to promote Celsius's vision. He positioned himself as an advocate for the average investor, often criticizing traditional banks and regulators for failing to serve the public. His messaging resonated with retail investors, who viewed him as a champion of financial inclusion. Mashinsky's direct engagement with Celsius's community made him indispensable to the company's brand, further fueling its rapid ascent. By mid-2021, Celsius had become one of the largest crypto lending platforms in the world. The company had over 1.7 million users, managed over $25 billion in assets, and facilitated billions in crypto-backed loans. Its rapid expansion fueled by aggressive marketing and strategic tokenomics, positioned it as a leader in the digital asset space. Celsius's rise was a testament to the power of community-driven finance, and for a time, it appeared to have redefined how crypto investors could earn and grow their wealth. By December 2020, Celsius had cemented itself as one of the largest crypto lending platforms, with $3.3 billion in user deposits. The company's rapid ascent was fueled by its aggressive marketing of high-yield returns, often far exceeding the rates offered by traditional banks. Retail investors, drawn to the promise of passive income, flocked to the Earn Interest program, depositing their Bitcoin, Ethereum, and stablecoins in exchange for weekly interest payments. Institutional players also took notice, lending credibility to Celsius's model and providing the company with large-scale loans to support its growing operations. The combination of retail enthusiasm and institutional backing created a cycle of expansion that reinforced Celsius's position as a dominant force in the crypto lending sector. By early 2021, Celsius had grown to manage $4.5 billion in assets, further solidifying its role as a major player in decentralized finance. The Earn Interest program continued to attract new deposits, while Celsius leveraged its expanding balance sheet to take on more institutional debt, increasing its ability to lend and invest. However, this rapid growth came with heightened risk exposure, as Celsius adopted increasingly leveraged strategies to maintain its high yields. With each new deposit, the company had to find new ways to generate returns, pushing it deeper into speculative trading and lending practices. Despite these underlying risks, Celsius's outward image remained strong, and its user base continued to expand. A crucial factor in Celsius's rise was the soaring price of its native CEL token, which reached an all-time high of $8.02 in mid-2021. The token's value was partly driven by Celsius's buyback strategy, where the company regularly purchased CEL to pay out interest to users. Additionally, promotional campaigns encouraged users to lock up their CEL holdings, reducing supply and further inflating demand. With Bitcoin and Ethereum reaching record highs, a bullish crypto market added further momentum to CEL's price surge. However, this price appreciation was not organic. It was deeply intertwined with Celsius's financial engineering. When market conditions shifted, CEL's price plummeted, exposing the fragility of the company's business model and the unsustainable nature of its token-backed growth, loans. By late 2021, Celsius had transformed from a niche crypto lender into one of the most influential players in decentralized finance. The company's rapid expansion was fueled by an aggressive strategy of securing institutional backing and leveraging borrowed capital. In October 2021, Celsius obtained a $1 billion loan from Tether, the issuer of the USDT stablecoin, using Bitcoin as collateral. This injection of funds allowed Celsius to scale its lending operations further, offering increasingly high yields to depositors while expanding its risk exposure. The move reflected Celsius's confidence in its business model, but it also tied the company's financial stability to Bitcoin's price fluctuations, making it vulnerable to market downturns. Institutional investors saw Celsius as a rising force in crypto finance, lending it credibility in the broader financial sector. In October 2021, the company raised $400 million in equity funding, led by Westcap and the Caisse de dépôt et placement du Québec, CDPQ, Canada's second-largest pension fund. This investment valued Celsius at $3 billion, reinforcing its status as a major player in the industry. Mashinsky framed the capital raise as a turning point, stating that it would help Celsius expand and legitimize crypto lending. The backing of a major pension fund signaled to retail investors that Celsius was more than just another high-risk crypto startup. It was a company with serious institutional support. Flush with investor interest, Celsius expanded its Series B funding round in November 2021, increasing the total raise to $750 million. The company boasted that strong demand from institutional investors validated its model and long-term sustainability. Behind the scenes, however, Celsius was becoming increasingly over-leveraged. The aggressive push for growth masked a growing dependence on borrowed capital and volatile assets, exposing Celsius to liquidity risks. While Mashinsky publicly projected confidence, internal cracks formed. Seeking to diversify beyond lending, Celsius made strategic acquisitions to bolster its security infrastructure. In November 2021, the company purchased Israeli cybersecurity firm GK8 for $115 million. The acquisition reflected Celsius's ambitions to expand into digital asset custody, a market that required institutional-grade security and regulatory compliance. In addition to lending and custody services, Celsius ventured into Bitcoin mining as a new revenue stream. The company invested heavily in mining equipment and infrastructure, betting that Bitcoin's long-term value appreciation would offset the high costs of mining operations. While this strategy aligned with the broader trend of crypto firms diversifying their revenue sources, it required significant capital expenditure and exposed Celsius to the volatility of Bitcoin mining profitability. With Bitcoin's price soaring to new highs in late 2021, the mining initiative seemed promising. However, as with many of Celsius's ventures, it depended on sustained market momentum. By December 2021, Celsius had reached the peak of its dominance, managing $26 billion in assets and distributing over $1 billion in interest payments to depositors. The company's meteoric rise was driven by its promise of high-yield, passive income and its ability to attract retail and institutional capital. The user base had swelled to over 1.7 million customers, many of whom were drawn in by Celsius's aggressive marketing campaigns. The company's mantra of financial freedom resonated with investors looking for alternatives to traditional banking. Few, however, fully understood the underlying risks of Celsius's lending practices. At its height, Celsius had issued over $8 billion in loans and managed $12 billion in assets, making it one of the largest lenders in the crypto industry. Its success was built on the assumption that digital asset prices would continue to rise and that the company's liquidity would remain intact. But behind the scenes, Celsius had significant exposure to unsecured loans, leveraged positions, and a volatile crypto market. Its financial model depended on continuous user deposits to sustain yields, creating a structure that required constant growth to remain viable. As 2022 approached, the crypto market began showing signs of stress, and the first cracks in Celsius's model started to appear. The collapse of Terra's Luna ecosystem and the subsequent failure of hedge fund Three Arrows. Capital 3AC sent shockwaves through the industry. Investors rushed to withdraw their funds, triggering a liquidity crisis for Celsius. In June 2022, the company froze all withdrawals, swaps, and transfers, citing extreme market conditions. This move shattered user confidence and triggered a chain reaction of regulatory investigations and lawsuits, marking the beginning of Celsius's dramatic fall from grace. Celsius's fall. The broader crypto market crash in May 2022 triggered a chain reaction that accelerated Celsius's downfall. The collapse of UST and Luna sent shockwaves through the industry, triggering mass withdrawals across crypto lending platforms. Celsius, which had significant exposure to high-risk DeFi investments tied to Terra, suffered undisclosed losses. And as panic spread, users rushed to withdraw their funds, fearing that Celsius would be the next casualty. Internally, alarm bells were ringing. By May 2022, key employees openly questioned the firm's financial health. Dean Tappan, Celsius's coin deployment specialist, described the company's operations as very Ponzi-like in private communications. On Slack, Celsius's chief financial officer expressed deep concerns, admitting that if customers ever found out how Celsius was using their deposits to prop up the price of its CEL token, it would be a very, very bad look. The firm had been engaging in hundreds of millions of dollars worth of CEL buybacks, artificially inflating the token's price. At the same time, executives, including Mashinsky and co-founder Daniel Leon, quietly offloaded their personal holdings. Publicly, however, Celsius continued to project confidence, dismissing any liquidity concerns. Despite mounting internal turmoil, Celsius attempted to reassure investors. On June 7, 2022, the company published a blog post titled "Damn the Torpedoes, Full Speed Ahead," ridiculing rumors about its financial instability. Mashinsky, in one of his weekly YouTube Ask Mashinsky Anything (AMA) sessions, dismissed critics as fearmongers spreading misinformation. He insisted that Celsius had billions in liquidity and that customer funds were safe. At the same time, internal records showed that Celsius was on the brink of insolvency. The company was scrambling to plug a widening hole in its balance sheet while simultaneously trying to stop a mass exodus of funds from its platform. Mashinsky's reassurances proved to be an outright deception. While he publicly insisted that customer withdrawals were safe, he privately withdrew his funds from the platform. Within weeks, Celsius's liquidity crisis became undeniable. On June 12, 2022, the company suddenly froze all withdrawals, swaps, and transfers, citing extreme market conditions. Overnight, billions of dollars in user deposits were locked. Bitcoin and Ethereum prices tumbled by over 10%, exacerbating an already volatile market. Celsius's own CEL token collapsed, losing 50% of its value within hours. Crypto markets as a whole dipped below a $1 trillion market cap for the first time since January 2021, sending shockwaves through the industry. For Celsius's customers, the announcement was devastating. Many had entrusted their life savings to the platform, believing Mashinsky's repeated assurances that Celsius was a safer, better alternative to banks. Now, they found themselves unable to access their own funds, with no clear answers on when or if withdrawals would resume. Furious depositors flooded social media, demanding explanations and legal action. Meanwhile, Celsius's executive team framed the decision as a temporary measure necessary to stabilize operations, though internal documents painted a different picture. The company had a $1.2 billion hole in its balance sheet, caused by a mix of uncollateralized loans, failed DeFi bets, and excessive CEL buybacks. Bankruptcy. On July 13, 2022, Celsius officially filed for Chapter 11 bankruptcy in the U.S. Bankruptcy Court for the Southern District of New York. The filing revealed the extent of the financial disaster that had been unfolding behind the scenes. Celsius listed $5.5 billion in liabilities, with $4.7 billion owed to customers, who were classified as unsecured creditors. At the same time, its assets stood at just $4.3 billion, creating a gaping $1.2 billion shortfall. Internal documents disclosed that Celsius had used customer deposits to fund high-risk, leveraged investments, many of which had collapsed in the wake of the broader crypto market downturn. In court, Alex Mashinsky admitted the company had made poor asset deployment decisions, though he continued to blame market conditions rather than mismanagement for the firm's downfall. As the bankruptcy proceedings unfolded, the true human cost of Celsius's collapse became clear. Thousands of customers submitted letters to the bankruptcy judge, detailing how they had entrusted their life savings to the platform, believing Mashinsky's repeated assurances that their funds were safe. Many had lost everything. At the same time, Celsius fought to recover funds from other firms. In August 2022, the company sued its former custodian, Prime Trust, for withholding $17 million in digital assets. Prime Trust had severed ties with Celsius in June 2021, citing concerns about the company's risky rehypothecation practices, where customer deposits were being used to back Celsius's own financial maneuvers. Now, as Celsius customers remained locked out of their accounts, the company was attempting to claw back assets for itself. Public scrutiny intensified as the bankruptcy court ordered Celsius to disclose customer names, wallet addresses, and transaction details. On September 28, 2022, a judge ruled that this information must be made public, exposing massive individual losses. The revelations contradicted Celsius's past claims that user funds were safe and further fueled outrage among depositors. Privacy concerns also mounted as the release of financial records made customers vulnerable to potential scams and security threats. Crypto forensic platforms quickly analyzed the data, with CelsiusNetWorth.com tracking the losses, showing that the top 3 creditors alone had lost more than $40 million each. As lawsuits and investigations mounted, Mashinsky stepped down as CEO on September 27, 2022. His resignation did little to calm the chaos. Even after formally leaving the position, he continued to exert control over company decisions behind the scenes. Meanwhile, Celsius's board appointed Chris Ferraro, the company's head of financial planning, as interim CEO. Just days later, Chief Financial Officer Rod Bolger resigned as well, raising further concerns about financial mismanagement. The abrupt departures underscored the growing instability within Celsius as it faced regulatory scrutiny, civil lawsuits, and bankruptcy proceedings all at once. In December 2022, Celsius saw its first major legal setback. A U.S. bankruptcy judge ruled that the company must return $50 million to users who had deposited assets in its custody program. Unlike customers in the Earned Interest program, these depositors had not technically transferred ownership of their funds to Celsius. However, this ruling only accounted for a small fraction of Celsius's $4.7 billion in customer liabilities. Most users remained locked out of their accounts, waiting for clarity on whether they would recover their crypto holdings. That clarity arrived in a devastating ruling on January 4, 2023. Judge Martin Glenn ruled that Celsius legally owned all customer deposits in its Earned Interest program, meaning depositors were classified as unsecured creditors. The court found that Celsius's terms of use explicitly transferred ownership of crypto assets to the company once deposited, leaving customers with no legal claim to their funds. This ruling had far-reaching implications, not only for Celsius users but for the entire crypto lending industry. As Celsius navigated bankruptcy, its collapse highlighted the broader contagion within the crypto industry. In August 2023, Celsius settled bankruptcy claims with another fallen crypto giant, FTX, for $175 million. The two companies had been financially intertwined, and their bankruptcies underscored the risks of high-leverage, interconnected crypto businesses. The Celsius FTX settlement was a pivotal moment, demonstrating the extent to which the failure of one major player could ripple across the industry. After nearly 2 years in bankruptcy, Celsius finalized a $3 billion payout to creditors in January 2024. The settlement provided depositors with recovery rates between 67% and 85%, depending on asset type. While this marked a significant step forward, many customers still suffered heavy losses, especially those who had invested in Celsius's CEL token or relied on the platform as a primary savings vehicle. As part of the bankruptcy exit plan, Celsius launched Ionic Digital, a new Bitcoin mining company that would be partially owned by creditors. This was intended to generate long-term value for those who had been affected by Celsius's collapse. By August 2024, Celsius had returned $2.53 billion to over 250,000 users, claiming it had repaid 93% of creditor funds. However, legal battles continued, particularly against Mashinsky and other executives who faced lawsuits over their roles in the company's collapse. Even as Celsius attempted to move forward, the fallout from its implosion continued to shape regulatory discussions around crypto lending. Its rise and fall had exposed the weaknesses in the industry: unregulated financial structures, misleading marketing, and an over-reliance on speculative assets, all of which contributed to one of the most dramatic bankruptcies in crypto history. The Examiner's report, released in January 2023, revealed that Celsius's financial problems had not begun with the 2022 crypto market crash, as Mashinsky had claimed, but instead dated back to 2020. From that year forward, the company had been operating at a loss, propping up its business with customer deposits while engaging in increasingly risky financial maneuvers. Even during the 2021 bull market, when Bitcoin and Ethereum reached record highs, Celsius recorded an $811 million pre-tax loss. By mid-2021, the company had $2 billion in stablecoin liabilities, a significant BTC and ETH deficit, and no clear path to profitability. As Celsius struggled to maintain liquidity, Mashinsky and other top executives prioritized their own financial interests. While publicly insisting that he was not selling CEL, Celsius's native token, Mashinsky personally withdrew $68 million before the bankruptcy. Other executives followed suit. CTO Nuke Goldstein offloaded $2.8 million, while Chief Strategy Officer Daniel Leon cashed out $9.74 million. At the same time, Celsius was spending massive amounts of customer funds, $558 million in total, to buy back CL tokens, artificially inflating the price to maintain investor confidence. Internal messages revealed that executives knew their actions were illegal. In one Slack exchange, a Celsius employee bluntly stated, "We are using users' USDC to pay for employees' worthless CEL." The scheme Celsius employed to boost CEL's value was deliberate and calculated. The company placed resting orders to buy CEL anytime its price dropped below a certain threshold, ensuring stability while secretly selling tokens in over-the-counter (OTC) transactions. This so-called OTC flywheel allowed Celsius insiders to profit while maintaining an illusion of demand. At the same time, Celsius took out loans using BTC and ETH deposits from customers, leveraging those assets to fund its own operational expenses. When the crypto market crashed in May 2022, the company scrambled to liquidate BTC and ETH holdings to meet withdrawal requests, but by then, it was too late. Celsius had overextended itself and could not cover its debts. Despite these internal problems, Mashinsky sought to double down on risky partnerships. In January 2022, he traveled to the Bahamas to meet with FTX founder Sam Bankman-Fried and Alameda Research CEO Caroline Ellison. According to the Examiner's report, Mashinsky initially claimed he was distrustful of FTX, but Celsius's chief credit officer, Brian Strauss, recalled that Mashinsky returned from the trip wanting to deepen the company's exposure. By April 2022, Celsius had borrowed $1.5 billion in stablecoins from FTX and held over $2.5 billion in assets on the exchange, placing itself at enormous risk. In the months leading up to the collapse, Celsius executives worked tirelessly to mislead the public about the company's financial health. On June 7, 2022, just days before freezing withdrawals, the company published a blog post titled, "Damn the Torpedoes, Full Speed Ahead." The post dismissed growing rumors of financial instability as misinformation spread by vocal actors. 3 days later, during his weekly YouTube AMA, Mashinsky explicitly denied that Celsius had liquidity problems, telling customers, "Celsius has billions in liquidity, and we provide immediate access to everybody." But in reality, withdrawals had already outpaced deposits, and the company was burning through what little liquidity remained. Reckoning Day arrived on June 13, 2022, when Celsius paused all withdrawals, swaps, and transfers, citing extreme market conditions. This announcement triggered a 12% drop in Bitcoin and a 14% drop in Ethereum, dragging the entire crypto market below $1 trillion in total market capitalization for the first time since early 2021. Celsius's own CEL token plummeted by 33%, falling to 21 cents, a far cry from its $7 peak the previous year. When Celsius officially filed for bankruptcy on July 13, 2022, it confirmed a $1.2 billion hole in its balance sheet. The company had just $167 million in cash on hand, a fraction of the $5.5 billion in liabilities it owed. Of that total, $4.7 billion belonged to retail investors, who were listed as unsecured creditors, a designation that meant they were last in line for any repayment. Court filings revealed that Celsius had used customer deposits to fund its own high-risk trading strategies, violating its stated mission of acting in the best interests of its community. Mashinsky resigned as CEO on September 27, 2022. The bankruptcy court ordered Celsius to publish its customer lists, exposing the scale of individual losses. Forensic investigations revealed that the company's top 3 creditors had lost $40 million, $38 million, and $26 million, respectively. Meanwhile, thousands of retail investors, many of whom had stored their life savings on Celsius, remained locked out of their accounts, unable to access their funds. In December 2022, Celsius was ordered to return $50 million to users who had funds in its custody accounts. A small victory for some, but one that did not extend to the 600,000 customers in the EARN program. In a January 4, 2023 ruling, a bankruptcy judge determined that deposits in Celsius's EARN program legally belonged to Celsius, not the customers. The ruling, based on the company's terms of use, meant that customers were unsecured creditors with no claim to their digital assets. The decision sent shockwaves through the crypto industry, reinforcing that crypto lending platforms do not operate like banks, and that deposits were never truly guaranteed. As Celsius's bankruptcy case dragged on, the contagion spread to other firms. In August 2023, Celsius struck a $175 million bankruptcy settlement with FTX, a company that was itself in the midst of financial collapse. The two firms had been deeply intertwined, underscoring how interconnected the crypto industry had become. The settlement further complicated Celsius's restructuring process, but it also marked the beginning of its efforts to return funds to creditors. In January 2024, Celsius officially exited bankruptcy, announcing a $3 billion repayment plan. Customers were expected to recover between 67% and 85% of their holdings, with 98% of creditors approving the reorganization plan. As part of the restructuring, Celsius created Ionic Digital Inc., a Bitcoin mining company in which creditors would hold equity. The company planned to go public, offering long-term compensation to those who had suffered losses. By August 2024, Celsius had returned $2.53 billion to 251,000 customers, marking a significant step toward resolution. However, the damage had already been done. The bankruptcy exposed the fragility and deception within crypto lending, showing that even platforms promising financial freedom were in reality deeply flawed, unregulated financial experiments. NYAG. On January 5, 2023, New York Attorney General Letitia James filed a civil lawsuit against Alex Mashinsky, accusing him of defrauding investors through false and misleading statements about Celsius's safety and financial stability. The lawsuit, filed in the New York State Supreme Court, alleged that Mashinsky had lured hundreds of thousands of investors, including 26,000 New Yorkers, into depositing billions of dollars in digital assets onto Celsius under false pretenses. While Celsius was secretly suffering massive losses from high-risk investments, Mashinsky continued to claim that the platform was a low-risk alternative to traditional banks. The lawsuit sought damages, restitution, and disgorgement of Mashinsky's personal gains, as well as a permanent ban on his involvement in securities and commodities businesses in New York. Throughout Celsius's meteoric rise, Mashinsky had been its most visible public figure, appearing in interviews, at conferences, and on social media to promote the company. His messaging was clear. Celsius was safer than a bank, a reliable place to earn yield, and an institution built for financial freedom. However, unlike traditional banks, Celsius was not regulated, nor did it offer any deposit protections. The lawsuit alleged that Mashinsky had deliberately misled investors by downplaying Celsius's risks and overstating its financial health, even as the company spiraled toward insolvency. He continued to assure depositors that their funds were safe, even while using their assets to cover massive losses. In reality, Celsius's investment strategies were anything but safe. The company routinely lent assets to high-risk counterparties and engaged in speculative DeFi trading strategies, which often resulted in catastrophic losses. The lawsuit pointed to numerous deceptive statements, in which Mashinsky assured investors that Celsius only worked with reputable borrowers and maintained a secure and sustainable business model. Behind the scenes, however, Celsius was hemorrhaging money, covering its deficits by misusing customer funds to inflate the price of its native token, CEL. Investors were unknowingly financing Celsius's survival, unaware of the magnitude of the risks they faced. The collapse of Celsius had devastating consequences for everyday investors, many of whom lost their life savings. The New York Attorney General's lawsuit highlighted multiple victims, including a New Yorker who mortgaged 2 properties to invest with Celsius, a disabled veteran who lost $36,000 that had taken him nearly a decade to save, and a low-income worker who lost his entire investment while earning just $8 per hour. These stories underscored the real human cost of Mashinsky's deception. Celsius's failure was not just a financial collapse, but a personal catastrophe for thousands of people who had believed in its promises. The lawsuit also revealed that Mashinsky had failed to register as a salesperson for Celsius, as well as a securities and commodities dealer, adding to the legal violations. Attorney General James made clear that New York intended to hold him accountable. As the former CEO of Celsius, Alex Mashinsky promised to lead investors to financial freedom, but led them down a path of financial ruin, she stated. The law is clear that making false and unsubstantiated promises and misleading investors is illegal. New York's enforcement efforts were part of a broader crackdown on crypto fraud, with James's office having previously sued Nexo, reached settlements with BlockFi, and warned about the risks of unregistered crypto lending platforms. Legal pressure mounted throughout 2023, culminating in a significant expansion of the lawsuit in October 2023. The revised complaint named additional Celsius executives, including Chief Revenue Officer Ronnie Cohen-Pavin and co-founders Daniel Leon and Nuke Goldstein, accusing them of participating in market manipulation and investor deception. The lawsuit detailed how Celsius's leadership had lied about the company's financial health, falsely claimed to have insurance protections for customer assets, and deliberately withheld information about massive losses. These revelations deepened the legal risks for Celsius's top executives, exposing them to civil and potentially criminal liability. The allegations of market manipulation were particularly damning. According to the expanded lawsuit, Celsius had falsely portrayed itself as a profitable, stable company while secretly propping up the price of CEL through manipulative trading strategies. Executives knowingly misled investors about the true demand for CEL, creating a false sense of security. These tactics ensured that insiders, including Mashinsky, could cash out their holdings at inflated prices, all while telling retail investors to hodl and buy more CEL. The lawsuit described this behavior as a systematic deception designed to enrich Celsius's leadership at the expense of its users, FTC. On July 13, 2023, the Federal Trade Commission, FTC, announced a landmark $4.7 billion settlement with Celsius, permanently banning the company from handling cryptocurrency, customer funds, or engaging in any financial services. The settlement, one of the largest in FTC history, underscored the massive scale of fraud that had occurred within Celsius's operations. At the same time, the FTC filed charges against former CEO Alex Mashinsky and co-founders Daniel Leon and Nuke Goldstein, accusing them of systematically deceiving customers into depositing their crypto assets while misusing billions of dollars in user funds. Unlike Celsius, these executives refused to settle, setting the stage for a legal battle in federal court. Celsius had built its business on the premise of financial security, repeatedly marketing itself as a safer alternative to banks. In public statements, Mashinsky assured customers that Celsius had less risk than traditional financial institutions, claiming that deposits were insured and that the company maintained sufficient reserves to meet all customer withdrawals. The FTC's investigation revealed that these statements were blatant lies. Celsius had no meaningful insurance policy, no ability to cover withdrawals, and a massive liquidity crisis hidden from customers until the final moments before bankruptcy. According to the FTC's complaint, Celsius executives had engaged in wide-scale deception, enticing customers with false promises of high-yield interest rates that were never sustainable. Celsius advertised interest rates as high as 18% APY, claiming that users could withdraw their funds anytime. However, the company routinely failed to deliver these promised returns, with only those enrolled in a loyalty program tied to CEL receiving the best rates. Many customers were unaware that the company's financial model depended on attracting new deposits to pay existing users, a practice eerily similar to Ponzi schemes. Celsius's gross mismanagement of customer deposits was at the heart of the FTC's case. Rather than keeping assets safe, Celsius took ownership of user funds, using them to cover operating expenses, reward earlier investors, borrow from institutions, and engage in risky, speculative investments. By April 2022, the company had issued $1.2 billion in unsecured loans, making it impossible to cover large-scale withdrawals. Shockingly, Celsius had no formal system to track its assets and liabilities until mid-2021, meaning that even its executives had limited visibility into the company's financial health. As Celsius's financial situation deteriorated in 2022, Mashinsky and his executives worked to conceal the crisis from the public. In May 2022, just weeks before the company froze withdrawals, Mashinsky falsely claimed in an online video that Celsius is stronger than ever, we have billions of dollars in liquidity. Days before blocking user accounts, Celsius publicly assured customers that it had more than enough assets to meet all obligations. These statements gave customers false confidence, preventing them from withdrawing their funds before it was too late. While deceiving the public, Celsius's top executives quietly protected themselves. The FTC's complaint revealed that Mashinsky, Leon, and Goldstein withdrew significant amounts of cryptocurrency from Celsius 2 months before bankruptcy, ensuring their personal wealth was preserved while ordinary investors suffered devastating losses. Many Celsius customers had deposited life savings, college funds, and retirement money, believing in Mashinsky's assurances that their assets were safe. When withdrawals were finally frozen, thousands of users lost access to their money overnight, with no clear path to recovery. In addition to the ban on financial services, the FTC's settlement imposed strict prohibitions on Celsius's future operations. The company was barred from misrepresenting any financial product, obtaining customer financial information through deception, and sharing user data without explicit consent. While the $4.7 billion judgment was suspended to allow Celsius to return assets to customers through bankruptcy proceedings, the ruling marked a watershed moment in crypto regulation. It demonstrated that federal agencies were willing to take aggressive action against fraudulent platforms, setting a precedent for similar cases in the future. The legal battles were far from over for Mashinsky, Leon, and Goldstein. Unlike Celsius, they refused to settle with the FTC, leaving them vulnerable to civil lawsuits, regulatory penalties, and potential criminal charges. The FTC's case against them was set to continue in federal court, where prosecutors sought to hold them personally accountable for their roles in Celsius's fraudulent operations. As the legal system worked through the fallout, Celsius's implosion served as a stark warning about the risks of unregulated crypto lending, exposing that the industry's lack of oversight, reckless financial practices, and deep vulnerability to bad actors. SEC. On July 13, 2023, the Securities and Exchange Commission, SEC, formally charged Celsius Network Limited and its founder, Alex Mashinsky, with securities fraud, unregistered securities sales, and market manipulation. The lawsuit alleged that Celsius had misled investors about the company's financial health, making false claims about the safety of deposits and engaging in manipulative trading tactics to inflate the value of its native CEL token. The charges, brought under the Securities Act of 1933 and the Securities Exchange Act of 1934, marked a significant escalation in the regulatory crackdown on fraudulent crypto lending schemes. At the heart of the SEC's case was Celsius's Earn Interest program, which operated from 2018 until the company halted withdrawals in June 2022. Under this program, investors deposited their crypto assets in exchange for high-yield interest payments, which Celsius claimed were generated through low-risk lending and investment strategies. However, the SEC's complaint detailed how Celsius failed to register these offerings as securities, meaning that investors lacked the protections provided under federal securities laws. The agency asserted that no exemption from registration applied, making the entire program illegal from the outset. Beyond the unregistered securities violations, the SEC accused Celsius and Mashinsky of misleading investors about the company's financial stability. Publicly, Celsius had positioned itself as a safe and profitable platform. Mashinsky repeatedly claimed that the company only issued collateralized loans, avoided high-risk trading, and returned 80% of its revenue to customers. The SEC alleged that Celsius was engaged in risky, uncollateralized lending, could not consistently generate the revenue needed to meet its obligations, and frequently paid out far more than 80% of its earnings to sustain its interest payments. Internal documents revealed that Celsius executives knew the company was operating at a loss, yet they continued deceiving the public to attract new deposits. The SEC's complaint also exposed the extent of Celsius's financial mismanagement. According to the filing, Celsius had secretly incurred losses of more than $800 million in 2021 and an additional $165 million in early 2022, even as it reassured investors that it was thriving. The company falsely claimed that it had secured regulatory approvals, that customer funds were insured, and that it had sufficient reserves to cover withdrawals. Celsius had no insurance, no regulatory clearance, and a growing liquidity crisis hidden from the public. Perhaps the most damning revelation was the manipulation of CEL's market price. The SEC's investigation found that in 2020, Celsius engaged in fraudulent buybacks of CEL far beyond what it publicly disclosed. Mashinsky personally directed these purchases, ensuring they had maximum impact on CEL's price, which in turn created artificial demand and misled investors into believing CEL was a valuable, stable asset. While Mashinsky and Celsius orchestrated this scheme, both entities profited immensely, selling CEL at inflated prices while encouraging customers to buy and hold the token. The SEC characterized this practice as a coordinated effort to defraud the market and enrich Celsius insiders. Even as Celsius teetered on the edge of collapse in mid-2022, Mashinsky and other executives continued their deception. On May 21, 2022, an internal report circulated among Celsius executives warned that the company's business model was not financially sustainable and that it faced severe liquidity constraints. One employee described Celsius as a sinking ship, while another said, "There is no hope. There is no plan." Yet, instead of admitting the truth, Mashinsky continued making public assurances that Celsius was in excellent financial health. As late as June 10, 2022, just 2 days before Celsius froze withdrawals, Mashinsky sought to reassure customers by claiming that Celsius had billions in liquidity. At the same time, internal messages showed that the company knew it could not meet withdrawal demands. The SEC's complaint painted a picture of a company in crisis for months, but deliberately concealed its insolvency to keep depositors from withdrawing their funds. The SEC's lawsuit was one of several legal actions against Celsius and Mashinsky. The U.S. Attorney's Office for the Southern District of New York announced criminal charges against Mashinsky on the same day. At the same time, the Commodity Futures Trading Commission, CFTC, filed its own case, alleging violations of commodities laws. Celsius, meanwhile, agreed to a settlement with the SEC, consenting to a permanent injunction that barred it from violating securities laws in the future. The SEC sought severe penalties against Mashinsky, including a ban on serving as an officer or director of any public company and injunctions preventing him from participating in the crypto securities market. The agency also sought civil penalties, disgorgement of profits, and other monetary relief to compensate Celsius investors. The lawsuit was a clear signal that federal regulators were cracking down on deceptive crypto lending practices, ensuring that companies like Celsius could not operate in the shadows of financial law. The SEC's case reinforced a harsh reality for Celsius's victims. The company had not merely collapsed due to market conditions. It had deceived investors, manipulated its own token, and operated an illegal securities scheme for years. Celsius's failure was not just a business miscalculation, but a premeditated fraud that left thousands of retail investors with massive financial losses. The legal actions against Mashinsky and Celsius marked a turning point in crypto regulation, demonstrating that the era of unchecked high-risk crypto lending was coming to an end. DOJ on July 13, 2023, federal prosecutors unsealed an indictment against Alex Mashinsky, the founder and former CEO of Celsius Network, charging him with securities fraud, commodities fraud, and wire fraud. Alongside him, former Celsius Chief Revenue Officer Ronnie Cohen. Pavin was charged with market manipulation and conspiracy for their roles in artificially inflating the price of Celsius's proprietary token, CEL, while secretly selling their own holdings for millions in profits. The charges marked a turning point in the government's investigation into the collapse of Celsius. Mashinsky's arrest followed a year-long probe by the U.S. Attorney's Office for the Southern District of New York, the FBI, and the SEC, which collectively found that Celsius had been built on deception. The company had falsely advertised itself as the safest place for your crypto, promising high yields with low risk, all while misusing customer funds, manipulating its token price, and hiding massive financial losses. U.S. Attorney Damian Williams clarified that Mashinsky's crimes would not go unpunished. Whether it's old school fraud or some new school crypto scheme, it doesn't matter one bit. It's all fraud to us, and we'll be here to catch it. At the heart of the criminal case was the revelation that Mashinsky and Cohen-Pavon had used customer deposits to manipulate the price of CEL. According to internal messages uncovered by investigators, Celsius executives knew that CEL's market value was entirely artificial. Cohen-Pavon confessed to Mashinsky in one message. The issue is that people are selling CEL, and no one is buying except for us. The main problem was that the value was fake, and was based on us spending millions just to keep it where it is. This strategy allowed Mashinsky and other insiders to sell their own CEL holdings at inflated prices, reaping enormous profits while misleading investors. The indictment also exposed how Mashinsky had systematically lied about Celsius's financial health. Even as the company suffered hundreds of millions in losses, he continued to assure customers that Celsius was stronger than ever and had billions in liquidity to cover withdrawals. Behind the scenes, Celsius funneled user funds into high-risk investments, issued uncollateralized loans, and covered its losses by manipulating CEL's price. Prosecutors found that by early 2022, Celsius was a sinking ship, yet Mashinsky kept recruiting new investors to plug the financial hole. In the months leading up to Celsius's collapse, Mashinsky quietly withdrew $8 million worth of his personal holdings from the platform, ensuring that his finances were secured while retail investors were left stranded. When Celsius paused all withdrawals on June 12, 2022, customers were trapped, unable to access $4.7 billion in funds that Mashinsky had promised would always be available. A month later, Celsius filed for Chapter 11 bankruptcy, revealing a $1.2 billion deficit and confirming that the company had been insolvent long before its final days. The federal case against Mashinsky was one of the most significant criminal prosecutions in crypto history, signaling a new era of accountability for executives who misled investors. Unlike many past financial frauds, Celsius's victims were not large institutions or hedge funds. They were retail investors, everyday people who had entrusted their life savings to a platform they believed was safe. Prosecutors argued that Mashinsky had preyed on these investors, promising financial freedom while secretly orchestrating one of the largest frauds in the crypto industry. As the case progressed, Celsius reached a non-prosecution agreement with the government, agreeing to cooperate with prosecutors in exchange for leniency. The company acknowledged its role in the fraudulent schemes and agreed to help maximize victims' recovery through the bankruptcy process. While Celsius, as an entity, avoided criminal liability, its top executives, including Mashinsky and Cohen-Pavon, faced the full weight of the law. In December 2024, after months of legal proceedings, Mashinsky pleaded guilty to 2 counts of fraud: commodities fraud and securities fraud. In his plea agreement, he admitted to deceiving investors, manipulating CEL's price, and withdrawing funds before bankruptcy, effectively confirming the prosecution's case. As part of the agreement, he forfeited $48 million in profits from his illegal schemes, though this sum was only a fraction of the billions lost by Celsius customers. U.S. Attorney Damian Williams called Mashinsky's plea a historic victory for crypto fraud enforcement. Mashinsky lured ordinary retail investors into investing billions of dollars in Celsius with false promises that their investments were low risk. In reality, Celsius was never profitable. To disguise the flaws in his business model, Mashinsky put investors' money into riskier and riskier bets and secretly used customer money to prop up the price of CEL. The once powerful CEO, who had spent years marketing himself as a visionary leader in crypto finance, now faced a maximum prison sentence of 30 years. The case was nearing its final chapter with sentencing scheduled for April 8, 2025. Mashinsky's guilty plea set a precedent for future crypto fraud cases, demonstrating that even the most high-profile industry leaders could not escape justice. As regulators and law enforcement agencies continued their crackdown on fraudulent crypto platforms, Celsius remained one of the most striking examples of how unchecked greed and deception could lead to financial disaster. Chapter 6. BlockFi. BlockFi's rise. BlockFi emerged in October 2017 with an ambitious goal: to bring traditional credit services to the rapidly growing cryptocurrency market. Founded by Zach Prince and Flory Marquez, the startup sought to bridge the gap between digital assets and conventional finance by allowing clients to borrow US dollars against their Bitcoin and Ether holdings. Prince, who had a background in sales, envisioned a company that could transform how crypto investors accessed liquidity without selling their assets. Marquez, with experience managing financial portfolios at Bond Street before its acquisition by Goldman Sachs, brought operational expertise to the venture. Headquartered in Jersey City, New Jersey, BlockFi quickly gained traction, expanding to key financial hubs like New York, Singapore, Poland, and Argentina, as it positioned itself as a pioneer in crypto-backed lending. In early 2018, venture capital investors took notice. In February, BlockFi secured $1.55 million in seed funding from a consortium led by Consensus Ventures, a firm deeply entrenched in Ethereum's ecosystem. Other notable backers included SoFi and Kinetic Capital, signaling that fintech investors saw crypto lending as a promising frontier. At a time when the broader crypto market was soaring, Bitcoin had peaked near $20,000 in December 2017. BlockFi's model appealed to investors seeking exposure to the digital asset space without the volatility of direct coin ownership. The company marketed itself as a bridge between capital markets and crypto, leveraging institutional-grade risk management to provide loans while reporting client repayment data to major credit bureaus. As the year progressed, BlockFi's ambitions outpaced its modest beginnings. In July 2018, it raised $52.5 million in a funding round led by Mike Novogratz's Galaxy Digital, a firm known for aggressively backing blockchain ventures. The injection of capital allowed BlockFi to expand its product suite beyond collateralized loans, setting the stage for interest-bearing crypto savings accounts and credit cards linked to digital assets. The company reported $8.3 million in revenue that year, a sign that demand for its services was growing. With capital markets increasingly receptive to crypto-based financial products, BlockFi positioned itself as an institutional-grade lender, promising security and transparency in an industry still plagued by regulatory uncertainty. By the end of 2018, BlockFi's funding rounds had cemented its status as one of the fastest-growing startups in the crypto lending sector. In December, it secured another $4 million through a convertible debt round led by Acuna Capital, with continued backing from Novogratz's Galaxy Digital and Anthony Pompliano's Morgan Creek Digital. The firm's rapid capital raises reflected a broader trend in the industry. Investors were eager to deploy funds into companies that could introduce traditional financial mechanisms to crypto. BlockFi's executives emphasized their commitment to risk management and compliance, reassuring backers that they were building a sustainable lending model. Yet beneath the surface, the firm's aggressive expansion would expose it to the same risks that would topple many of its peers in the coming years. BlockFi's early years were defined by innovation, ambition, and venture capitalists' willingness to bet on the integration of digital assets with traditional finance. The firm capitalized on crypto's meteoric rise, securing significant funding rounds and launching products that allowed traders and long-term holders to leverage their crypto without selling. BIAS. On March 4, 2019, BlockFi launched its most ambitious product yet, the BlockFi Interest Account BIA. The offering promised investors a way to earn yield on their cryptocurrency holdings, allowing them to deposit Bitcoin, BTC, or Ethereum, ETH, in exchange for monthly interest payments. The concept, which mimicked traditional savings accounts without federal insurance, offered an initial annual percentage yield, APY of 6.2%, compounded monthly. To generate these returns, BlockFi deployed customer deposits through institutional lending, retail loans, and investments in equities and futures. The product quickly gained traction among retail and institutional investors, with the company announcing within weeks that it had attracted over $10 million in deposits. The BIA represented BlockFi's first major foray into yield generation, a financial strategy that had fueled the rise of decentralized finance, DeFi, but was now being offered in a centralized, regulated framework. Unlike banks, which are required to maintain reserves, BlockFi retained full discretion over how it deployed customer assets. Under the terms of the BIA, investors effectively granted the company complete control over their deposits, allowing BlockFi to lend, invest, or rehypothecate the funds at its own risk. This meant that depositors were not just earning interest, they were unknowingly acting as unsecured creditors to BlockFi, a reality that many would not fully grasp until it was too late. The company assured customers that its lending operations were sound, emphasizing that it charged more to institutions borrowing its crypto than it paid out to depositors. To further instill confidence, BlockFi partnered with Gemini Trust Company, a New York-regulated custodian founded by Cameron and Tyler Winklevoss. Gemini's oversight, combined with its insurance coverage for digital assets, gave the impression of enhanced security. BlockFi's executives emphasized that while BIAs functioned like savings accounts, they did not carry federal protections like those provided by the Federal Deposit Insurance Corporation, FDIC. This distinction, while noted in disclaimers, was often overshadowed by aggressive marketing campaigns promoting BIAs as a low-risk way to grow wealth. In a market still recovering from the 2018 crypto crash, BlockFi positioned itself as a leader in bringing institutional-grade financial services to an industry long plagued by volatility. The rapid adoption of BIAs led BlockFi to implement a tiered interest rate structure just 1 month after launch. On April 1, 2019, the company announced that balances up to 25 BTC or 500 ETH would continue earning 6.2% APY, but any holdings above those limits would earn just 2%. The decision reflected the company's need to manage risk while sustaining profitability, but it also marked the beginning of a pattern in which BlockFi would periodically adjust rates in response to changing market conditions. The company framed these changes as a way to maintain great rates for the maximum number of clients, though in reality, the adjustments were dictated by the firm's ability to generate yield from lending and investments. As interest in BIAs surged, BlockFi ramped up its promotional efforts. The company aggressively marketed the product as a tool for wealth accumulation, targeting long-term crypto holders with slogans like, "Earn Bitcoin as you HODL." The reference to HODL, a popular crypto slang term for buy-and-hold strategies, reinforced the idea that BIAs were an easy way for passive investors to earn extra returns on assets they plan to keep anyway. On March 20, 2019, just weeks after launching the BIA, BlockFi boasted that major firms were participating in the program, validating its business model. The company framed its mission as democratizing financial tools, positioning itself as an innovator in an industry still dominated by speculation. By mid-2019, BlockFi had established itself as the leading provider of interest-bearing crypto accounts, a status it maintained even as competition emerged. The firm continued adjusting interest rates based on market conditions, ensuring that yields remained competitive enough to attract deposits while maximizing the spread between lending and borrowing. Investors, drawn by the promise of high returns, largely ignored the inherent risks in BlockFi's model, risks that would only become evident when market conditions shifted. With the crypto industry on an upward trajectory, few questioned whether the company's lending practices could withstand a prolonged downturn. For BlockFi, the launch of the BIA was a turning point, transforming the company from a niche lender into a financial powerhouse. But beneath the surface, its business model relied on continued market growth and the assumption that institutional borrowers would always demand crypto loans at profitable rates. While the company appeared to be building a sustainable bridge between traditional finance and digital assets, The structure of its interest accounts contained vulnerabilities that would later prove catastrophic. When the crypto bull market inevitably turned, BlockFi's promise of safe yield would unravel, exposing both the firm and its customers to the brutal reality of high-risk lending. By March 2019, BlockFi had transformed from a niche crypto lender into one of the most talked-about financial services firms in the digital asset space. Just 2 weeks after launching its BlockFi interest account BIA, the company had already amassed over $35 million in deposits, with an additional $25 million flowing in shortly after. The product, which promised up to 6.2% annual yield on Bitcoin, BTC, and Ethereum, ETH, was marketed as an attractive alternative to traditional bank savings accounts, which offered near-zero interest rates at the time. But beneath the surface, BlockFi's terms gave the company significant control over how it deployed customer assets, with no fixed benchmark guiding its interest rates. CEO Zach Prince justified this flexibility as necessary for growth, explaining that BlockFi was willing to operate the BIA as a loss leader for up to 18 months to maximize customer acquisition. Unlike traditional banks that earn revenue from issuing fiat loans, BlockFi's core business model was built on lending crypto to institutional borrowers. These included proprietary trading firms, hedge funds, and market makers who needed access to digital assets for arbitrage and futures trading. BlockFi charged these borrowers between 4% and 12% interest and retained the right to call in loans or require additional collateral if crypto prices fluctuated. This arrangement made BlockFi's business highly sensitive to market movements, as its ability to pay depositors depended on maintaining a steady flow of institutional demand. The company's lending operations were further complicated by the fact that it did not hold private keys to customers' assets, relying instead on third-party custodians like Gemini Trust, founded by the Winklevoss twins. By April 2019, BlockFi's explosive growth showed no signs of slowing down. The company announced it was paying interest on $53 million in crypto deposits, a staggering jump from the prior month. This influx of new clients, however, forced BlockFi to modify its interest structure. Initially, all deposits earned the full 6.2% APY, but by the end of March, the company introduced a tiered system. Only deposits up to 25 BTC or 500 ETH qualified for the top rate, while any holdings beyond that earned just 2%. CEO Zach Prince acknowledged that the rapid influx of deposits had outpaced demand from institutional borrowers, making it unsustainable to maintain uniform interest rates. While the company's terms allowed it to adjust yields at its discretion, these changes hinted at the underlying challenge of balancing supply and demand in the crypto lending market. In December 2019, BlockFi expanded beyond lending, entering the crypto trading business with a zero-fee exchange for Bitcoin, Ethereum, and stablecoins. Unlike traditional exchanges that charge transaction fees, BlockFi monetized the platform by selling anonymized trading data to institutional firms. This model resembled the approach used by Robinhood, which generated revenue by routing retail trades to high-frequency trading firms. BlockFi's market makers included some of its own lending clients and equity investors, such as Susquehanna, Acuna Capital, and CMT Digital. By vertically integrating lending, trading, and market making, BlockFi strengthened its ties with institutional players while increasing its control over liquidity flows. As BlockFi's product suite expanded, so did its workforce. In August 2019, the company raised $18.4 million in a Series A round led by Peter Thiel's Valor Ventures, allowing it to double its headcount to over 60 employees. By early 2020, BlockFi had cemented itself as the leading centralized crypto lender, securing high-profile partnerships with Gemini and Circle. These collaborations paved the way for new offerings, including the BlockFi Rewards Visa credit card, which allowed users to earn Bitcoin cashback on purchases. With crypto prices recovering from the 2018 bear market, BlockFi positioned itself as the go-to financial institution for retail investors looking to monetize their holdings without selling them. In early 2021, BlockFi made its biggest push yet into institutional investment by launching the BlockFi Bitcoin Trust. The product, structured similarly to the Grayscale Bitcoin Trust, GBTC, allowed accredited investors to gain exposure to Bitcoin through a traditional financial vehicle. To attract clients, BlockFi undercut Grayscale's fees, charging 1.75% compared to GBTC's 2%. The company also disclosed that it held $1.7 billion in GBTC shares, representing 5.66% of the market-leading Bitcoin trust. This position underscored BlockFi's deep integration with the institutional side of crypto, but also revealed its growing dependence on the performance of a single asset class, funding. By August 2019, BlockFi had established itself as a rising force in the cryptocurrency lending market, attracting institutional investors and retail customers seeking high-yield returns. The company secured an $18.3 million Series A funding round, led by Peter Thiel's Valar Ventures, with participation from Winklevoss Capital, Galaxy Digital, Consensys, Acuna Capital, and other major players in the digital asset space. The infusion of capital underscored growing confidence in BlockFi's model, which allowed customers to earn interest on their Bitcoin, BTC, and Ethereum, ETH holdings. At the same time, the company generated yield through institutional lending. Earlier that year, BlockFi had reached a significant milestone, surpassing $50 million in customer deposits just weeks after launching its flagship BlockFi Interest Account BIA. The firm's rapid growth, however, was already forcing it to adjust its promised returns, with interest rates for larger depositors reduced to 2% in April 2019. With fresh capital secured, BlockFi expanded its product offerings, reinforcing its position as a leading provider of crypto financial services. The firm continued to refine its lending operations, which allowed users to take out US dollar loans backed by crypto collateral while aggressively marketing its high-yield deposit accounts. The 6.2% annual interest rate remained a significant draw for retail investors looking for alternatives to traditional savings accounts in an era of low interest rates. BlockFi's ability to offer such high yields depended on the continued willingness of institutional players, such as hedge funds and proprietary trading firms, to borrow crypto at premium rates. As long as demand remained strong, BlockFi could sustain its model. However, the company's flexibility in adjusting interest rates at its discretion signaled that the balance between inflows and lending demand was an ongoing challenge. The Series A funding also fueled a significant expansion in BlockFi's workforce, doubling its headcount from around 30 employees to more than 60 by mid-2019. CEO Zach Prince emphasized that half of the new hires were engineers, reflecting the company's push to enhance its technology and infrastructure. This rapid scaling was essential for BlockFi to manage the increasing complexity of its lending and deposit products while meeting regulatory requirements in various jurisdictions. Unlike decentralized finance, DeFi platforms, which operated through automated smart contracts, BlockFi's centralized structure required significant human oversight to assess risk, manage institutional loans, and ensure liquidity. While the company's custodial arrangement with Gemini Trust provided an additional layer of security, the reliance on third-party partnerships also added to its operational dependencies. BlockFi's trajectory appeared unstoppable at the time, buoyed by an influx of capital and an expanding user base. The firm's ability to raise significant funding from prominent venture capitalists demonstrated that institutional investors saw promise in crypto lending as a bridge between traditional finance and digital assets. Yet, beneath the surface, the company was already navigating fundamental challenges, balancing deposit growth with institutional lending demand, maintaining competitive interest rates, and ensuring liquidity in volatile crypto markets. As BlockFi scaled, its ability to sustain its high-yield promises would depend not just on operational efficiency, but on the broader stability of the crypto financial ecosystem. This risk would only become apparent in the years ahead. In February 2020, BlockFi secured a $30 million Series B funding round, once again led by Peter Thiel's Valar Ventures. The round included repeat investors such as Morgan Creek Digital, Acuna Capital, and Winklevoss Capital, as well as new backers like Castle Island Ventures and Hong Kong-based Hashkey Capital. CEO Zach Prince highlighted Hashkey's participation as particularly significant, as it would support BlockFi's planned expansion into Singapore and the broader Asia-Pacific region. While the company had been serving customers in Asia remotely, the new capital injection allowed it to establish a physical presence there. By early 2020, BlockFi's lending and deposit operations had grown, with the company reporting more than $650 million in assets on its platform, a 160% increase from the $250 million it had recorded just 6 months earlier. Despite this rapid growth, a fundamental challenge had already begun to emerge. Deposit inflows were outpacing institutional borrower demand. BlockFi had been forced to cut interest rates multiple times, acknowledging that the imbalance made its original yields unsustainable. However, Prince remained optimistic, framing the Series B as an opportunistic raise that would strengthen BlockFi's balance sheet and allow the company to continue investing in new products and markets. With a reported loan loss rate of 0%, the company projected confidence. However, its ability to maintain high yields while expanding its institutional lending business would remain a delicate balancing act that would become increasingly difficult as the crypto market's volatility intensified. In August 2020, BlockFi raised $50 million in a Series C funding round, led by Morgan Creek Digital, further cementing its position as a dominant force in crypto lending. At the time, CEO Zach Prince reported that the company held $1.5 billion in assets under management, generating nearly $10 million in monthly revenue. The round attracted diverse investors, including National Basketball Association player Matthew Dellavedova, highlighting the growing mainstream appeal of crypto-based financial services. With this fresh capital, BlockFi continued expanding its offerings, aiming to scale its lending business while maintaining its high-yield interest accounts. The infusion of funds also signaled strong investor confidence in BlockFi's model, even as questions lingered about the long-term sustainability of its aggressive growth strategy. Between January and March 2021, BlockFi secured a staggering $350 million in Series D funding, pushing its valuation to $3 billion. At the same time, its retail business was booming, with the average customer balance increasing fivefold from $10,000 to $50,000. CEO Zach Prince attributed this growth to both customer confidence and the surging price of digital assets. The company announced the launch of BlockFi Prime, a trading platform tailored for high-net-worth investors, further expanding its reach into the institutional space. With momentum building, BlockFi appeared on track for an eventual public listing, with reports surfacing in July that it was closing a $500 million Series E round at a $4.75 billion valuation. GBTC. By mid-2020, BlockFi's monthly revenue had surged, fueled by Bitcoin's highly anticipated halving event in May and a rapid expansion of its user base. The halving, which reduced the supply of new Bitcoins entering circulation, drove investor interest in crypto, bringing new users to BlockFi's lending and interest-bearing accounts. In the week following the event, BlockFi added more users than in any other week in its history, with 7,000 new funded accounts and a 25% month-over-month growth rate. The launch of BlockFi's mobile app further accelerated adoption, making it easier for retail investors to deposit and borrow against their crypto holdings. By July 2020, BlockFi projected that it was on track to generate $50 million in revenue over the next 12 months, a staggering fourfold increase from just 6 months earlier. As BlockFi's revenue climbed, so did its appetite for investment. In October 2020, the company made a bold move by acquiring a 5% stake in the Grayscale Bitcoin Trust GBTC, a publicly traded fund designed to provide institutional exposure to Bitcoin without requiring direct ownership. Grayscale, owned by Digital Currency Group, had become the dominant player in the crypto investment space, with billions of dollars in assets under management. BlockFi's bet on GBTC mirrored that of Three Arrows Capital, a high-profile hedge fund that had also amassed a significant stake in the trust. However, while GBTC provided a regulated way for institutions to gain Bitcoin exposure, it came with a critical flaw. Once money was invested in GBTC, it was difficult to withdraw. At the time, the trust consistently traded at a premium to Bitcoin's spot price. Still, as market conditions shifted, shares in GBTC would later plunge to a steep discount, creating liquidity issues for BlockFi and other major holders. Doubling down on its Bitcoin ambitions, BlockFi registered its own Bitcoin trust with the U.S. Securities and Exchange Commission, SEC, in early 2021, directly competing with Grayscale's product. Unlike GBTC, BlockFi's trust offered a lower management fee and partnered with Fidelity Digital Asset Services for custody, signaling its intent to challenge Grayscale's dominance. Later that year, BlockFi sought further institutional legitimacy by filing for approval of a spot Bitcoin exchange-traded fund ETF, a product the SEC had repeatedly declined to approve. These moves reflected BlockFi's strategy to entrench itself in the institutional Bitcoin market. Still, they also exposed the company to significant regulatory and liquidity risks, issues that would later contribute to its downfall. Despite the growing risks, investor confidence in BlockFi remained strong. In March 2021, as Bitcoin soared past $60,000 for the first time, BlockFi raised $350 million in a Series D funding round, pushing its valuation to $3 billion. The firm reported holding $15 billion in assets and announced plans to scale its workforce to 500 employees by the end of the year. Its user base had skyrocketed to 225,000, up from just 10,000 in late 2019, reflecting the broader surge in crypto adoption. BlockFi's business appeared unstoppable, buoyed by the unprecedented bull market and a flood of capital from retail and institutional investors alike. Yet beneath the surface, cracks had already begun to form. BlockFi's reliance on GBTC as a revenue-generating asset, its exposure to fluctuating interest rates, and its aggressive expansion in an unregulated market created vulnerabilities that would later be impossible to ignore. As long as Bitcoin prices continued their upward trajectory, BlockFi could maintain its lending model and pay high yields to depositors. But if the market turned, the company's high-risk strategy would be tested. The seeds of its collapse had already been planted. The only question was when the reckoning would arrive. By late 2021, BlockFi had set its sights on breaking into the lucrative exchange-traded fund ETF market, signaling its intent to entrench itself in mainstream financial markets. On October 8, 2021, the company filed for a Bitcoin futures ETF, the BlockFi Bitcoin Strategy ETF, which would invest solely in futures contracts traded on the Chicago Mercantile Exchange, CME. The filing followed signals from SEC Chair Gary Gensler that futures-based Bitcoin ETFs were more likely to receive regulatory approval than those based on the spot price of Bitcoin. However, BlockFi faced stiff competition from several firms that had filed similar proposals months earlier and were already nearing final approval. Despite the slim chance of winning the race, BlockFi's move reflected its strategy to expand beyond lending and interest accounts into more traditional financial products. BlockFi doubled down on its ETF ambitions a month later, filing for a spot Bitcoin ETF in partnership with asset management firm Neuberger Berman. Unlike a futures ETF, which tracks derivative contracts, a spot ETF would hold actual Bitcoin, offering investors direct exposure to the asset's price movements. The SEC had repeatedly rejected spot Bitcoin ETFs over concerns about market manipulation and a lack of regulatory oversight in crypto trading. Still, BlockFi joined a growing list of firms pushing for approval, betting that increasing institutional interest in Bitcoin would force regulators to allow such products. At the same time, BlockFi faced mounting legal and market pressures. In late 2021, FTX.US, the American subsidiary of SBF's crypto empire, extended a $400 million credit facility to BlockFi in exchange for an option to acquire the company at a future date. The deal provided BlockFi with much-needed liquidity as it navigated regulatory scrutiny and a cooling crypto market. Though BlockFi was still managing significant investor assets, $10.4 billion in BlockFi interest accounts, BIAs, as of December 8, 2021, the firm's long-term sustainability was in question. The FTX partnership inextricably tied BlockFi to SBF's rapidly expanding and ultimately unstable crypto empire. Despite these pressures, BlockFi continued adjusting its BIA interest rates to remain competitive. By November 1st, 2021, investors could earn anywhere from 0.1% to 9.5%, depending on the type and amount of cryptocurrency deposited. Stablecoin deposits, such as Tether, USDT, yielded the highest returns, with rates of 9.5% for deposits up to 40,000 USDT and 8.5% for amounts beyond that. Bitcoin, by contrast, saw significantly lower rates, with 4.5% interest for deposits up to 0.1 BTC, 1% for deposits between 0.1 and 0.35 BTC, and just 0.1% for anything above 0.35 BTC. These adjustments reflected BlockFi's ongoing struggle to balance the supply and demand of its lending business while maintaining attractive yields for depositors. By the end of 2021, BlockFi had grown into one of the largest centralized crypto lending firms, managing over $10.4 billion in BIA assets from more than 572,000 investors, including over 390,000 in the United States. The firm had successfully positioned itself as a bridge between the crypto and traditional financial sectors. Yet, beneath the surface, its reliance on high-yield interest accounts, exposure to volatile crypto investments like GBTC, and dependence on external funding from firms like FTX revealed the fragility of its crypto empire. BlockFi's fall. By mid-2021, BlockFi's rapid ascent collided head-on with regulatory scrutiny. On July 19th, New Jersey's Bureau of Securities struck the first blow, issuing a cease-and-desist order that barred BlockFi from onboarding new customers into its high-yield BlockFi interest accounts, BIAs. The order claimed that BIAs constituted unregistered securities under U.S. law, a classification that other state regulators would soon echo. Alabama and Texas followed with their own enforcement actions the same day, alleging that BlockFi had failed to properly register its lending products. 2 days later, Vermont added its voice to the growing chorus, and by the end of the month, Kentucky had also ordered BlockFi to halt new BIA signups. In the span of 2 weeks, the company had gone from one of crypto's most promising financial platforms to a firm under siege. The core issue regulators raised was whether BIAs were, in fact, securities. Under U.S. law, an investment contract is considered a security if investors contribute funds with a reasonable expectation of profit derived from the issuer's efforts, a framework established under the Supreme Court's Howey test. The SEC and state regulators argued that BIAs fit this definition. BlockFi pooled investor funds, used them to generate yield through institutional loans, and then distributed returns to depositors. Compounding its legal woes, BlockFi had made misleading claims about its risk management practices, repeatedly asserting that its institutional loans were typically over-collateralized. In reality, only 17% of BlockFi's loans met that threshold in 2021, exposing depositors to greater risks than they had been led to believe. These misrepresentations violated U.S. securities laws, adding another layer of liability to the company's mounting legal troubles. By February 2022, the regulatory pressure reached a breaking point. BlockFi agreed to a landmark $100 million settlement with the SEC and state regulators. The deal required BlockFi to pay $50 million to the SEC and an additional $50 million to resolve investigations in 32 states. More significantly, BlockFi was forced to cease offering BIAs to new U.S. clients and prohibit existing customers from adding more funds to their accounts. The SEC order also compelled BlockFi to register any future lending products under the Securities Act of 1933, ensuring stricter oversight of its operations. SEC Chair Gary Gensler framed the settlement as a warning to the broader crypto industry, emphasizing that crypto platforms must comply with time-tested securities laws or face similar consequences. BlockFi sought to chart a compliant path forward despite the financial and operational blow. The company announced plans to launch a new product, BlockFi Yield, which would be registered with the SEC and designed to comply with U.S. securities regulations. However, the process of obtaining regulatory approval was far from straightforward. BlockFi first needed to navigate the Investment Company Act of 1940, which required firms holding over 40% of their assets in investment securities to register as investment companies. The SEC provided a 60-day window for BlockFi to either restructure its operations or demonstrate why it did not meet the definition of an investment company. This legal gray area, coupled with the inherent challenges of registering a novel crypto lending product, placed BlockFi in an uncertain regulatory limbo. 3AC and FTX. By the summer of 2022, BlockFi's financial stability had unraveled. The crypto lender, once valued at $3 billion, was forced to accept a down round of funding in June, cutting its valuation to just $1 billion. The steep decline reflected a broader collapse in crypto markets, punctuated by Bitcoin falling below $20,000 for the first time in over a year. Compounding the crisis, BlockFi had been a major lender to Three Arrows Capital, 3AC, one of the largest crypto hedge funds, which imploded in late June after overexposing itself to the collapse of the Terra stablecoin ecosystem. Reports later revealed that BlockFi had liquidated 3AC's collateral before the hedge fund filed for bankruptcy on July 1st, but the damage had already been done. As confidence in centralized crypto lenders evaporated, BlockFi's main competitors, Voyager Digital and Celsius Network, also filed for bankruptcy that summer, signaling the depth of the sector-wide liquidity crisis. In an effort to contain the fallout, BlockFi took swift but painful measures to stabilize its operations. On June 16th, CEO Zach Prince announced on Twitter that BlockFi had been forced to liquidate a large client that had defaulted on an over-collateralized loan. Though he did not name the client, industry speculation pointed to Three Arrows Capital, whose rapid collapse had sent shockwaves across the crypto ecosystem. At the same time, BlockFi announced a 20% workforce reduction, slashing approximately 170 jobs to cut costs and conserve cash. These efforts, however, were not enough to stem the bleeding. On June 21st, BlockFi secured a $250 million revolving credit facility from FTX, with Prince framing the deal as a necessary move to bolster our balance sheet and platform strength. But the agreement also signaled a growing dependency on FTX and its founder, SBF, who had begun positioning himself as the central figure in crypto's bailout era. FTX's involvement with BlockFi quickly escalated. By late June, reports surfaced that the crypto exchange was in talks to acquire BlockFi outright, with negotiations centering on a shockingly low sale price of $25 million, just a fraction of the lender's $3 billion valuation from the previous year. The rumors triggered immediate backlash, with Prince publicly denying the reports, tweeting, "I can 100% confirm that we aren't being sold for $25 million. However, the reality was that BlockFi had little leverage. With $1.8 billion in open loans at the end of June and $600 million in exposure, the company was teetering on the brink of insolvency. The vast majority of its loan book, $1.5 billion, was concentrated in institutional clients, many of whom were also struggling with liquidity issues. BlockFi needed more than just a credit line. It needed a buyer. FTX had secured an even deeper financial commitment to BlockFi by late July. The companies finalized an agreement that provided BlockFi with a $400 million line of credit, along with an option for FTX US to acquire the lender at a future date. The deal effectively positioned FTX as BlockFi's lender of last resort, giving SBF's firm significant control over its operations. Notably, the acquisition price could have been as low as $15 million if BlockFi failed to secure SEC clearance for its yield-generating services in the US, a sign of how desperate the company's situation had become. While the agreement temporarily reassured investors and prevented an immediate collapse, it tied BlockFi's fate directly to FTX, a decision that would later prove catastrophic. When FTX collapsed in November 2022, BlockFi was one of the first major casualties. With the exchange's implosion erasing its primary financial backer, BlockFi abruptly paused withdrawals, citing significant exposure to FTX and its affiliated entities. The move confirmed what many had feared. BlockFi had never truly recovered from the liquidity crisis of the summer. Instead, it had merely delayed the inevitable by leaning on FTX, a firm that itself had been operating on borrowed time. The events of 2022 revealed the fragility of BlockFi's high-yield lending model, which had once promised retail investors easy returns but ultimately proved unsustainable in the face of cascading market failures. What had started as a promising effort to bridge crypto and traditional finance ended in a spectacular collapse, one that left thousands of investors stranded in its wake: bankruptcy. By November 2022, BlockFi's fate was sealed. The collapse of FTX, its financial backer and would-be savior, sent shockwaves through the crypto industry, and BlockFi, already weakened by the summer's liquidity crisis, could not withstand the impact. It had relied heavily on FTX's $400 million credit facility to stay afloat. But when FTX imploded, that support vanished overnight. On November 10th, BlockFi froze customer withdrawals, citing a lack of clarity around FTX's situation. The following day, California's financial regulator revoked BlockFi's lending license, and by November 15th, reports surfaced that the company was preparing for bankruptcy. On November 28th, BlockFi officially filed for Chapter 11 protection, revealing that it owed money to over 100,000 creditors and had over $350 million in crypto frozen on FTX. The filings also exposed a major financial entanglement. Alameda Research, FTX's sister trading firm, had defaulted on $680 million in loans to BlockFi, deepening the lender's financial black hole. BlockFi's bankruptcy case quickly became entangled in legal battles over assets, including a high-profile dispute with FTX's founder, SBF. On the same day it filed for bankruptcy, BlockFi sued SBF's Emergent Fidelity Technologies for control of Robinhood shares that had been pledged as collateral for a loan. Those shares, valued at around $600 million, were already the subject of competing claims from FTX, the Department of Justice, and multiple other creditors. As the bankruptcy proceedings unfolded, BlockFi's lawyers revealed that the lender had between $1 billion and $10 billion in total assets and liabilities, leaving customers uncertain about whether they would recover their funds. Attorney Joshua Sussberg, representing BlockFi, told the court that the process of recovering assets from FTX would play out over a long period of time. Given that FTX itself had over 1 million creditors and had suffered a reported hack that drained hundreds of millions in assets on the day of its bankruptcy, the likelihood of BlockFi customers receiving full restitution appeared slim. As BlockFi moved forward with its bankruptcy proceedings, new revelations emerged about the depth of its ties to FTX and Alameda Research. In May 2023, BlockFi claimed more than $1 billion in asset recoveries against FTX, with its financial recovery hinging primarily on whether it could recoup funds from its defunct partner. Its wind-down plan projected that customers with interest-bearing accounts could recover anywhere between 39% and 100% of their assets, depending on legal outcomes. But creditors were increasingly skeptical of BlockFi's leadership. In court filings, they accused the company of making reckless decisions, including converting $240 million in cryptocurrency into fiat at the bottom of the market, resulting in massive losses. Even worse, BlockFi had deposited $10 million of those funds into Silicon Valley Bank, which later collapsed, adding yet another layer of mismanagement to the saga. By June 2023, BlockFi's unsecured creditors had lost patience. They filed to liquidate the company, accusing management, particularly CEO Zach Prince, of fraud and extortion in delaying the bankruptcy resolution. The creditors argued that BlockFi had no viable path forward and was simply using the process to shield its executives from legal consequences. In response, BlockFi filed an updated bankruptcy plan under Chapter 11, offering interest account holders a recovery range of 39% to 100% of their assets, depending on the outcome of legal battles with FTX. But the creditors saw this as an unnecessary delay, insisting that liquidation was the only logical course of action. With administrative costs ballooning to $16 million per month and over 100 employees still on payroll, They argued that BlockFi was merely burning through what little remained of its assets. In July 2023, BlockFi's bankruptcy plan faced opposition from multiple fronts. FTX, Three Arrows Capital, and the SEC all objected to the proposed restructuring, arguing that it unfairly favored BlockFi's leadership while neglecting the interests of creditors. FTX, which had once bailed out BlockFi before its own downfall, claimed that its sizable claims against BlockFi had been improperly downgraded in the proposed plan. Three Arrows Capital, another former BlockFi borrower that had collapsed in 2022, contested fraud allegations made against it in the proceedings. The SEC, meanwhile, took issue with provisions that would release BlockFi's management from liability, mirroring objections it had raised in other crypto bankruptcies, such as Voyager Digital's. The growing chorus of opposition underscored a broader sentiment. BlockFi had made too many risky bets, and its efforts to protect its executives at the expense of creditors would not go unchallenged. A final damning report, unsealed on July 17, 2023, provided the most apparent evidence yet of BlockFi's mismanagement. The report alleged that the company had continued making high-risk loans to Alameda Research even after seeing FTX's infamous balance sheet, the same document that had triggered FTX's collapse when it was published by CoinDesk in November 2022. The report, based on 30,000 internal documents and interviews with key individuals, revealed that BlockFi had disregarded warnings from its own risk committee. Instead of tightening collateral requirements, CEO Zach Prince reportedly told employees to offer terms that we think the client Alameda could say yes to. The findings confirmed what many had suspected. BlockFi had knowingly put itself at the mercy of FTX and Alameda, even when red flags were glaringly obvious. By November 2023, BlockFi had emerged from bankruptcy, attempting to rebuild trust and re-establish itself in the crypto financial landscape. The company announced a structured plan to repay creditors, balancing crypto and fiat distributions according to court directives. Leadership emphasized a renewed focus on regulatory compliance, user asset security, and sustainable growth, an effort to distance itself from the reckless lending practices that had led to its collapse. CEO Zach Prince, in his first major address since the bankruptcy proceedings, outlined a roadmap that aimed to position BlockFi as a responsible player in the evolving digital finance sector. The message was clear. The company had learned from its past and was determined to regain its footing. In December 2023, BlockFi took its first tangible steps toward fulfilling its obligations. Initial creditor distributions began, with some customers receiving partial repayments in both cryptocurrency and fiat. Though the settlements fell short of full restitution, they marked a milestone in the company's long road to recovery. Meanwhile, reports surfaced of BlockFi engaging in discussions with fintech firms to explore new liquidity partnerships. Speculations swirled around the potential reintroduction of lending products, albeit with tighter oversight and risk management. These early efforts signaled BlockFi's intent to resume operations in a way that would avoid the regulatory entanglements of its past. The first quarter of 2024 brought BlockFi's most ambitious relaunch yet. The company introduced redesigned interest accounts under stricter regulatory scrutiny, ensuring full transparency in yield generation and collateral management. To further bolster its comeback, BlockFi secured a fresh capital raise, obtained additional state lending licenses, and resolved lingering disputes with regulators. At the same time, it unveiled an upgraded version of its Crypto Rewards credit card, boasting enhanced security features and more competitive rewards. These moves reflected a broader strategy to reintroduce products gradually while demonstrating regulatory maturity. By mid-2024, BlockFi was looking beyond the U.S. market. In the second quarter, the company announced plans to expand into Europe, targeting the UK, Germany, and France, while simultaneously piloting programs in Asia through Hong Kong and Singapore. Regulatory settlements at the state and federal levels allowed BlockFi to revamp its institutional lending division, this time with significantly tighter collateral requirements and improved risk controls. The company positioned itself as a safer, more measured player in the crypto lending space, a shift meant to appeal to both retail customers and institutional investors still wary of the industry's past failures. By the third quarter, BlockFi had released its first post-bankruptcy annual report, showcasing revenue growth and an expanding user base. The company also introduced an experimental governance token, giving users voting rights on select platform initiatives, a nod to the decentralized principles that the crypto industry valued. BlockFi invested heavily in infrastructure, deploying new blockchain security measures and hiring top-tier legal and compliance experts. The year concluded with BlockFi celebrating its one-year post-bankruptcy milestone, reporting over 5 million users and strong liquidity reserves. A newly launched over-the-counter OTC trading desk catered to growing institutional demand, reinforcing the idea that BlockFi was no longer just surviving, but actively rebuilding. Though the scars of its collapse remained, BlockFi had managed to do what many of its fallen peers could not: return from the brink and chart a new path forward. Chapter 7: FTX. FTX's rise. In November 2017, Sam Bankman-Fried, SBF, and Gary Wang launched Alameda Research in Berkeley, California, with a modest $250,000 in initial capital. At the time, the cryptocurrency market was experiencing an unprecedented bull run, with Bitcoin surpassing $10,000 for the first time. SBF, a former Jane Street trader, saw an opportunity in the inefficiencies of global crypto markets. Alameda carved out a niche in crypto arbitrage, a strategy that involved exploiting price discrepancies between different exchanges. One of the most lucrative opportunities was the so-called kimchi premium, where Bitcoin prices in South Korea ran significantly higher than in other markets due to capital controls and local demand. Alameda. By mid-2018, Alameda had expanded beyond arbitrage and into market making, a critical function in financial markets where firms provide continuous buy and sell orders to ensure liquidity. As a market maker on leading exchanges such as Bitfinex, Alameda earned fees on every trade, generating consistent revenue regardless of market conditions. At the same time, Alameda developed a growing over-the-counter OTC trading business, facilitating large crypto transactions for institutional clients. The firm's ability to execute trades efficiently and at scale further solidified its role as a dominant player in crypto. In July 2018, Alameda capitalized on another emerging trend: the rise of exchange-native tokens. Binance, the world's largest cryptocurrency exchange, launched its BNB token through its ICO platform, Binance Launchpad. Recognizing the potential for rapid appreciation, Alameda made a strategic investment in BNB early on. As Binance's influence grew, so did the value of BNB, turning Alameda's position into a massive windfall. This success validated SBF's broader strategy, leveraging Alameda's position as a market maker and liquidity provider to gain early exposure to high-growth crypto projects. It also marked the beginning of a close relationship between Alameda and Binance, a connection that would later play a pivotal role in FTX's rise and eventual downfall. The firm's rapid growth did not go unnoticed by institutional investors. In October 2018, Sequoia Capital, one of Silicon Valley's most prestigious venture capital firms, invested $250 million into Alameda Research. This infusion of capital allowed Alameda to scale its operations, recruit top-tier trading talent, and expand into new areas of crypto finance. With fresh capital in hand, Alameda moved aggressively into derivatives trading, launching complex financial products that allowed traders to hedge their positions or amplify their exposure to crypto markets through leverage. In early 2019, Alameda secured a founding membership in Crypto Facilities, a regulated derivatives clearinghouse. This move was more than just a business expansion. It was a strategic play to gain credibility with institutional investors wary of the crypto industry's lack of regulation. By participating in the clearinghouse's governance, Alameda had a seat at the table in shaping industry standards. It also provided a level of legitimacy that distinguished it from other trading firms that operated in the shadows. This effort to straddle both the unregulated and institutional sides of crypto finance would become a hallmark of SBF's strategy. Alameda's ambitions only grew from there. By February 2019, it had entered the futures and derivatives market, a sector that would later become the backbone of FTX. Derivatives allowed traders to take leveraged positions on crypto assets, increasing both potential gains and risks. For Alameda, these new financial instruments opened the door to even more sophisticated trading strategies. The firm could now hedge its own positions, profit from market volatility, and provide liquidity to exchanges that lacked deep derivative markets. The move into derivatives also signaled SBF's larger vision: to create a crypto trading ecosystem where Alameda controlled multiple points of financial infrastructure. In March 2019, Alameda launched a dark pool, a private exchange where large trades could be executed anonymously without affecting market prices. Dark pools are common in traditional finance, used by institutional investors to buy and sell large quantities of stock without creating price slippage. Alameda's introduction of this concept to crypto markets reflected its growing influence. It catered to high-frequency traders and large funds seeking discrete execution, further entrenching Alameda's dominance. At the same time, the firm made a significant investment in BlockFi, a crypto lending platform that allowed users to earn interest on their holdings. This move extended Alameda's reach into the world of decentralized finance, DeFi. By mid-2019, Alameda was no longer just a trading firm. It was a financial empire within crypto. In August, it launched Alameda Ventures, an investment arm focused on acquiring stakes in promising blockchain projects. Unlike traditional venture capital firms, Alameda Ventures had the advantage of deep market intelligence, allowing it to identify and support projects that could benefit from its liquidity expertise. At the same time, the firm's ability to provide capital, liquidity, and market-making services created a self-reinforcing cycle where its investments had a built-in advantage. By November 2019, Alameda had reached a staggering $2 billion valuation. The firm's success was built on aggressive risk-taking, cutting-edge trading strategies, and a willingness to operate in the gray areas of crypto finance. But even as Alameda thrived, SBF was already looking ahead. He recognized that the biggest opportunity in crypto was not just trading, it was building an exchange. An exchange would allow him to capture fees from every transaction, control liquidity, and shape the very infrastructure of crypto markets. The stage was set for the next phase of his empire, the creation of FTX. Alameda Research had become a dominant force in crypto, but its influence would soon extend far beyond trading. The firm's success laid the foundation for FTX, the exchange that would make SBF one of the most powerful figures in the industry. However, the very traits that fueled Alameda's rise, high-risk strategies, market manipulation, and deep entanglements with its own investments, would eventually contribute to its undoing. The seeds of FTX's collapse were already being sown long before the world took notice. FTX. In May 2019, SBF officially launched FTX, a crypto exchange designed to cater to sophisticated traders. Co-founded with Gary Wang and Nishad Singh, the platform distinguished itself early with an aggressive suite of offerings, including many leveraged offerings. Products that allowed traders to take amplified bets on crypto price movements. Unlike traditional exchanges, which facilitated direct buying and selling of digital assets, FTX focused on derivatives, complex financial instruments that enabled users to speculate on price swings with significant leverage. At the core of its liquidity operations was Alameda Research, which served as the primary market maker. While SBF argued that this setup ensured tighter spreads and more efficient trading, critics questioned the ethics of a trading firm so closely intertwined with an exchange, fearing that Alameda's privileged access could be used to manipulate markets. FTX simultaneously launched its own exchange token, FTT, which would become central to its financial structure and eventual collapse. Alameda played an active role in stabilizing FTT's price, using algorithmic trading to create an illusion of steady growth. Holders of the token were offered reduced trading fees, staking rewards, and other incentives, driving adoption among retail and institutional investors. FTX also used FTT as collateral in its own trading ecosystem, further embedding it into the platform's financial mechanics. By August 2019, venture capital firms took notice, with Sequoia Capital leading an $8 million Series A funding round, further legitimizing FTX as a rising force in the crypto industry. FTX's expansion continued at an astronomical pace. In October 2019, the company established an office in Miami, positioning itself to navigate U.S. regulatory waters while signaling its ambition to compete in traditional financial markets. While SBF frequently claimed to prioritize compliance, FTX operated primarily offshore, skirting direct regulatory oversight by setting up its main operations in jurisdictions with lax crypto laws. Miami's growing reputation as a crypto-friendly hub made it a strategic choice, allowing FTX to strengthen its ties with institutional investors and regulators while maintaining operational flexibility. The move aligned with SBF's broader strategy, presenting FTX as a transparent, well-run exchange while keeping its more opaque business dealings offshore. The onset of the COVID-19 pandemic in early 2020 accelerated FTX's trajectory, as financial chaos sent traders flocking to high-risk, high-reward platforms. By February, FTX's daily trading volume had surged past $2.7 billion, fueled by global investors seeking leveraged opportunities amid economic uncertainty. The volatility of traditional markets pushed many traders into crypto derivatives, where FTX had positioned itself as a premier destination. As other financial institutions struggled with liquidity issues, FTX thrived, benefiting from both heightened speculation and institutional demand for alternative investment vehicles. The crisis validated SBF's vision of crypto derivatives as the future of trading and reinforced his belief that traditional finance was slow, inefficient, and ripe for disruption. In June 2020, FTX raised $115 million in a Series B funding round, cementing its status as a billion-dollar company. Paradigm and other top-tier venture capital firms participated in the round, betting on FTX's ability to reshape the crypto trading landscape. The infusion of capital enabled FTX to scale aggressively, expanding its trading products, hiring top engineering talent, and increasing its marketing efforts. Unlike many crypto startups that struggled to attract institutional backing, FTX's meteoric rise drew in investors eager to gain exposure to the booming digital asset sector. SBF's growing influence in the industry was becoming undeniable, as he positioned himself not just as an exchange operator, but as a key architect of the broader crypto economy. FTX's ambitions extended beyond derivatives trading. In August 2020, the company acquired Blockfolio, a popular crypto portfolio tracking app, for $150 million. The move was a play for the retail market, broadening FTX's reach beyond institutional and professional traders. Blockfolio's user base, which consisted of millions of casual crypto investors, provided FTX with a direct channel to onboard new customers. The acquisition also underscored SBF's strategy of vertical integration. By controlling multiple layers of the crypto ecosystem, from liquidity provision to retail trading, FTX sought to embed itself deeply into the fabric of digital finance. The deal was well received, further boosting FTX's reputation as an industry leader. By the end of 2020, FTX had established itself as one of the fastest-growing crypto exchanges in the world, seemingly poised to challenge even the largest players in the industry. With a billion-dollar valuation, deep venture capital backing, and an expanding product suite, the company was on a relentless upward trajectory. SBF cultivated an image as an unconventional but visionary leader, known for his disheveled appearance, rapid decision-making, and willingness to push regulatory boundaries. He presented himself as a champion of financial innovation, frequently engaging with lawmakers and regulators while simultaneously operating an opaque and highly leveraged business empire, mooning. By 2021, FTX's meteoric rise seemed unstoppable. In July, the company secured a record-breaking $900 million Series B funding round led by SoftBank, Sequoia Capital, and over 60 other investors, valuing the exchange at $18 billion. This was the largest fundraising event in crypto exchange history at the time, a clear indication that institutional money was pouring into the industry. FTX had surpassed 1 million users, cementing its position among the top 3 cryptocurrency trading platforms by volume. The exchange had also carved out a dominant role in the Bitcoin futures market, increasing its share from 9% to 16%, second only to Binance. These achievements gave FTX an aura of legitimacy, attracting more traders and reinforcing the perception that it was the next global financial powerhouse. In the months that followed, FTX's market influence deepened. The value of its native token, FTT, soared by 249% since the start of 2021, outperforming major competitors like Binance's BNB. SBF's company aggressively pursued acquisitions, expanding its reach beyond trading. In September 2021, FTX's U.S. subsidiary acquired LedgerX, a regulated crypto derivatives platform, giving the company a foothold in the U.S. options market. Around the same time, FTX Digital Markets was launched in the Bahamas, securing regulatory approval under the country's Digital Asset Registered Exchanges Bill. By establishing operations in jurisdictions with favorable crypto laws, FTX strategically positioned itself to operate with limited oversight while still appearing compliant to global regulators. In October 2021, the company raised another $420 million in a Series C funding round, pushing its valuation to $25 billion. Sam Bankman-Fried debuted on the Forbes Billionaires list with an estimated net worth of $22.5 billion, making him the richest self-made newcomer in the publication's history. His wealth would climb to $26 billion by year's end, fueled by the increasing value of FTT and its expanding global presence. At the time, FTX itself was reportedly valued at $40 billion, with SBF owning approximately 60% of the company. The success story was further burnished by the launch of the Future Fund, an initiative tied to SBF's belief in effective altruism, which positioned him as both a financial savant and a philanthropic leader. FTX's ambitions extended well beyond crypto trading. In January 2022, the company announced a new $2 billion venture fund, FTX Ventures, aimed at investing in promising blockchain projects. The same month, FTX raised an additional $400 million in Series C funding, bringing its valuation to an astounding $32 billion. The U.S. arm of the exchange, FTX.US, was also rapidly expanding, reaching an $8 billion valuation after securing $400 million from investors including SoftBank and Temasek. By this point, FTX was no longer just a cryptocurrency exchange. It was positioning itself as a global financial technology empire, capable of rivaling traditional Wall Street institutions. Meanwhile, SBF's growing political influence was also evident, as he announced plans to spend up to $1 billion on U.S. political campaigns ahead of the 2024 elections, simultaneously entrenching himself in regulatory and policymaking circles. As FTX grew, so did its regulatory footprint. In March 2022, the company secured approval from Cyprus's financial regulator, CySEC, allowing it to offer services across the European Economic Area. That same month, FTX became the first firm to obtain a license to operate a crypto exchange and trading house in Dubai, a rapidly emerging hub for digital assets. The company also expanded into Australia, further solidifying its global reach. By mid-2022, FTX had established a presence on nearly every major continent, portraying itself as a leader in both crypto innovation and compliance. In September 2022, FTX Ventures acquired a 30% stake in Skybridge Capital, the hedge fund founded by former White House Communications Director Anthony Scaramucci. However, behind the scenes, Skybridge was struggling. Its affiliate fund, Legion Strategies, had suspended redemptions due to severe losses in both stocks and crypto. By September, the firm faced redemption requests totaling 60% of its primary fund's total value, driven by a 38% loss. Skybridge had allocated 14% of its assets to FTX and held significant positions in other crypto investments, making its financial health directly tied to FTX's stability. The partnership included an agreement that Skybridge would invest $40 million into the crypto space, with $10 million earmarked specifically for FTX's FTT token, reinforcing a financial loop that benefited FTX's internal liquidity. FTX's presence in mainstream financial events grew alongside its business dealings. In April 2022, the company partnered with Scaramucci's Skybridge Alternatives SALT conference to co-host Crypto Bahamas, a high-profile event attended by top industry executives and political figures. The conference featured speakers including former U.S. President Bill Clinton and ex-UK Prime Minister Tony Blair, and NFL star Tom Brady, who, along with his wife supermodel Gisele Bündchen, had become equity investors in FTX. The sold-out event was heralded as a major success, prompting FTX and SALT to book the venue for a follow-up in 2023. Marketing. FTX's aggressive marketing strategy propelled the exchange into mainstream consciousness, transforming it from a niche crypto trading platform into a household name. The company pursued high-profile sponsorships, securing naming rights, sports partnerships, and celebrity endorsements at an unprecedented level. In June 2021, FTX paid $210 million to acquire naming rights for the esports powerhouse team SoloMid TSM, rebranding it as TSM FTX. This was followed by a groundbreaking partnership with Major League Baseball, MLB, making FTX the first cryptocurrency exchange to sponsor the league. The deal placed the FTX logo on umpire uniforms, ensuring constant visibility during every televised game. The partnerships reflected FTX's strategy of embedding itself within cultural institutions that reached millions of fans, legitimizing crypto as part of the broader entertainment and financial landscape. By the fall of 2021, FTX's presence in the sports world exploded. In September, the exchange signed a sponsorship deal with Mercedes-AMG Petronas, placing its logo on the Formula One team's cars and merchandise. That same month, FTX secured a 19-year, $135 million naming rights agreement for the Miami Heat's basketball arena, rebranding it as FTX Arena. These deals positioned FTX alongside some of the world's most recognized sports brands. The strategy mirrored traditional financial firms like JP Morgan and American Express, which had long associated themselves with professional sports to reinforce their market dominance. FTX's ability to attract top-tier athletes and celebrities further elevated its brand. In September 2021, Golden State Warriors star Stephen Curry signed on as a global ambassador, receiving an equity stake in FTX in exchange for his endorsement. In 2022, tennis champion Naomi Osaka followed, agreeing to wear the FTX logo during her matches while receiving part of her compensation in cryptocurrency. Tom Brady, one of the most celebrated athletes in American sports history, also aligned himself with FTX, appearing alongside SBF at the Consensus 2021 crypto conference. Beyond sports, FTX sought validation through political and entertainment circles. In November 2021, SBF traveled to Los Angeles, attending a whirlwind series of events that highlighted his growing influence. Over the course of 4 days, he met with Shaquille O'Neal, dined with the Kardashian family, spoke with former Secretary of State Hillary Clinton, and conversed with Goldman Sachs' CEO. SBF's schedule underscored a broader strategy, positioning himself as a visionary at the intersection of finance, technology, and popular culture. This calculated charm offensive was not just about FTX. It was about cementing SBF's own status as a once-in-a-generation entrepreneur, someone who could rival the likes of Jeff Bezos and Elon Musk. The pinnacle of FTX's mainstream marketing came in February 2022, when the company aired a Super Bowl commercial starring comedian Larry David. The ad, titled "Don't Miss Out," portrayed David as a historical skeptic who dismissed pivotal innovations such as the wheel and the light bulb, with the punchline suggesting that ignoring FTX would be a similar mistake. The commercial aired alongside a wave of other crypto advertisements during the Super Bowl, marking a moment when digital assets were presented as the future of finance to an audience of over 100 million viewers. The campaign captured the speculative euphoria of the time, as crypto firms poured money into advertising to fuel mass adoption. Yet, just months later, many of those same companies, including FTX, would unravel, and their business models were exposed as unsustainable. Despite FTX's success in securing major sponsorships, some deals never materialized. In late 2021, the company entered negotiations with singer-songwriter Taylor Swift over a potential $100 million endorsement agreement. The discussions stretched into the following spring, but ultimately fell apart without a deal. Unlike many celebrities who eagerly aligned with the crypto industry, Swift's team reportedly raised concerns about regulatory uncertainty and the long-term viability of the sector. In hindsight, the failed partnership stood out as a rare moment when a high-profile figure walked away from what seemed like an easy financial windfall, one that later proved to be a reputational minefield for many of FTX's endorsers. Smart move, Taylor Swift. While FTX dominated sports and entertainment sponsorships, the company's financial reach extended even further. In August 2021, FTX.US signed a $17.5 million 10-year agreement with University of California, Berkeley to secure naming rights for the football field at California Memorial Stadium. The payment was made in cryptocurrency, reflecting FTX's strategy of using its own digital assets as a financial instrument for real-world transactions. The lavish spending on sponsorships continued throughout 2022, even as cracks in FTX's financial foundation began to appear. In April, the company co-hosted the Crypto Bahamas Conference alongside Skybridge Capital's SALT event, featuring speakers such as former U.S. President Bill Clinton, former UK Prime Minister Tony Blair, and an array of financial industry heavyweights. The sold-out event underscored FTX's position as a global power player, with its branding, investment influence, and political connections reaching unprecedented heights. Yet, behind the scenes, the company's internal financial structure was far more fragile than its public image suggested. FTX's aggressive expansion had been fueled by risky financial maneuvers, opaque balance sheets, and an over-reliance on its own exchange token, FTT. White Knight. By mid-2022, the crypto industry entered a full-blown crisis. Bitcoin's price plunged, triggering a domino effect of collapses across the sector. The most devastating event came in May, when the Terra Luna ecosystem imploded, erasing over $40 billion in value and sending shockwaves through the industry. Crypto lenders like Celsius, BlockFi, and Voyager Digital found themselves over-leveraged and facing insolvency, unable to recover from the cascading liquidations. Amid the wreckage, SBF emerged as the White Knight, offering financial lifelines to distressed firms on the brink of collapse. As the contagion spread, FTX and Alameda Research moved aggressively. In June 2022, Alameda extended a $200 million credit facility to Voyager Digital, designed to provide liquidity and prevent further destabilization of the lender's operations. Around the same time, FTX announced a $250 million loan to BlockFi, another embattled lender struggling to meet withdrawal demands from panicked customers. SBF framed these bailouts as a necessary step to stem contagion and prevent further losses from rippling through the industry. "Even if we weren't the ones who caused it or weren't involved in it," he told NPR, "I think that's what's healthy for the ecosystem, and I want to do what can help it grow and thrive." While some applauded his efforts, others questioned whether FTX's interventions were truly altruistic or merely a calculated play to consolidate power. FTX's largest bailout deal came on July 1, 2022, when it signed an agreement with BlockFi that included an option to acquire the lender for up to $240 million. The deal also granted BlockFi access to a $400 million credit facility, temporarily shoring up its finances. The agreement positioned FTX as a de facto central bank of the crypto world, stepping in where traditional financial institutions could not or would not. At the same time, these moves signaled that SBF was not just aiming to save failing firms. He was acquiring valuable distressed assets at bargain prices. The BlockFi deal, if completed, would allow FTX to absorb its lending infrastructure and expand its control over the crypto credit market, further entrenching its influence. The takeover attempts extended to Voyager Digital, but this deal proved far more contentious. On July 22, 2022, FTX publicly offered a partial bailout of the bankrupt lender, proposing a plan where Voyager's customers could receive an advance on their bankruptcy claims. Under FTX's proposal, users would be able to withdraw cash or purchase new digital assets on the FTX platform, effectively integrating them into FTX's ecosystem. However, Voyager's management rejected the deal, calling it a lowball bid that was designed more for publicity than for the benefit of its customers. In a court filing, Voyager's lawyers wrote, "It seems clear, however, that Alameda FTX's proposal, which was made in contravention of the proposed bidding procedures, was designed to generate publicity for itself rather than value for Voyager's customers." Despite the rejection, FTX was not deterred. It would soon return with an even larger bid. By September 26, 2022, FTX.US had officially won an auction for Voyager Digital's assets, valuing the deal at approximately $1.42 billion. The agreement included $1.31 billion worth of Voyager-held cryptocurrencies, along with $111 million in additional consideration. The deal was contingent on court and creditor approval, but it positioned FTX as the new custodian of Voyager's remaining assets, reinforcing SBF's image as a consolidator of the crypto industry. Yet, the financial landscape was already shifting in ways that few had anticipated. Within weeks, FTX itself would be embroiled in a liquidity crisis, and by December, Voyager's assets would be re-auctioned, this time to Binance US, following FTX's catastrophic implosion. While securing these acquisitions, SBF continued expanding its reach. On September 28, 2022, FTX Ventures announced it had acquired a 30% stake in Skybridge Capital, the hedge fund founded by Anthony Scaramucci. The deal was part of SBF's broader effort to integrate FTX into the mainstream financial system, forging alliances with established Wall Street figures. However, the timing of the investment raised eyebrows. In the months leading up to the acquisition, Skybridge's affiliate fund, Legion Strategies, had suspended investor redemptions due to severe losses in both stocks and crypto. The firm's flagship fund had also seen redemptions spike to 60% of its total value, fueled by a 38% decline in performance. This meant that FTX's investment was not just an expansion play, it was in many ways another bailout, one that may have been structured to secure loyalty and influence rather than purely financial gain. Despite the perception that FTX was riding high, its aggressive bailout and acquisition strategy carried significant risks. Each loan and investment tied the company more deeply to the firms it was trying to rescue, creating a fragile web of interdependence. FTX's financial health was increasingly linked to the stability of the very firms it was absorbing, many of which had already proven to be poorly managed and over-leveraged. If any of these deals unraveled, they had the potential to trigger a liquidity crisis for FTX itself. The interconnections between Alameda Research, FTX, and its newly acquired companies remained opaque, raising concerns about whether FTX had the resources to back all of its financial commitments. As the broader crypto market continued its downward spiral, the cracks in FTX's foundation grew larger. Many of the firms it had attempted to save were beyond rescue, and the capital deployed in these bailout deals was not infinite. More troublingly, as onlookers would later realize, FTX was not merely risking its own funds, but also misusing customer deposits to sustain its empire. The very actions that elevated SBF to the status of a white knight were built using FTX customer funds. In retrospect, FTX's bailout spree of mid-2022 was not a demonstration of strength but a desperate gamble. Rather than stabilizing the market, these interventions exposed the fragility of the entire crypto ecosystem, where leverage, unregulated lending, and interwoven financial dependencies created the conditions for systemic collapse. When FTX itself fell apart just months later, it became clear that SBF had not been rescuing crypto. He was propping up a bubble already doomed to pop. FTX's fall. FTX's rise was built on innovation, aggressive marketing, and the strategic use of its native digital token, FTT. Like Binance's BNB, FTT functioned as an incentive mechanism, offering trading fee discounts, staking rewards, and other benefits to its holders. However, FTX took the concept further, pledging to use its profits to buy back and burn FTT, creating a controlled supply that reinforced its value. The token became deeply embedded in FTX's financial structure, but it also became the foundation of a dangerous and hidden risk. Behind the scenes, FTX had begun lending massive amounts of customer assets to its affiliated trading firm, Alameda Research, while using FTT as collateral. This arrangement created a precarious feedback loop. If confidence in FTX wavered, FTT's price would drop, threatening the solvency of both FTX and Alameda in a matter of days. Publicly, FTX maintained that customer funds were kept separate from its own operations, a claim that reassured traders and investors. But Alameda's financial strength depended on FTT. Alameda's market-making strategies and FTX's buyback promises kept the token's price inflated. Skeptics had long questioned the risks of such an interwoven structure, but hard evidence remained elusive until the fall of 2022. A leaked balance sheet from Alameda, first reported by CoinDesk, revealed the extent to which the firm's financial health relied on illiquid assets, primarily FTT. Of the $14.6 billion Alameda claimed as assets, a staggering $5.8 billion consisted of FTT tokens, and another $1.2 billion was tied up in Solana. Meanwhile, its liabilities loomed at $8 billion, including $7.4 billion in outstanding loans. The revelations triggered deeper scrutiny of the relationship between FTX and Alameda. Analysts quickly identified a pattern resembling a flywheel scheme, a self-reinforcing financial structure in which a company inflates the value of its assets to attract more investors, whose funds are then used to keep prices artificially high. The flywheel effect allowed Alameda to use FTT as collateral to borrow billions, while FTX's buyback model ensured a steady price floor for the token. But this system relied on perpetual confidence. Once investors or counterparties doubted the legitimacy of FTT's valuation, the flywheel would collapse under its own weight. Further analysis of blockchain data revealed an even more troubling fact. Alameda controlled nearly 180% of all FTT tokens in circulation, a mathematical impossibility that suggested widespread market manipulation. Moreover, 93% of all FTT was concentrated in just 10 wallets, meaning that true market demand for the token was effectively non-existent. By early November 2022, FTX's foundation cracked under scrutiny. A leaked CoinDesk report revealed the extent to which Alameda Research depended on FTT, a token largely controlled by FTX. This raised immediate concerns about Alameda's liquidity, and by extension, FTX's solvency. If the token's value dropped, Alameda would struggle to meet its obligations, setting off a dangerous domino effect. The crypto industry watched closely, but no one anticipated how quickly the house of cards would fall. On November 6, 2022, Binance CEO Changpeng Zhao, CZ, announced that his firm would liquidate its entire FTT holdings, citing recent revelations. Binance had received FTT as part of a 2021 equity buyout deal when FTX repurchased Binance's stake in the company. Within hours, millions of FTT tokens moved between wallets, prompting a liquidity crisis. Market participants understood the implications. If Binance, the world's largest exchange, no longer trusted FTX, why should anyone else? FTT's price plummeted. Customers, spooked by rumors that FTX lacked real liquidity, rushed to withdraw funds. Within 48 hours, users attempted to pull $6 billion from the platform, far exceeding its liquid reserves. Meanwhile, SBF tweeted that FTX's assets are fine. The crisis deepened on November 8th, when Binance announced it had signed a non-binding letter of intent to acquire FTX, pending due diligence. For a moment, it appeared that CZ had swooped in to rescue his former rival. The announcement sent a temporary wave of relief across the crypto market. But those familiar with Binance's playbook knew CZ was in control. He had the leverage to walk away, and the very next day, he did. After reviewing FTX's financials, Binance backed out, citing concerns over liquidity shortfalls and allegations of customer fund mismanagement. As FTX's troubles mounted, details of its reckless financial management emerged. SBF's inner circle diverted $10 billion in customer deposits to Alameda Research to fund risky bets. FTX's balance sheet was exposed as a patchwork of self-created assets, including FTT and Serum, SRM, tokens whose valuations relied almost entirely on market perception rather than real liquidity. Most damning of all, an $8 billion discrepancy appeared in FTX's books, with a missing sum hidden under a poorly internally labeled fiat account. The revelation confirmed what skeptics had long feared. FTX had been using customer deposits to prop up its empire. Regulators swiftly intervened. On November 10th, the Securities Commission of the Bahamas, where FTX was headquartered, froze its assets and ordered the platform to cease operations. A day later, on November 11th, FTX, Alameda Research, and over 100 affiliated entities filed for Chapter 11 bankruptcy in Delaware. Sam Bankman-Fried resigned as CEO and was replaced by John J. Ray III, the restructuring expert who had famously overseen the liquidation of Enron. Ray's first statements were chilling. FTX had worse corporate governance than Enron. Just hours after the bankruptcy filing, $473 million mysteriously vanished from FTX's wallets in what appeared to be an inside job. The company's apps warned users to uninstall them, suggesting a security breach. Some speculated that insiders had siphoned off funds before law enforcement could seize them. Meanwhile, another $1 billion to $2 billion in customer deposits remained unaccounted for, adding to the chaos. FTX had collapsed, but the full extent of the disaster was still unfolding. In the weeks leading up to FTX's downfall, SBF's political ambitions had drawn scrutiny. On October 14, 2022, he stunned Washington insiders by claiming he was considering donating $1 billion to influence the 2024 U.S. presidential election. The crypto industry viewed the statement with suspicion. FTX had spent lavishly on lobbying efforts, attempting to shape U.S. regulations in SBF's favor. A week later, Delphi Labs' general counsel, Gabriel Shapiro, revealed a draft bill allegedly influenced by FTX, which sought to regulate decentralized finance, DeFi, in ways that favored centralized exchanges like FTX. The proposal sparked outrage, with critics accusing SBF of trying to co-opt the DeFi movement for his own gain. While SBF sparred with DeFi advocates, his rivalry with Binance's CZ reached its breaking point. On October 25, 2022, SBF and Skybridge Capital's Anthony Scaramucci attended the Future Investment Initiative (FII) conference in Saudi Arabia, attempting to raise $2 billion for FTX. Behind closed doors, SBF allegedly made derogatory remarks about CZ, further straining relations. Scaramucci later hinted that CZ retaliated by dumping Binance's FTT holdings, triggering the FTX liquidity crisis. The battle between two of crypto's most powerful figures had become a full-scale war. In early November 2022, CoinDesk's bombshell report on Alameda's balance sheet confirmed the industry's worst fears. The leaked documents revealed that Alameda's assets included $5.8 billion in FTT, representing 180% of the token's market capitalization, a sign of severe market manipulation. Further investigation showed that 93% of FTT tokens were held by just 10 wallets, meaning the token had virtually no organic demand. The entire system had been propped up by FTX and Alameda themselves. As panic spread, Alameda CEO Caroline Ellison attempted to contain the damage. On November 7, 2022, with FTT falling to $22, she publicly offered to buy all FTT at that price, attempting to signal market strength. But her statement backfired. Instead of reassuring investors, it exposed Alameda's desperation. Traders realized that if FTT fell below $22, Alameda would face catastrophic liquidations. They began shorting the token aggressively, accelerating its collapse. By November 9th, FTX's reserves were nearly depleted. Internal chats revealed that SBF was scrambling to raise $8 billion to cover the liquidity hole. He reached out to OKX's Lennox Lai, asking for emergency funding, but received no help. His last hope was CZ, but Binance had already walked away from the deal. FTX's liquidity had dried up, and its empire was crumbling in real time. The final blow came on November 10th, when FTX stablecoin reserves plunged from $500 million to nearly zero. The exchange was out of the money. That morning, SBF admitted he had miscalculated user margins, a stunning admission that he had lost control of his own company's finances. By that evening, FTX was no longer viable. Its empire had collapsed in just 5 days. Bankruptcy. By November 10, 2022, the situation at FTX had become unsalvageable. Sam Bankman-Fried had spent the past several days scrambling to secure a bailout, reaching out to competitors, investors, and financial institutions in a desperate bid to raise capital. Axios reported that FTX had approached Kraken for a potential rescue deal, but no agreement materialized. SBF took to Twitter, issuing vague apologies and accepting responsibility for his company's failures, yet still insisting that FTX US was solvent. Meanwhile, the entire in-house legal and compliance teams resigned, leaving the exchange in free fall. The revelation that FTX had secretly loaned $10 billion in customer funds to Alameda Research sent shockwaves across the financial world. At the same time, regulators around the world were taking action. The Securities Commission of the Bahamas froze the assets of FTX Digital Markets Ltd., signaling the start of an official investigation. Japan's Financial Services Agency ordered FTX Japan to suspend operations, while the company's Australian subsidiary was placed under administration. The fallout from the FTX implosion extended far beyond its customers. Crypto lender BlockFi, which had received a credit line from FTX earlier in the year, suspended operations, citing its exposure to the collapsing firm. On November 11, 2022, the inevitable happened. FTX, FTX.US, Alameda Research, and more than 100 affiliated entities filed for Chapter 11 bankruptcy in Delaware. The New York Times reported that the company owed as much as $8 billion. Sam Bankman-Fried resigned as CEO, replaced by John J. Ray III, a restructuring specialist with a history of handling corporate disasters, most notably Enron. Ray immediately began assessing the damage, and what he found was staggering: a total failure of corporate controls, missing records, and billions in unaccounted-for customer funds. Even as the bankruptcy proceedings began, FTX was hit by yet another crisis. Late on November 11th, $473 million in funds were mysteriously siphoned from FTX wallets in what FTX U.S. General Counsel Ryan Miller described as unauthorized transactions. Analysts noted that the stolen funds were quickly converted from stablecoins into Ethereum, a common tactic used by crypto thieves to obfuscate the trail and evade asset recovery efforts. FTX issued an alert urging users to delete its mobile apps, warning that they had been compromised. Kraken, a competing exchange, later announced that it had identified a user connected to the unauthorized transactions, fueling speculation that the breach had been an inside job. As SBF's empire collapsed, law enforcement in the Bahamas moved in. On November 12th, the Royal Bahamas Police Force questioned SBF, though he insisted he was still attempting to raise funds for FTX. Meanwhile, other high-ranking FTX executives began fleeing to Hong Kong and other jurisdictions in anticipation of regulatory crackdowns. Reuters reported that between $1 billion and $2 billion in customer funds had simply vanished from FTX's books. The Financial Times revealed that, just before bankruptcy, FTX had only $900 million in liquid assets to cover $9 billion in liabilities, a shortfall that underscored the depths of the financial mismanagement. By November 14th, U.S. federal prosecutors had launched an official investigation into FTX's collapse, with the Southern District of New York leading the probe. That same day, the Australian Securities and Investments Commission suspended FTX Australia's financial license, preventing it from offering services to its 30,000 customers in the country. A class action lawsuit was filed in Florida against FTX and its celebrity endorsers, including Tom Brady, Gisele Bündchen, Larry David, and Shaquille O'Neal, alleging that they had misled consumers into investing in a fraudulent company. On November 17th, newly appointed CEO John J. Ray III submitted a sworn statement to the bankruptcy court. His assessment was damning. "Never in my career have I seen such a complete failure of corporate controls and such a complete absence of trustworthy financial information as occurred here." He revealed that Alameda Research had loaned $1 billion directly to SBF and more than $500 million to FTX co-founder Nishad Singh. The company's financial records were in complete disarray. FTX had been using QuickBooks for accounting, despite handling billions of dollars in transactions. "Literally, there's no record-keeping whatsoever," Ray testified before Congress. As the contagion spread, fears mounted that other crypto firms would follow FTX into bankruptcy. Crypto.com's exchange token, Cronos, lost $1 billion in value, in part due to reports that the company had accidentally sent $400 million in Ether to another platform. Crypto lender BlockFi, which had already halted withdrawals, was reportedly preparing to file for bankruptcy. Genesis Global Capital, a major crypto lender, suspended withdrawals, leading Gemini, the exchange owned by the Winklevoss twins, to pause redemptions on its high-yield crypto lending program. The publicly traded Grayscale Bitcoin Trust saw its price drop 42% below its Bitcoin reserves, reflecting deep distrust in crypto-linked financial products. The fallout extended to traditional banking institutions. Silvergate Bank, which had provided banking services to FTX, faced scrutiny over its potential exposure. While the bank insisted that it had ample liquidity and no loan exposure to FTX, investors and regulators remained cautious. The FTX collapse had become the single largest event of contagion in crypto's history, erasing billions in value and forcing the entire industry into crisis mode. The bankruptcy proceedings quickly exposed the financial rot beneath FTX's empire. On November 22nd, FTX's attorneys revealed in a Delaware court hearing that the company's financial controls were so poor that it had been run as a personal fiefdom by SBF and his inner circle. The court also learned that FTX had lost $3.7 billion between 2019 and 2021, long before the final collapse, suggesting that its business model had never been as sound as its public image suggested. By early 2023, the FTX estate began liquidating assets to repay creditors. SBF, now facing criminal charges, had been arrested in the Bahamas and extradited to the United States to stand trial. His extravagant political donations, lavish spending, and reckless management of customer funds became the subject of intense scrutiny. Regulators across the globe vowed stricter oversight of crypto exchanges, and former FTX customers were left wondering if they would ever recover their funds. After more than 2 years of legal battles, the FTX bankruptcy plan was finally approved by a Delaware judge on October 8, 2024. The plan aimed to distribute $16 billion to affected creditors, marking one of the largest asset recovery efforts in corporate bankruptcy history. The first round of creditor repayments was scheduled for January 3, 2025, with payouts processed through BitGo and Kraken in either stablecoins or cash. Prosecution. In the weeks following FTX's collapse, Sam Bankman-Fried embarked on an aggressive media tour, attempting to control the narrative. On November 30, 2022, he made a virtual appearance at the New York Times Dealbook Summit, telling interviewer Andrew Ross Sorkin that he didn't ever try to commit fraud. He granted interviews to major outlets and independent podcasters alike, appearing on Twitter Spaces marathons, crypto podcasts, and YouTube interviews. His tone wavered between remorseful and defensive, acknowledging that he had made mistakes while portraying himself as naive rather than malicious. "Look, I screwed up. I was the CEO of FTX. That means I was responsible, he told the New York Times. But denying intentional fraud was an argument that would soon face a harsh reality. That reality arrived on December 12, 2022, when Bahamian authorities arrested SBF at the request of the U.S. government. The arrest came just one day before he was scheduled to testify before Congress, suggesting that law enforcement agencies wanted to prevent him from speaking publicly under oath. Reports quickly emerged that he faced charges of wire fraud, securities fraud, money laundering, and campaign finance violations. Denied bail, he was sent to Fox Hill Prison, a Bahamian facility known for harsh conditions. U.S. prosecutors moved swiftly, filing a formal extradition request as details of the indictment became public. By December 13th, the U.S. Department of Justice, SEC, and CFTC announced parallel civil and criminal cases against SBF. Attorney General Merrick Garland described it as a global scheme to deceive and defraud customers and lenders, and stated that the government would aggressively prosecute financial fraud. U.S. Attorney Damian Williams was even more blunt, declaring that this was not a case of mismanagement but intentional fraud, plain and simple. According to the indictment, since 2019, SBF and his co-conspirators had misappropriated billions of dollars in customer deposits, using the funds for luxury real estate purchases, political contributions, and Alameda Research's debts. As the legal battle unfolded, other key FTX executives began flipping on SBF. On December 19, 2022, Caroline Ellison, the former CEO of Alameda Research, and Gary Wang, FTX's co-founder, pleaded guilty to wire fraud, securities fraud, and commodities fraud. Both agreed to cooperate with the government, setting the stage for devastating testimony against SBF. On December 21st, SBF was extradited to the United States to face formal arraignment. One day later, he appeared in a Manhattan federal court, where he was released under house arrest at his parents' home in Palo Alto on a $250 million bond, one of the largest bail packages in U.S. history. Despite the mounting evidence, SBF maintained his innocence. On January 3, 2023, he pleaded not guilty to all criminal charges in federal court. Prosecutors, however, continued to pile on additional counts, revealing a second indictment on February 23, 2023, which added bank fraud and operating an unlicensed money transmitter to the list of offenses. By this point, SBF faced 12 felony charges, with his trial set for October 2023. Meanwhile, the government secured yet another key witness. On February 28, 2023, Nishad Singh, FTX's director of engineering, pleaded guilty to wire fraud, campaign finance violations, and money laundering. Singh admitted that he had become aware of the $8 billion hole in FTX's balance sheet by September 2022, 2 months before the collapse. He fully cooperated with investigators, offering damning testimony against his former friend. As the trial loomed, SBF's legal troubles worsened. Prosecutors accused him of witness tampering, alleging that he had leaked private writings from Caroline Ellison in an attempt to discredit her. On July 26, 2023, the judge placed a gag order on SBF and revoked his bail on August 11th, sending him back to pretrial detention. While SBF prepared for trial, his former colleagues faced their own legal reckoning. On September 7, 2023, Ryan Salami, another top FTX executive, pleaded guilty to campaign finance violations, admitting to funneling tens of millions of dollars to both Democrats and Republicans on behalf of FTX. By October 2024, Ellison was sentenced to 2 years in prison, with the judge noting her full cooperation with authorities. Singh and Wang, however, received no prison time, with the court emphasizing their extensive assistance in securing SBF's conviction. SBF's trial began on October 3, 2023. Over the course of the proceedings, prosecutors laid out the full scale of the fraud, using insider testimony, internal documents, and financial records to prove that SBF had knowingly orchestrated a scheme to defraud FTX customers and investors. The trial was one of the most closely watched financial crime cases in recent history, drawing comparisons to Enron, Bernie Madoff, and Theranos. Trial. The criminal trial of Sam Bankman-Fried commenced on October 2, 2023, inside a packed Manhattan courtroom. U.S. District Judge Lewis Kaplan, known for his no-nonsense judicial style, presided over the case, overseeing the high-profile jury selection process. Given the extensive media coverage surrounding FTX's collapse, Kaplan acknowledged the difficulty of finding jurors who had not already formed opinions. The object is to select a jury of individuals who, no matter what they may know or not know about these parties or about this case, are willing and able to decide this case in a manner that's fair and impartial, he emphasized. Prospective jurors admitted varying levels of familiarity with the case. Some had followed Wall Street Journal coverage, others had watched 60-minute segments featuring Michael Lewis, who had written a book about SBF. When one juror admitted, "I still don't understand how crypto works," Kaplan dryly responded, "You probably have a lot of company in this court." By October 4, 2023, with the jury selected, the trial's opening statement set the stage for the legal battle. Prosecutors portrayed SBF as a mastermind of one of the largest financial frauds in history, accusing him of misleading customers, investors, and lenders about FTX's financial health. The defense, in contrast, framed him as a well-intentioned entrepreneur navigating an unregulated crypto industry, arguing that his failures were mistakes, not crimes. Prosecutors wasted no time calling Adam Yedidia, a former FTX employee and personal friend of SBF, as their first witness. Yedidia detailed the chaotic nature of FTX's work culture, from SBF's habit of sleeping on a beanbag chair in their $35 million Bahamas penthouse to internal employee discussions about FTX's growing financial instability. When messages were shown in which SBF acknowledged that Alameda Research was paying for their extravagant living arrangements, Yedidia admitted that these revelations had prompted him to resign from FTX just before its collapse. On October 5, 2023, Gary Wang, FTX's co-founder and former chief technology officer, took the stand. Wang confirmed that Alameda Research had received special privileges on FTX, including the ability to carry negative balances and withdraw unlimited customer funds, privileges that no other trading firm had. Under questioning, Wang admitted that these privileges were coded into FTX's infrastructure under direct orders from SBF. His testimony was particularly damning because Wang had already pleaded guilty and was cooperating with prosecutors, making it clear that he had no incentive to protect his former business partner. The trial reached a turning point on October 10, 2023, when Caroline Ellison, the former CEO of Alameda Research and SBF's ex-girlfriend, took the stand. Ellison's testimony lasted 3 days and was among the most explosive of the trial. She admitted that she had knowingly participated in fraud under SBF's direction, explaining that Alameda had used FTX customer funds to cover its trading losses. The courtroom fell silent as she described their on-again, off-again romantic relationship, shedding light on how personal dynamics played into business decisions. Ellison detailed the final days of FTX, calling them chaotic and overwhelming, and confirmed that SBF was willing to take reckless financial risks in pursuit of long-term gains. Her testimony was corroborated by internal documents and messages, leaving little room for doubt. By October 13, 2023, prosecutors shifted their focus to the broader impact of FTX's collapse. Zach Prince, the CEO of BlockFi, testified that his company had relied on misleading balance sheets from Alameda when extending loans. By the time FTX imploded, BlockFi had $1 billion in exposure to the failed exchange, a level of risk that eventually drove it into bankruptcy. Nishad Singh, FTX's former director of engineering, testified on October 16 to 17, confirming that political donations were funneled through employees' names using customer funds, and that SBF had approved a $700 million investment in K5 Global, despite FTX's precarious financial state. Singh admitted to borrowing money for a home purchase just before FTX collapsed, underscoring the recklessness inside the company. By October 18, 2023, The prosecution called expert witnesses to explain how FTX customer funds flowed to Alameda. A University of Notre Dame professor broke down the mechanics of FTX's fraudulent transactions, while FTX's former general counsel, Can Sun, testified that he had been unaware of Alameda's ability to access customer funds. To further discredit SBF's post-collapse public relations campaign, prosecutors played his December 2022 media interviews, where he downplayed the extent of the fraud. In a high-stakes gamble, Sam Bankman-Fried took the stand on October 26, 2023. His testimony was carefully orchestrated by his defense team, presenting him as a brilliant but overwhelmed entrepreneur who made bad decisions rather than engaged in outright fraud. However, Judge Kaplan restricted key parts of his testimony, excluding details about FTX's legal counsel and their role in company decisions. Prosecutors seized on inconsistencies between his past public statements and his courtroom testimony, pressing him on how Alameda had been able to siphon billions from FTX without customers' knowledge. The cross-examination on October 30th to 31st was brutal. Prosecutors pointed out contradictions in SBF's statements, highlighting moments where he previously claimed ignorance but later admitted to key decisions. The defense attempted to frame his mistakes as the result of navigating a complex, fast-moving industry, but the damage was done. By the time the closing arguments took place on November 1, 2023, both sides had cemented their positions. Prosecutors argued that SBF had deliberately lied to customers, investors, and lenders to sustain FTX's fraudulent empire. The defense countered that he had made errors while running a complicated business but never intended to deceive anyone. On November 2, 2023, after just a few hours of deliberation, the jury returned its verdict: guilty on all counts. Bankman-Fried was convicted of fraud and conspiracy, cementing his fall from grace. The courtroom buzzed with tension as the judge set a sentencing date, signaling the end of one of the most high-profile financial crime trials in modern history. For the crypto industry, the conviction was a definitive statement. The era of unchecked exchanges was over, and the consequences for fraud in the sector were now very real. Sentencing. On March 28, 2024, Sam Bankman-Fried stood before Judge Lewis A. Kaplan in a Manhattan courtroom, awaiting the final chapter in his dramatic downfall. Once hailed as a visionary in cryptocurrency, he was now a convicted fraudster, facing the weight of justice. The court sentenced SBF to 25 years in federal prison, along with 3 years of supervised release and an $11 billion forfeiture order. The sentence reflected the sheer scale of his fraudulent schemes, which siphoned billions in customer funds from FTX and misled investors and lenders about the true financial health of his empire. The Department of Justice called it one of the largest financial frauds in history, comparing it to Enron and Bernie Madoff's Ponzi scheme in its devastating consequences. Attorney General Merrick Garland delivered a stern warning about the broader implications of the case. Anyone who believes they can hide their financial crimes behind wealth and power, or behind a shiny new thing they claim no one else is smart enough to understand, should think twice, he stated. His words captured the deceptive allure of cryptocurrency's rapid rise, where figures like SBF positioned themselves as tech pioneers, only to manipulate and exploit their customers' trust. FBI Director Christopher Wray reinforced the severity of the case, stating that the FBI would aggressively pursue individuals who misuse financial systems for personal gain. The coordinated efforts of the Department of Justice, the FBI, and the Southern District of New York underscored the U.S. government's growing scrutiny of crypto fraud. During the trial and sentencing, prosecutors outlined the extensive web of lies orchestrated by SBF. From 2019 to 2022, he misappropriated billions of dollars from FTX customer deposits, funneling them into Alameda Research, his personal trading firm. These funds were not only used to prop up Alameda's failing bets, but also to finance lavish personal expenditures, including luxury real estate and political contributions. Despite repeated assurances that FTX customer deposits were safe and segregated, the evidence revealed a completely different reality, one in which Alameda had unrestricted access to FTX customer funds, facilitated through altered computer code and deceptive financial reporting. Judge Kaplan, in his sentencing remarks, did not mince words. He described SBF's actions as brazen and calculated, noting that his lies were not a momentary lapse in judgment, but a deliberate strategy to enrich himself and expand his influence. The prosecution emphasized that his crimes were not victimless. Many FTX customers, some of whom had invested their life savings, were left with nothing when the exchange collapsed. U.S. Attorney Damian Williams stressed that the consequences extended beyond the dollar amounts, stating, "The scale of his crimes is measured not just by the money stolen, but by the extraordinary harm caused to victims." The sentence marked a defining moment in the regulation and enforcement of cryptocurrency markets. Unlike previous high-profile financial fraud cases, where crypto companies often operated in legal gray areas, SBF's conviction signaled a clear shift. Fraudulent behavior in decentralized finance would not go unpunished. With $11 billion in forfeiture authorized, authorities began the long process of recovering assets to compensate victims. The collapse of FTX had shattered trust in digital asset exchanges, and regulators worldwide were now tasked with ensuring such a collapse never happened again. In the end, SBF's rise and fall became a cautionary tale, a reminder that no amount of technological innovation could shield fraud from accountability. On May 28, 2024, Ryan Salami, a former FTX executive, was sentenced to 90 months in federal prison for his role in an unlawful political influence scheme and an unlicensed money-transmitting business. Once a trusted lieutenant of Sam Bankman-Fried, Salami admitted to funneling tens of millions of dollars in illegal campaign contributions to political candidates and operating an underground financial network that allowed FTX and Alameda Research to move customer funds outside legal banking channels. His sentencing marked yet another high-profile conviction in the fallout of FTX's collapse, as federal prosecutors continued to unravel the layers of deception behind the crypto giant's meteoric rise and catastrophic implosion. U.S. Attorney Damian Williams emphasized the gravity of Salami's crimes, stating that his actions undermined public trust in American elections and eroded the integrity of financial markets. At the heart of the case was Salami's willingness to leverage political donations as a tool to secure regulatory favor for FTX and Alameda. Alongside SBF and fellow FTX executive Nishad Singh, he disguised campaign contributions to make them appear as individual donations, when in reality, they were corporate funds designed to amplify FTX's influence in Washington. These efforts secured favorable political relationships, ensuring that FTX's legislative agenda remained a priority among key lawmakers who were shaping the future of crypto regulation. Beyond his role in political maneuvering, Salami was also instrumental in FTX's illicit financial operations. Prosecutors detailed how he conspired with SBF and other insiders to operate an unlicensed money-transmitting business, using a shadowy entity called North Dimension to funnel FTX customer deposits without proper regulatory oversight. By bypassing traditional financial institutions, FTX and Alameda were able to move billions in customer funds, fueling high-risk trading strategies and lavish executive expenditures. The scheme was concealed through deceptive financial statements, which falsely assured banks that FTX was operating within legal boundaries. In reality, Salami and his co-conspirators had built a financial empire on a foundation of deceit. Salami's sentence included 3 years of supervised release, as well as over $6 million in forfeiture and more than $5 million in restitution. His conviction added to the growing list of FTX insiders who turned against SBF, testifying to the depth of corruption within the company. While some executives cooperated early in exchange for reduced sentences, Salami's direct involvement in illegal campaign finance violations and financial misconduct led to a severe penalty. His sentencing underscored the government's commitment to holding FTX's leadership accountable, demonstrating that even those operating in the highest echelons of the crypto industry would face consequences for financial crimes. The downfall of FTX's political strategy revealed the extent to which SBF and his inner circle had manipulated Washington to advance their interests. The illegal contributions Salami helped facilitate were not merely about influence. They were about control. By strategically funding candidates on both sides of the aisle, FTX sought to position itself as an untouchable force in the crypto industry. But as prosecutors peeled back the layers of deception, it became evident that FTX's political power was built on fraudulent foundations. Salami's sentencing, much like those of his former colleagues, signaled a reckoning for the crypto industry, reinforcing that unchecked ambition, when fueled by deceit, leads to inevitable collapse. CFTC. On December 13, 2022, the Commodity Futures Trading Commission, CFTC, filed a sweeping fraud complaint against Sam Bankman-Fried, FTX Trading, and Alameda Research, alleging that they had misappropriated over $8 billion in customer funds. The case marked one of the most significant enforcement actions in cryptocurrency history, accusing SBF and his companies of systematic deception, market manipulation, and violations of the Commodity Exchange Act, CEA. The complaint detailed how FTX had falsely assured customers that their deposits were safe, segregated, and held in custody, when in reality, they were being funneled into Alameda Research for high-risk trading, political contributions, and luxury purchases. The lawsuit underscored the fragile foundation of trust that had allowed FTX to grow into a multi-billion-dollar behemoth, only to crumble under regulatory scrutiny. CFTC Chairman Rostin Behnam framed the lawsuit as part of a broader effort to bring accountability to digital asset markets, warning that crypto's lack of basic investor protections had made it an ideal breeding ground for fraud. The charges against FTX and Alameda illustrated how SBF and his inner circle had used their positions of control to rewrite the rules in their favor. Prosecutors revealed that FTX's code had been secretly altered to grant Alameda unlimited access to customer funds, including a backdoor function that allowed it to withdraw assets beyond its available balance. This unprecedented level of financial manipulation was concealed from both customers and investors, allowing Alameda to operate as a hedge fund subsidized by unwitting depositors. As part of the investigation, former Alameda CEO Caroline Ellison and FTX co-founder Gary Wang were formally charged by the CFTC on December 21, 2022, further tightening the noose around SBF's criminal enterprise. The amended complaint detailed Ellison's role in directing billions in customer funds to prop up Alameda's failed bets, as well as Wang's responsibility for engineering the backdoor system that facilitated the fraud. Both Ellison and Wang pleaded guilty to the charges and agreed to fully cooperate with prosecutors, acknowledging their participation in one of the largest financial frauds in history. Their testimonies would prove critical in building the case against SBF, revealing the depth of FTX's financial deception and the deliberate actions taken to mislead customers, investors, and regulators. The CFTC's pursuit of justice extended beyond FTX's original leadership, as FTX's Director of Engineering, Nishad Singh, was also charged on February 28, 2023, for aiding and abetting fraud. Singh had been responsible for maintaining and modifying the software architecture that allowed Alameda to withdraw customer funds at will. Prosecutors also alleged that Singh had personally misappropriated millions of dollars through loans and withdrawals from FTX, even after knowing the source of these funds was customer deposits. Singh, like Ellison and Wang before him, did not contest his liability and agreed to cooperate with investigators, further solidifying the prosecution's case against SBF. The legal reckoning culminated on August 8, 2024, when the U.S. District Court for the Southern District of New York imposed a staggering $12.7 billion penalty against FTX and Alameda Research. The judgment, which remains the largest monetary relief ever secured by the CFTC, included $8.7 billion in restitution to defrauded customers and $4 billion in disgorgement to recover ill-gotten profits. The ruling permanently barred FTX and Alameda from trading or operating in financial markets, a symbolic but largely procedural measure given that both firms were already defunct. The decision cemented FTX's collapse as the most consequential financial fraud in cryptocurrency history, sending shockwaves throughout the industry. In response to the case's resolution, CFTC Chairman Behnam noted that FTX had used the same age-old tactics of deception that had led to past financial crises, only repackaged under the guise of crypto innovation. He warned that without a robust regulatory framework, crypto markets would remain vulnerable to similar frauds, as companies operating in legal gray areas would continue to exploit the lack of oversight. While the record-breaking judgment offered some measure of justice, regulators cautioned that many victims may never fully recover their losses, as the FTX estate's assets remained a fraction of the total funds lost. Chapter 8. 2025 Bull Market. Donald Trump. In 2025, Donald Trump, the self-proclaimed first crypto president of the United States, reclaims the White House. In August 2024, I publicly predicted that crypto regulation would reset if Trump won the election. In my Law 360 article, Crypto Regs Could See a Reset. Under the next president, I explained that Trump began to collect large political donations from the crypto industry and simultaneously made promises on the campaign trail to fire Gary Gensler, the hawkish SEC chair in the Biden administration, universally despised by the crypto industry, and to establish a national Bitcoin reserve. In my December 2024 article, Crypto Regulatory Reset Under Trump Administration, I explained the 5 strong signals showing that there will be a regulatory reset under the Trump administration. Gensler's gone. The chair of the Securities and Exchange Commission, SEC. Under the Biden administration, Gary Gensler has already handed in his resignation, effective January 20th, 2025. Gensler's tenure, beginning in 2021, was marked by over 100 enforcement actions against crypto companies and a firm stance that most digital tokens are properly classified as securities requiring registration. 2. SEC Chair Paul Atkins. On December 3, 2024, Trump selected pro-crypto Paul Atkins to again chair the SEC. Atkins was the SEC chair under President George W. Bush from 2002 to 2008. Since leaving the SEC, Atkins has been outwardly pro-crypto. He has co-chaired the Token Alliance at the Digital Chamber of Commerce since 2017 and has advised digital finance companies, including cryptocurrency companies, on regulatory compliance at his firm, Patamac Global Partners, since leaving the SEC. Following Atkins's nomination, reports have surfaced that he is reluctant to clean up Gensler's mess. This selection by Trump strongly signals that the new agency plans to sharply depart from Gensler's pro-enforcement regulatory framework. Trump's pro-crypto leadership team. Trump is assembling a pro-crypto leadership team, including running mate J.D. Vance, Vice President, Robert Kennedy, Secretary of Health and Human Services, Howard Lutnick, Commerce Secretary, Scott Bessent, Treasury Secretary, and Elon Musk and Vivek Ramaswamy, Department of Government Efficiency, who are both vocal crypto supporters and will co-lead this first-of-its-kind project named after the meme coin, Dogecoin. 4. Crypto Policy Role. Reportedly, Trump was considering creating the first-ever White House crypto policy role to coordinate agency efforts and report directly to him. Trump named David Sacks as the White House AI and crypto czar. David Sacks famously hosts the All In podcast, which is currently my favorite podcast. The crypto role, or council, would be led by industry experts who would advise Trump on policy direction. 5. Market optimism. Because of all of this news, Bitcoin and cryptocurrencies have seen explosive growth. Cryptocurrencies now hold over a $3 trillion market cap. Bitcoin ETFs have surpassed $100 billion in assets under management, and each Bitcoin is now valued at nearly $100,000. Institutional investors, including most notably BlackRock, which alone has seen $30 billion in inflows to its iShares Bitcoin Trust, are now moving quickly to invest in crypto. 2025 Crypto Policy Predictions. 1. National Bitcoin Reserve. The policy with the most apparent momentum is for a domestic strategic reserve of Bitcoin, which was mentioned by Trump in a campaign speech at the Bitcoin convention. Senator Cynthia Lummis has proposed for the United States to hold 1 million Bitcoin, about 5% of Bitcoin's 21 million token supply, as a hedge against economic volatility. The plan includes converting U.S. gold certificates to Bitcoin and investing up to $100 billion in digital assets. Following Trump's win, Pennsylvania lawmakers introduced legislation to establish a state reserve which would invest up to 10% of state funds in Bitcoin. 2. Regulatory framework. Establishing a clear regulatory framework that allows crypto companies to grow domestically will be vital to ensuring that the U.S. does not fall behind other countries, according to pro-crypto advocates like Trump. The SEC's current Framework for Investment Contract Analysis of Digital Assets is over 5 years old and will likely be updated by Gensler's successor. It is possible in Trump's first 100 days that we see bipartisan legislation, like the Financial Innovation and Technology for the 21st Century Act, FI-21, which would give the CFTC primary authority to regulate the industry and take some or all authority away from the SEC. 3. Stablecoin legislation. Congress also may move forward on stablecoin legislation, which may be accomplished with bipartisan support. Stablecoins, which are static and do not fluctuate price, have grown to a near $190 billion market capitalization this year, yet face uncertainty in the U.S. regarding whether they should be classified as securities or commodities. Further, there may be the potential for bipartisan legislation about the token reserves required for stablecoin issuers to hold, and it is possible that there could be restrictions on algorithmic stablecoins, which are not backed one-to-one with token reserves. As stablecoins continue to grow in importance in our financial markets, the U.S. would be smart to set clear guidelines regarding reserve requirements to ensure that stablecoin issuers have ample reserves to maintain the market price for the stable asset. 4. No action. Guidance. One effective way that Atkins could dismantle anti-crypto regulations and precedent established during Gensler's administration is to issue no action guidance. For example, no action guidance could be issued as part of the dismissal of registration-only enforcement actions against cryptocurrency companies for offering tokens in the United States without registering with the SEC. Or it could be used to dismiss actions based on violation of the Staff Accounting Bulletin Number 121, SAB 121, which has been widely criticized by the industry for causing the debanking of crypto companies. The SEC would then likely dismiss or settle the SEC's active cases against crypto companies involving non-fraudulent behavior and may issue guidance explaining that many cryptocurrencies do not meet the agency's definition of securities. If Atkins issues this type of broad, no-action guidance, crypto advocates will celebrate this move for fostering the domestic development of cryptocurrencies without fear of regulatory retribution. Conclusion. Ultimately, the Trump administration is set to deliver a dramatic regulatory shift favoring the crypto industry in 2025. This regulatory reset will significantly reduce the SEC's scrutiny of the crypto industry, establish a clearer, more favorable regulatory environment for crypto companies to thrive domestically, and redefine the United States' role in the global digital asset economy. Chapter 9. Solana Meme Coins and Wiener Doge. In 2025, Solana meme coins have controlled the narrative and have expanded into a multi-billion-dollar industry. The ease of token creation on platforms like Raydium and Pump.Fun has democratized the process of token creation and has led to an unprecedented surge in meme coins. Public figures like Donald Trump and financial platforms like Robinhood have capitalized on this growth to secure billions. Wiener Doge on Solana. After 5 years of experience litigating high-stakes financial cases in New York City, I launched my first cryptocurrency at the beginning of 2025. I named my cryptocurrency Wiener Doge after my 1-year-old miniature dachshund. Wiener Doge was not like many other Solana-based meme coins. Wiener Doge was designed to be a scarce asset to store investors' Solana long-term. The token owners invested in my cryptocurrency primarily because they believed both that, 1, Solana would increase in value during the Trump presidency, and 2, I would not liquidate my majority share of the tokens for the entire lifetime of my one-year-old puppy. Wiener Doge experienced explosive growth from January 7th to January 20th. On January 7th, each of the 1 million tokens were worth 1 cent, and on January 13, each of the tokens were worth over $3. Given this explosive growth, some early investors took profits when Wiener Doge reached a $3 million market cap. But not me. I never sold one token and always believed in the long-term growth of the project, so much so that I invested almost $100,000 into this project, convinced my friends and family to buy and hold tokens as a long-term investment, and started the process of engaging a law firm to negotiate the listing of Wiener Doge on centralized exchanges. At its height, my Phantom wallet held $1,518,562.11. See Exhibit A. This explosive growth was driven by Wiener Doge's 1. Solana-based liquidity pool, coupled with laws of scarcity, 2. Viral social media community and marketing engine, and 3. Strong credibility from a crypto lawyer who aims to rid the crypto industry of fraud. First, my token was built using a Raydium liquidity pool, which allows individuals to purchase Wiener Doge in exchange for Solana. The value of Wiener Doge grew as the number of tokens for sale in the liquidity pool shrank. So when 98% of the tokens, 980,000, were owned on January 13th, the market cap of all Wiener Doge tokens reached $3 million. And when 96% of the tokens were owned on January 20th, the value of all tokens was worth more than $1 million. Second, the Wiener Doge Pack community went viral on social media and grew to over 5,000 members, and we set out to reach 1 million members by the end of 2025. Quickly, Wiener Doge developed a cult-like following on Facebook, X, Telegram, Instagram, and YouTube. The community all believed in holding Wiener Doge as a long-term store of value. We advocated against trading cryptocurrencies because of the risks associated. For the first live event hosted on my personal Facebook and later uploaded to YouTube, thousands of people tuned in and listened to my vision to list this project on centralized exchanges at a rate of $100 per token. Third, Wiener Doge went mainstream and grew to new crypto investors because I staked my entire reputation on this project, which I had built over the last 5 years as a litigator in New York City, working on 9- and 10-figure litigations concerning financial fraud. Many, if not all, of the holders invested into the project solely because I was behind it and because they trusted me. Unlike other tokens, this project was designed to be immune from rug pulls because my family, my friends, and I owned a controlling share of the tokens, and we intended to hold these tokens long-term. Our goal was to sell 33% of the token supply to centralized exchanges for $33,333,333, which values the total supply of all Wiener Doge tokens at $100 million. But after my Phantom wallets were hacked, and after all my Wiener Doge tokens were drained from my 3 Phantom wallets by a criminal, the tokens, once worth $3, are now worth less than a penny. Criminal hacking. Before launching Wiener Doge, I only had invested in cryptocurrencies on centralized exchanges, like Coinbase. I chose to use Phantom as my first decentralized wallet because of the public statements Phantom makes on social media, promising security, safety, and support to its users. Phantom also promotes its web-based plugin broadly on social media and encourages crypto novices to start their crypto investing journey on Phantom by investing into meme coins. On January 20th, 2025, a criminal hacker downloaded InfoStealer malware onto my MacBook Pro, hacked into my Phantom application, and stole my private passkey and Phantom login credentials. The criminal then uploaded my private passkey to their own Phantom application on their device. After hacking into my Phantom account, the criminal utilized their own Phantom application to sell 489,240.5 Wiener Doge tokens in 4 transactions, which took place in under 5 minutes, causing the market cap to plummet and causing my community to crumble. The criminal then sent the Solana that was received from these unauthorized transactions to a burner Solana wallet, before sending the funds to a wallet that stored the criminal's proceeds. Immediately thereafter, I filed a police report with the NYPD, who arrived at my apartment to document the crime that night and later referred the matter to the FBI. The criminal hacker eventually laundered his money through Stake.com, which was unwilling to work with me or law enforcement authorities to seize the hacker's funds. I am now working around the clock to hold the criminal hacker, Phantom, and money laundering website accountable. And the rest of this story will play out in 2025. So, if you are interested in working with me on this mission, then get in touch via my affiliates.